Good morning, Taylor Gang. Good morning. We like 30 minutes early. I was looking at the clock on Law and Crime and it was like starting at 9 instead of 9:30 Eastern time. So I was like, well, let me go live just in case anything happens and we end up going live or they end up starting early. So that's why I just went ahead and kicked it off instead of waiting. But good morning, Kim, Tarika, Mixed Chick, and Karen. Hey y'all. Hey y'all. So today we are revisiting or rewatch. We're not going to rewatch anything. We're actually watching the motions hearing part 2 for Melly. So if you missed on yesterday, you missed on yesterday. The defense filed a motion asking for basically clarity around an ongoing investigation for Miss Raven Liberty. If you don't know who Raven Liberty is, she is the female attorney for YNW Melly. She's been here, I mean, a long time. She's probably the senior attorney on his case. She is also the attorney who has been unable to see him. And she's also named in the habeas corpus response from Broward County. So when we look at that response, within it, they actually allege that Miss Raven Liberty um, possibly planned to help Melly break out of jail by giving him a handcuff key. There were allegations that she attempted to bring him pictures, new pictures of girlfriends. And then there's also an allegation in there around her possibly allowing him to get phone calls from non-attorneys. And I had to have a conversation with somebody yesterday to kind of break that down to me, because honestly, when I first read it, it read to me as if people were calling in pretending to be her when in actuality they weren't. And so what it sounds like is that there is some type of Zoom or video call that attorneys have, and it's basically being alleged that she has allowed people who are not her, non-attorneys, to use like her login or something in order to allow them to talk to Melly. So we don't know how valid these allegations are, but it had to be something. Uh, they had to produce some type of evidence in order to get a judge to sign off on a warrant based on what they put inside of their affidavit. And so on yesterday, we saw that Raven Liberty was, one, not in court because she was stuck grounded somewhere due to the snowstorm that hit the country, and that, two, the defense attorneys did not want to argue any of the motions for a couple of reasons. One, Miss Liberty was not there, and the majority of the motions were hers. And two, if there is an open investigation on Miss Liberty, they kind of need to know what's kind of going on with it to determine the next steps. And when we talk about the investigation, what we know is that sometime in December of 2023, the Broward County, Broward County's investigators subpoenaed the Apple iCloud for Miss Liberty. They did not tell the defense this was going on. I mean, this is something that they did pre-trial, while she's actively representing Melly. And Apple ended up letting Miss Liberty know about or around December the 18th of 2024. So about a year later, they let her know that um, her iCloud account had been subpoenaed. I'll say 9 to 10 days later is when we saw this motion come into play. There were concerns around what exactly was retrieved, if they have any type of trial strategy information, and if they have anything that is attorney-client privileged for their client and for others. And so yesterday we saw the defense attorney stand in front of the judge and pretty much say, like, we need to know what's going on. We need to know if there's an active investigation. Is it over? Is she still going to be under investigation later? The state confirmed that she is under an active investigation, and so now the defense wants the affidavit. The state pretty much said no at first, and the judge asked them, well, look, does this investigation have anything to do with Melly? And they said yes, it has to do with Melly and some type of tampering. And what we know about the tampering case is that Melly's tampering allegations are something that they're trying to bring into this second trial as consciousness of guilt, which means that basically you wouldn't be doing this if you weren't guilty, if you didn't have anything to hide. And so the judge is like, well, here's the thing. He's going to trial in September. I don't know if you know, but I'm pretty busy and I'm booked out until January 2026. This has to do with them. This is his discovery. You have to turn it over. And so the state wanted to have a week to do this, but the judge told them again, you're going to have to come in here tomorrow with that affidavit, or you're going to have somebody in here with some authority and some damn good reason why you cannot turn that over. So that's what we're doing here today. That's what we're doing here today. So I hope that recap helps you if you kind of missed yesterday. If you got any questions about where we're going to pick up. Again, we are about 25 minutes early ahead of the stream start time. I think if you look at the screen, it actually said 8:00 a.m. because I'm in Central Time Zone. So I didn't want to miss it if I had anything wrong, which is why I started early. But again, if you got any questions, y'all know the Telegram chat. They keep it cracking in here. So come on over. If I've missed saying good morning to you, good morning, good morning, good morning. Welcome, welcome, welcome. Um, yep, yep, yep. Kim just said, I bet Bradley is behind this. I absolutely think that she is behind this. This would have been done while she was still on the case. And if you look at what my thing is, they had this, they could have, we don't know if or when Apple turned over her records, right? And if and when they did, we don't know the timing of that, but we do know that habeas corpus response came possibly after the fact. So some of the allegations, I'm curious to see what's in the affidavit if we ever get to see it, to know what evidence or what type of circumstances did they present to the judge in order to get them to sign off on this search warrant. So you're so welcome, Texas T. Thank you for being here. Hello, good morning, Felicia. Good morning, Zoe, mommy. Hey, D Wood. All right, so I am going to try and get me some breakfast, y'all, because it's another snow day. They ain't let these kids go back to school today, y'all. So we're gonna try to do something a little different. Karen Reed also has emotions hearing today. So if Taylor Gang wants to watch that, we'll switch over to that after this. But I'm gonna grab me some breakfast real quick. So I'm here. The chat is live. So if you want to talk, my people in the chat will talk to you. Make sure that you like and subscribe to my channel. If you want a membership, they are available. And again, I'll be back. All right, Taylor Gang. Good morning. We got about 5 minutes before our hearing is getting ready to start. Malik, I was just getting ready to talk about this. They just filed a motion for a rehearing or reconsideration less than 10 minutes ago. Because they don't want to give up that affidavit, y'all. What I forgot to mention in the recap too is something that I found interesting yesterday was that the defense attorney said that he needed to call the bar because he needed to know if they are still under any obligations to remain on the case. That right there tells me that somebody want to leave and they want to make sure that if they want to leave that they can leave. Very, very interesting. Very, very interesting. So I'm pulling up the motion right now for the affidavit so that we can go through it. Do y'all want me to share it or y'all just want me to read it? Because I can read it or I can share it, whatever y'all want to do. We got about 4 minutes, so I'll keep the audio on and then I'll share the motion and we'll run through it real quick. All right. So again, this is the state's motion for a rehearing or consideration of the defendant's tenant's motion to compel disclosure of Apple search warrant related to an attorney, Raven Liberty. So on January 6th, its honorable court entered an oral order requiring the state to provide the defense with a copy of a warrant issued in December 2024 to Apple regarding attorney Raven Liberty. In reviewing this honorable court's oral order, it is the state's position that the court has overlooked or misapprehended several matters of fact or law as laid out. Further, the state requests the court reconsider its order. A trial court has the inherent power to reconsider a ruling upon appropriate motion by either counsel while that court has jurisdiction of the case. And there was some case law cited there. There's even more case law cited here that states that it referred to the Rutledge state case that requires the state to disclose that there is in fact an ongoing investigation relating to the defendant's attorney, Raven Liberty, to compel the state to go beyond what is required by law is a departure from the essential requirements of the law. So basically, they had to tell him that she's under investigation. Upon the state's assertion that there is an open and pending investigation stemming from the defendant's present case, but entirely separate in its own right, it is then up to Miss Liberty to have that conversation with her client as well as assert herself whether she can ethically continue her representation. The state asserts that the state has complied with all of the required and the defense is now aware of an ongoing criminal investigation regarding Ms. Liberty. But here's my thing though. Y'all should have told her that she was under investigation or them that she was under investigation when she started being under investigation. Y'all didn't say anything. Y'all tried to keep it under wrap and it made y'all look real, real shady. So I'm not even mad at the defense attorney for talking about filing a motion for prosecutorial misconduct because baby, that's what it really happened. Y'all didn't say nothing until they brought it up to y'all. But anything further is a departure from the essential requirements of the law. To require the state to provide a copy of a warrant at issue to defense would require the state to disclose information regarding an ongoing criminal investigation that encompasses more parties than just Miss Liberty. The investigation is separate and apart from the defendant's current cases and involves numerous parties. But here's the thing, y'all have already asserted that y'all plan on bringing in the tampering situation into this case. And if y'all are also saying that she aided in his, alleged tampering, that's relevant. Requiring the state to divulge details on the ongoing investigation with the broad sheriff's office would set a dangerous precedent for the current state of criminal investigations. Unable to do their job without threat of being forced to divulge their investigations prematurely would surely have the effect of limiting the work of the police Broward counties. Well, y'all should have did this after the fact. Yeah, why would y'all do this while y'all in the middle of a trial? That's just crazy. How can you do it without recusing yourself either? I got a lot of questions, y'all. I'm sorry that I keep just stopping, but I got questions. In the instance, case requiring the state to produce a copy of the warrant would greatly impede the current investigation and allow suspect, you brought that on yourself, to avoid apprehension and or allow for the destruction of evidence, and it is exactly why Florida law expressly prohibits in bold the disclosure of such information regarding active investigations. There is an litany of cases dealing with the courts requiring the state to produce information related to an ongoing investigation. The court held under the Florida law, active criminal investigation information is exempt from public disclosure until the investigation is concluded. This is crazy. Notably, it goes far as to the state that criminal intelligence and criminal investigation information shall be considered active while such information is directly related to pending prosecution or appeals. An executed search warrant and accompanying material is exempt from discovery and public records per the law. They got some case law cited there. Investigations into attorneys, especially those involving potential criminal conduct, are often kept confidential to protect the integrity of the investigation and avoid whatever was I confidential to and the integrity of the investigation to avoid prejudicial. I can't even get the word out. I'm just so like I'm just shocked. Ongoing proceedings. Their disclosure is prohibited in the system of information for information related to the crimes and criminal activities of the disclosure of the contents of such information may seriously impair enforcement and jeopardize the Why would y'all do the investigation in the middle of a trial? Like y'all know that she is in trial and y'all basically my thought right now, y'all, is that they basically wanted to ambush them. They basically wanted to bring this up in the middle of the trial and be like, yeah, now she got to recuse herself. Like, I just don't see good faith in this at all. Like, I'm sorry, I can't get through it. I can't. The state would further argue that the specific details of any potential conflict that may arise between Ms. Liberty and the defendant is irrelevant. The defendant is aware of his attorney, Ms. Liberty, is under investigation because the state, going beyond its duty outlining Rutledge, disclosed the investigation is related in some fashion to the defendant's case. The information in and of itself is sufficient notice for conflict. This satisfies the defendant's due process rights, regardless of the details of the investigation. Ms. Liberty has an ethical obligation to withdraw, even if the defendant were to waive the conflict. Okay. If the attorney suffers from an actual conflict so severed that it impedes effective assistance, counsel should be disqualified, notwithstanding defendant's desire to waive. If the activity for which the attorney is investigating is substantially related to the charges against the defendant, disqualification is necessary, notwithstanding the defendant's waiver. Much like the compelled disclosure of the confidential informant, unwarranted disclosure of sensitive material related to ongoing investigation unto yet uncharged targets cannot be undone or remedied. If the state is forced to comply with them and providentially issued discovery order, there is no adequate relief once the disclosures are made. The damage would have been done. Disclosures would jeopardize the ongoing criminal investigation where arrests have not yet been made. Compliance with the trial's court order to provide the discovery would force the state to either jeopardize the ongoing investigations by continuing its lawful prosecution of the defendant or drop the charges against the defendant to preserve the integrity of other investigations. Discovery may reasonably cause material injury of the irreparable, however you like to say it, irreparable nature includes material protection by privilege, work product, or that involves confidential informant that may cause such injury if disclosed. And then they got more case law cited there. What in the absolute hell? What in the absolute hell? Like I said, my thing here is y'all shouldn't have started this investigation. What it says your browser has lost connection to your screen share audio. Can y'all still hear me? Let me know if y'all can hear me. Okay, yeah, good. I don't know what that was, but that's why they should not have done this in the middle of the investigation, because at the end of the day, like, how do you do this without recusing yourself? Because at this point, whatever was in her iCloud, whatever is there, like the defense attorney said, how do they know that whoever investigating it has not relayed any of that information to the prosecuting team? Like, it's too much. It's too much. It should have never been done. So, I mean, Child, he said turn it over. He told them yesterday to turn it over. He told her don't come in here saying that you can't. They need to start this stream because I'm on the edge of my seat now. They should have never did it. Okay, I gotta catch up on the comments because I know my boy Malik in here. Okay, we read it. The judge should say no. Is what Kim is saying. The judge told them to be ready. And how do they suggest Melly to make a decision? They never even told her. Apple did. Exactly, Princess. Like, they never said anything. Apple told them and they brought it to the court. So when you talk about their Rutledge case, you were still in the fault because you never disclosed that she was under investigation. That would have given everybody ample time to say whatever it is that they wanted to say. But I feel like, again, all of this is all of it stall tactics. Stall tactics. He does deserve a fair trial. Everybody deserves a fair trial. Exactly. And here's the thing too, Waku, like we don't know when the investigation started. Y'all could have been investigating her prior to before you even disclosed it or asking Apple for the iCloud. Like for real. Let's keep it a buck. You didn't fulfill your duties per the Rutledge case. Malik think they gonna, hey, sweet lady sugar. They say Judge Stein better stand on business today like he did yesterday. Okay? Because he even told them that he don't have time. He said he don't got time for that. He said he don't got time. Where y'all gonna get another 2 days to argue anything? I'm booked. And told her this is a death penalty case. This ain't something you just finna you think you just finna play with. It's crazy, Waku. It's crazy how he get a completely new defense team that's gonna be up to speed on all of the discovery, the appellate issues. Like, come on now. Come on now. It's not possible. Malik wants to know why so many different tactics if the man is so guilty. Why do you have to do all of this if he's guilty? Right, right. I will say that while I was talking to attorney Arian yesterday, she actually practices down in Florida. We were live on TikTok. She did say that Apple is very, very stingy with their information and they try and make it very limited on what they choose to disclose when even asked by law enforcement. But who's to say that they even know knew where to look at? You know, they could have very well requested something that they didn't need. Mm. Malik, that's a theory. That's a good theory. Malik said, what if they bluffing? Good morning, Peach. Exactly. Wait, is it a rumor that they are wiretaps on Miss Liberty's phone? KT, I haven't heard that. I haven't heard that. What I heard was that she was allowing people to use her login to video call Melly. And not telling what they saw on her phone. Yes, y'all. Karen Reed is also having a motions hearing today. So Taylor Gang, if that's something that y'all want to watch, I will definitely stream it for y'all if y'all want to do that. After we get out of here. All right, friends. So, or cousins, I will switch over to Karen Reed once we're done here. Which would be cool too because I think she started at 9, so we should be able to get right into it. But I think Jason, it was an allegation though. I don't believe that they actually did it. Why cool? I think that Yak did have a status hearing today. I don't know how relevant it is to be honest, because if he has the revocation hearing in February is the one that's really going to make the determination for what he would have seen Whitaker for today, if that makes sense. So I can do a little research on the back on the outside and see what's going on. What's going on, Jason? Y'all, Cuff Boys is amazing. I love Cuff Boys or Cuff Boy. It's Wednesday. Ooh, y'all. There is also another motion that I just saw on Twitter that was filed in response. It says, shout out to Bryson Boom Paul, who posted YNW Melly's attorneys filed a response to the habeas corpus back on January the 2nd, y'all. We're going to go through that. We're going to go through there because I can just tell you from one of the headers, it says Broward County's Sheriff Office has admitted to actions clearly violating the petitioner's Demons constitutional rights. Okay. Um, it also says that their response contains false and incomplete assertions that will be disputed at an evidentiary hearing. So I need to go find this because we're gonna go through that too. Yes, we're going through that too. We got 9 to 12 inches around the city, so it just kinda depends on where you live. I live more out in the suburbs, so I'm literally, like, in the middle, 10 inches. If you go 1 mile north, they got 12, and you go 1 mile south, I'm sorry, 1 mile south, they got 12, 1 mile north, they got, 9. So 9 to 10, 9 to 12, sorry. Do you think they're stalling because the warrant affidavit is some BS or something else? I don't know. I'm not surprised if that is a reason. Um, I just think that they on some BS. Like the case is there's a severe gap of evidence. And as Arian mentioned on yesterday, I don't know, y'all. Like it's so many things playing through my head right now. Like I don't know. Like I can't even figure out which angle they coming from because they coming from so many of them. They coming from so many of them. All right, it's 117 people watching the stream. We got about 36 of those watching from X and 81 watching from YouTube. So if you are on YouTube, I need you to like my video right now. I need you to come up and come out the comments, hit the X, like the video, so that your girl can stay in the algorithm so that people can continue to engage with us. Make sure you like it, like it, like it. If you haven't done so already, make sure you also subscribe to my channel. Over here on the Taylor Umber channel, we do a lot of trial watching. We watch trials every day. We got something to watch every day. Okay. The Taylor gang members are extremely respectful. Our chat is always lit. Everybody always has a good time. So if you are new here, welcome. But make sure that you subscribe, okay? What's going on, girl? And in walks Miss Liberty, y'all. In walks Miss Liberty. D Wood, tell your job they got the weight. They got the weight. Right on, Juice from Milwaukee. We appreciate you over here. Okay. No shame, baby. We went for her. Raven is in the house. Okay. She walked in there. I could have sworn I heard mystical. I heard somebody was looking for me. Here I go. Here I go. I heard somebody was looking for me. That's how she walked in there. Good morning, y'all. It looks like we getting ready to start. Miss Raven is here. Melly has come in. Let's see what's going on. Just BT, his mother is beautiful. She is a gorgeous woman. And here's the thing, she's the only one that literally engages with him. They are always talking, laughing, smiling. Look how close she just was to him, talking to him. Like, they are the only one that kind of has that type of relationship, cheek to cheek. Like, come on now. Come on now. I think that I don't know. I don't know. I want to see that affidavit, y'all. I want to see that affidavit. Because they want to break him down. They want to break him down. Like, ooh, McShit, girl. She's like, you see what his hand, what her hand with? Ooh. They want to break him down. You know what I'm saying? Get him uncomfortable. Also, y'all know that him and Borland are going to be tried together this next time around. We got to talk about how we feel that's going to impact this case, because I thought that they were severed. They were going to be tried separately, but yesterday it was confirmed. I confirmed it. They got tried date, same day, same time, same court. So they're being tried together. Let me know how y'all think that's going to impact the case. Throw y'all comments down there in the chat. All right, y'all. We waiting on audio. We don't have audio yet. We can't hear anything. So we just waiting.
Believe in the U.S. Constitution. This is a. I'm not involved in this. The underlying facts that are going to make a determination is whether there's a conflict and what Mr. Devins wants to do. This is completely 100% a decision between himself and his lawyers. I don't have anything to do.
We're not disputing that.
So I don't know what else I can do at this point. You've asked me to press pause on all these motions. I'll press pause. I'm not going to move this trial date. This trial is going forward in September. So if these motions are heard next month, or they're heard in March, or they're heard in August, or they're heard contemporaneously during his trial, which again would not be the most ideal way to do things. If that's what ends up happening, that's what ends up happening. But the one thing I can tell you is not going to happen is someone that has been in custody for 2,160 days, his trial is not going to be delayed under any circumstance. So that being said, what else would you like me to do this morning? Execution.
Apple that the warrant is being.
All right. Mike, take your time. So when you're ready. Good? Okay, let me go back on the record. This is State versus Jamel Demons, 19-1872 CF10A. I've got Ms. Bucklow, Ms. Collins, Mr. Griffiths present for the state. I've got Ms. Liberty, Mr. Abelstein, Mr. Aronson, Mr. Benjamin, present, and Mr. Demons, who likewise is present. We're not waiting for Mr. Catanza.
We are not waiting for his presence.
Okay. Okay, so this is just a continuation of yesterday. I did get, and I read, as well as the authority cited therein. The state's motion for rehearing and reconsideration of the defendant's or tenant's motion to compel disclosure of the Apple search warrant related to Attorney Raven Liberty. I don't know that I actually conducted a formal hearing. I just asked the state to turn over a copy of the search warrant and affidavit. Ms. Combs, let me ask you this. I read your authority. Would you agree that they're entitled to a copy of just the search warrant, not the affidavit, just the search warrant?
At some point, but not at this point necessarily.
Well, can you explain that to me? Because if I sign a search warrant for someone's home, and BSO goes to their home and executes the search warrant, and they're there, they give them a copy of the search warrant.
Correct. But
Upon
in
its
this case, it's
execution.
Apple that the warrant is being executed upon, not the party themselves.
And you think your authority says that she's not even entitled to a copy of the search warrant?
Yeah, that's correct, Judge. Yes.
That's your position?
Yes, Judge.
Okay. Okay, well, over the state's objection, I'm ordering you to turn over a copy of the search warrant. I'll put that in a written form today, so you can litigate that as you see fit, but I certainly think she's entitled to a copy of the search warrant. Probably that's it at this point. So, defense, I'm happy to hear anything you want to tell me, but based on our discussion yesterday, I think where we're at is, I need to give you a date very soon in the future. It's a date in February, which is what we're looking at. And at that point in time, you're gonna have to come back in here and tell me, and I'm gonna have to have a discussion with Mr. Demings. I'm gonna start that discussion this morning, so we understand he's the captain of the ship. This is his decision, but he's gonna have to tell me if he wants Ms. Liberty to continue to be his lawyer or not. He's gonna have to tell me if he wants all of you to continue to be his lawyers or not, or he's gonna have to tell me that he's gonna seek other counsel, but I think that needs to happen sooner rather than later.
We concur with that issue. I'm confused, and I apologize to the court. Is the court entertaining this motion for reconsideration and not?
There was no motion or room. I think she's entitled to, listen, Mr. Demings is entitled to heightened due process. The state is seeking the death penalty. It is very clear that one of his lawyers is under investigation right now.
Okay.
He is entitled to have as much information as I have the ability to give him before he has to make a decision. Is there a conflict of interest? Does he want to waive that conflict of interest and continue with that lawyer as part of his representation? Or does he not? Does he want the lawyer to withdraw? And again, the Florida Supreme Court has been very clear on this. He's the captain of the ship. He
Absolutely.
makes this decision. So if there was, again, I'll repeat what I said, I think Mr. Aronson yesterday, if you all had some other authority that says I have some additional power to assist in the fact finding here, I would hear what the state has to say about it, but I would probably be inclined to do that. But my inherent authority or citing the U.S. Constitution, although I very strongly believe in the U.S. Constitution, this is I'm not involved in this. The underlying facts that are going to make a determination is whether there's a conflict and what Mr. Demings wants to do. This is completely 100% a decision between himself and his lawyers. I don't have anything to do
We're
with it.
not disputing that.
So I don't know what else I can do at this point. You've asked me to press pause on all these motions. I'll press pause. I'm not going to move this trial date. This trial is going forward in September. So if these motions are heard next month, or they're heard in March, or they're heard in August, or they're heard contemporaneously during his trial, which again would not be the most ideal way to do things. If that's what ends up happening, that's what ends up happening. But the one thing I can tell you is not going to happen is someone that has been in custody for 2,160 days, his trial is not going to be delayed under any circumstance. So that being said, what else would you like me to do this morning?
Well, a couple things. Since the state filed a motion for rehearing, there are misstatements in their motion that need to be corrected. Since we received this early this morning and saw it for the first time, we did not file any written plea response. And if I may, just go through the corrections that we saw. It's on number one, it says the search warrant was issued in December of 2024. It was 23, not 24, a year earlier.
We agree with that, Judge. That way,
In paragraph number 2, they said that the state disclosed an ongoing investigation to Ms. Liberty. That is absolutely untrue. We learned of it through Apple. They confirmed it yesterday for the first time, over a year after the search warrant was executed. Paragraph number 5 indicates that this investigation is separate and apart from the defendant's current case. It conflicts with paragraph 11 that implies that this investigation is related to the tampering case of Mr. Demings. Is it unrelated or is it related? I think the court needs to know that, because if it's related, I believe, and we will file a written response under discovery, he's entitled to that information, anything that leads to relevant and important information. And I'm not asking the court to rule on it at this point, but I want the court to know that if it's related to his present charges under 3.220, we're entitled to that information. They make a statement that regardless of what Mr. Demons wants and is willing to waive the conflict, they believe that Ms. Raven must get off the case, regardless of that. That's their assertion. They have to prove it. And I want to put the court, the state on notice that they must prove. They can't merely allege that the conflict is so extent that even if this young man wants to waive it, they're going to come in here and say she must get off the case. That's what they say in this plea in paragraph number 11. That's a question for the court to determine, and they have to present evidence of that fact. We are still under the same impression that we don't have enough information. Pursuant to your Honor's request, Mr. Aronson and I spoke to Mr. Demons. I call him Melly if the court will allow me.
I'd actually prefer that you use.
Mr. Demons?
Yeah.
Fair enough.
Thank you.
Mr. Demons, we discussed the potential of that. And if the court accepts my representation, or the court can inquire from him, he informed us that he doesn't have enough information to make that decision.
You're talking to me about privileged communication.
Well,
I'm going to talk to Mr. Demons at the conclusion of the hearing this morning, everything that I'm allowed to talk to him about. I want to hear about anything that you all know.
I was just willing to profit the state of that fact. And we would, of course, ask the court to deny their motion for rehearing and rule consistently with what you ruled yesterday, that they not only have to produce the search warrant, but the affidavit.
Well, do you want to respond to any of the case law they cited about ongoing investigations? That would relate to the affidavit.
Well, it relates, if it's related to his present charges under Rule 3.220, they must turn it over. So let him come in here and make a representation that it is either unrelated, totally different, or if it's in fact related, he has a right to see that information. And 3.220 is clear on that. Anything that could lead to relevant information must be disclosed. Judge, there's one other matter that we need to go sidebar on.
Okay, well, hold that, pause on that till we. State, is there anything else that you want to tell me today? The only thing I'm going to do is talk to Mr. Demons about the front end of this colloquy, if you will, and then give you a future date, which I'm looking at is February 18th. That's the day before my next trial starts, after the trial that's starting tomorrow. And on Tuesday, February the 18th, what I'm also going to ask each side to do is, if there's any motion pending that you think I can hear that is not interfered with by the pending matters that are up on appeal to 4th DCA, state if you have anything that you want me to hear on February 18th, just file a notice of hearing and identify the motion you want me to hear. Defense, if there's anything else you want me to hear on February the 18th, just file a notice of hearing and identify what it is you want me to hear. I anticipate the murder trial that I'm commencing tomorrow will be done by then. It may not be, but I'm hoping that it is. And if it is, then I'll give you the whole day on February the 18th to address this issue regarding his representation. And if it turns out we can go forward and hear some of these pending matters, then I'll be happy to do that too.
Judge, I can just ask, I know you said file a notice of hearing, if we can have a deadline like by February 1st, so we don't end up in the same position we did this time where it's filed, pre-business
Well,
before.
Let's see, we're talking about February 18th. So how about the end of business on February the 7th? How about that?
That's fine.
All right, so that goes for both sides. If there's anything you want me to hear on February the 18th, just file a notice of hearing, identify exactly what it is that you want me to hear. And I'm going to see you on February the 18th at 9:30 a.m. Again, we'll call it all pending motions. Maybe we'll be able to work all day, and maybe we'll be able to do nothing. I guess that's really going to be up to you all. State, is there any other requests that you have this morning?
Yes, Judge, as to the search warrant itself that Your Honor is going to compel us to provide, I'd ask that we have until February 1st, just so we have time to pursue the appellate remedies in the meantime, and then I'd also ask that we provide Your Honor in camera first, because it's the state's position that there are, even in the search warrant itself, certain things that make reference to other targets of the investigation, which are confidential privilege and would jeopardize the investigation. So we would ask that Your Honor review that in camera, if any necessary redaction has to be made, and then it can be provided to defense.
We would object to that procedure, and they've had over a year, to produce this document, so it's no surprise. We would ask that to be given to us by the end of tomorrow.
Okay, so listen, over the defense objection, state, this is what I'll do. I'm ordering you to turn over a copy of the search warrant. I need you to get that to me. A week from today, that's January 14th. End of the day, January the 14th, that comes to me,
Yes, Judge.
and then I'll review it, and then I'll distribute it as I see fit. I can't imagine there's anything in there I'm going to redact. I mean, it doesn't matter. The state's free to investigate whoever they want for anything they want. to do this in the midst of a capital case, say, I realize some things are gonna happen that you might not find ideal, but that is of your doing because you've chosen to do this in the middle of a capital case. So, Mr. Demon's heightened due process rights will take precedent over every other matter in this case, obviously. So that's just the way it's gonna have to be. But I'll grant your request over the defense objection, at least as to that. Ms. Wilcox can give you a blank order. You can fill it out this morning. I know it's over the defendant's objection, but show them the order, and I'll be happy to sign it. The search warrant comes to me within 1 week, and then I will review it in camera, and then I will distribute it accordingly as I see fit. Say anything else you want me to do this morning?
The judge.
Defense, besides your matter that you want to talk to me about, sidebar, anything else
Yes,
you want
since
me to
you're
do this
going
morning?
to, in camera, review the search warrant, we would ask that the state submit the affidavit.
Well, the case law seems pretty clear that you're not entitled to that, but if you have some competing authority, I'm happy to look.
Yes, sir.
Your Honor, on another note, I was a little confused yesterday as to whether or not you have lifted the stay as far as discovery, and we can start discovery again on everything, or we're still under that stay order. Just asking for
I asked both sides if you wanted to do that. I thought you both told me that you did want to do that, that you wanted to do the things that you can do.
I want to do everything,
I agree with you.
but,
Time is short, but,
the state is the one that asked for the stay.
well, see, what do you want me to do?
Judge, we need to speak with the Attorney General's office, because we had that stay for a reason with certain things, but we have plenty to do outside of that first, so.
Okay,
we have
well, why don't we do the things that we all agree we can do? So the answer to Mr. Hampton's question is yes, without objection from either side, the stay is lifted to the extent that we can litigate any matter that's not currently before.
Well,
the
no, no,
court.
we are objecting to that,
That was
Judge.
already done by Judge Murphy.
Right, that's already been
Judge
done.
Murphy already lifted the
He
stay.
modified it,
Right, he
so that we
modified
could
it.
do ongoing discovery
okay.
as to things that were not up on appeal.
Again, if one side notices something for February 18th and the other side thinks that that is included in the matters that cannot be handled because it's currently at the Fourth District Court of Appeals, I'm sure you will file a written response and let me know that. And I guess I'll have to make a decision whether I agree with you or whether I don't. Defense, besides the matter that you want to talk to me about, anything else?
Judge, the only thing I would like to have you possibly consider is that you had said you were prepared to ask Mr. Deming some questions right now. I'm a little concerned that with the lack of information that exists in this case, for him to even opine on where to go right now, based on what? The paragraph in their motion that says that he has to make a decision now because we told him there's a conflict.
I'm not gonna ask him any questions. I'm just gonna explain to him the choices that he's made. No different than a defendant deciding to testify or not testify at a trial. I'm not gonna ask him any questions. I'm telling him what's coming. Because at some point, he is gonna have to tell me what he wants to do.
And of course, we're gonna object at this point, and until the time that he's fully informed as to what there is that may be a conflict, he is in no position to answer, to make an opinion as to whether
I'm not asking his opinion. You're objecting to me talking to your client about his rights?
it depends on what you say, Judge, but I am prefacing what you comments are because I was under the impression that you were gonna inquire with him as to whether or not that he finds there's a conflict.
No, I'm not.
Okay, great.
Okay, again, so the record is crystal clear on this. I'm following this procedure pursuant to a case called Figueroa, Figueroa hyphen Sanabria, Sanabria versus State, Florida Supreme Court case from 2023. It's found at 366 Southern 3rd, 1035. And this was a death penalty case as well. I'll quote what the Florida Supreme Court quotes. In all criminal prosecutions, the accused shall enjoy the right to have the assistance of counsel for his defense. All competent defendants have the right to control their own destinies. He's entitled to his constitutional right of assistance of counsel, and there's nothing that makes him relinquish this right. So all I'm going to do this morning is explain to Mr. Demons that at some point this is going to be his choice. I'm sure his lawyers will give him the best advice, but this is going to be his decision. And he may not agree with your advice at some point, just like a defendant may decide to testify or not testify and not follow the lawyer's advice. But I take this decision to be the same way. It's a fundamental decision. This is a client decision. This isn't a lawyer decision. So, Mr. Demons, raise your right hand for me. You don't have to stand. You're okay. You can sit. You swear to tell the truth, whole truth, nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Please state your full name.
Chanel Maurice Jim.
How old are you?
I
How far did you go in school?
graduated, but I got my own GED.
Do you read and understand the English language?
Yes.
Are you presently under the influence of any drugs, medication, or alcohol?
No.
Have you ever been treated for a mental illness?
No.
Are they giving you any medication in the jail right now?
No.
How are you feeling this morning? I understand. I'm a little confused myself. Your head is clear? You're not hearing voices. You hear your lawyers. You're talking to your lawyers. You understand what's going on this morning?
Yeah.
Okay. All right, so Mr. Devins, here's the deal. You're just like any other defendant. You're entitled to have conflict-free lawyer or lawyers representing you. Okay, a lawyer that has your best interest in mind to the exclusion of anything else. You with me so far?
Yes.
Okay. The state has told you that one of your lawyers is currently under investigation. For what? I have no idea. But there's some ongoing criminal investigation. Okay, you with me so far? Okay. So this, what your lawyers correctly pointed out yesterday, raises immediately what we call a conflict of interest. In other words, maybe at some point during this litigation or some point during the trial, my lawyer's not going to do what's the best thing for me. My lawyer's going to do what's the best thing for my lawyer. And your two interests are separate. You understand that?
Yes, sir.
Okay. So once your lawyers have had the opportunity to investigate all this, to get you all the information they can possibly get so they can talk to you about all this, at some point, you're going to have to make a decision about who you want your lawyers to be going forward. You with me on that?
Yes.
Okay. Even if there's a conflict, you can waive the conflict if you want and say, Judge, I understand there's a conflict, but that's okay. I like these lawyers. They're doing a great job for me. They did a great job for me in the past, and I don't want to change, lawyers this late in the game. You understand that?
Yeah.
Or you could likewise say the opposite and say, Judge, I don't feel comfortable with this. I think there's a conflict. I don't think Miss Liberty should be my lawyer anymore. I don't think any of my lawyers should be my lawyer anymore. And I want to go get some new lawyers. And if you want to hire your own lawyers, you can go out there and hire anyone you want. And if you want me to appoint lawyers to represent you, you would have to file an application with the clerk's office. And if they find that you're financially qualified, I could appoint lawyers to represent you. You understand that?
Yeah.
The whole point I'm trying to make with you today, sir, is that this is going to be your decision. Your decision. Your lawyers will give you their best advice, and you have some excellent lawyers, okay, about what they think you should do. But at the end of the day, you can follow their advice, or you don't have to follow their advice. It's your decision. Do you understand that?
Yeah.
Do you have any questions for me about anything that I've said so far?
We have a moment now.
Sure. No questions? All right. So, Mr. Jennings, I'm pressing pause on the conversation at this point. We're going to have the second half of this conversation at some point in the future. I hope it's sooner in the future rather than later, because the last point I want to make sure, and I'm giving you and your family and your lawyers as much notice of this as I can. Your case is set for trial September the 10th, and that's not that far away. Do you understand that? Okay. Your case is going to go to trial on September the 10th. So if you change lawyers, you're going to get a group of lawyers in place that are going to have like 7 months to prepare a capital case. Okay? So the longer it takes to make this decision.
To what the court has just said. What you're telling him is right now that he is basically having to stay with us as his attorney, because if not, then he'll get another set of lawyers that will not be prepared, and they will only have 8 months to do what has taken years to do, and therefore you're pushing him into the corner that he has to stay with us. I don't think that's fair what the court has said.
Over your objection, sir. That's not what I'm saying at all. I want to make sure that you understand the time is of the essence. Do you understand that?
Yes.
Okay. So I'm going to put it back on the docket, February the 18th at 9:30 a.m. This issue with the warrant will be resolved at this point, and whatever's going to be distributed to the parties will have long since been distributed to the parties. You all can file whatever additional motions you think are appropriate. If there's any motion the state wants me to hear, we're going to do that in a notice of hearing. That's by the close of business on Friday, February the 7th. Defense, if there's any motion that you want me to hear, you're going to do that in a written notice of hearing by Friday, February the 7th. If I don't have something noticed in writing by Friday, February the 7th at the close of business, we will not be hearing it on Tuesday, February the 18th. Mr. Deming's case remains set for trial September the 10th at 9 o'clock. State, anything else that I can do for you this morning?
No, Judge.
Defense, with the exception of your, all right, is the state coming up here too?
Yes.
Okay. Mike, this is not on the record. Dan, I think there's a microphone here. That needs to go.
Ooh, okay. So I'm not even gonna hold y'all. I actually want to go back a little bit so that we can hear again the things that the defense called out as incorrect in the state's motion. Why? Because I create content. I need to make sure I got my facts straight. I agree with you all. I don't think that it's fair. I do believe that what the judge just said was a little bit contradictory. You have the right to keep your attorneys. You have the right to change attorneys. But if you change attorneys, whoever you get will have to get up to speed, because I will not change your court date. You will be going to trial on September the 10th. I think that is bizarre. And I agree with his attorney that it pushes him, it backs him into a corner, right? He basically has, an ultimatum. He was presented with an ultimatum. I just, this is my non-attorney brain going, y'all, because y'all know I have not taken a law class. I ain't passed the bar. I'm not licensed to practice in anybody's state. I think that that's crazy. I don't know how that's legal. Yeah. So I'm gonna try to make sure we don't miss anything else. But I will tell you that we will go back and re-listen to when his defense attorney decided to talk through the issues that were wrong in that motion. And he did so rightfully. Because one, he was like we had been talking about beforehand, they won for sure, did not say that she was under investigation in December of 2024. That thing said in 2023. They found out in 24. Okay, they had a year to do that. Two, they did not tell them. They didn't just be forthcoming and say that they are investigating Miss Liberty. They waited until Apple said something and the defense brought it to the court, and then they confirmed it. That's it. That's all. All right, they lied. They flat out lied, Lacey. I agree with that. And then I guess, in the motion, they kind of say, well, yeah, it has something to do with it. It's separate. It's unrelated, but at the same time, it is. And then they also say that Miss Liberty has to recuse herself because the conflict is that egregious. Yet you don't have anything in there. So I want to go back and listen to it. I feel like I missed something. I feel like there was another one or two things that the defense team brought up in reference to maybe paragraph 3 or 4 that I missed. So we're going to go back and rewatch that. But again, I don't want us to miss anything if anything additional is said. So we're just kind of waiting, hanging out here for a second. Oh, King Nail said, lock them up. Since they want to play gangster, go be where the gangsters at. They definitely playing a different game. They definitely playing a different game. How do you just lie?
Okay, so I'm going to see Mr. Bivens on February the 18th. If you need to get in front of me sooner, just contact my office. Although I am starting another first-degree murder trial tomorrow, but that trial may end earlier than I suspect. I'll just play that one by ear. Ms. Wilcox, FT, that concludes FT for today. That concludes FX until 3:30? Yeah. Okay. So then the division FX will otherwise be in recess until 3:30 this afternoon. Hope y'all have a nice one. All right, Mr. Court reporter.
3:30 from here.
All right. So it looks like they are concluding now. Everybody is standing up. We know that February 18th, 2025 is going to be the next court date for the hearings. Terrible. I agree, Kay. I agree. I thought it was 3:30 on the 18th. You want me to run it back a little bit? We're gonna run it back a little bit just to confirm in case anybody.
3:30 this afternoon.
Oh, wait a minute, this afternoon.
So then the division FX will otherwise be in recess tomorrow, but that trial may end earlier than I suspect. I'll just play that one by ear. Ms. Wilcox, FT, that concludes FT for today. That concludes FX until 3:30? Yeah. Okay. So then the division FX will otherwise be in recess until 3:30 this afternoon. Hope y'all have a nice one.
All right, we'll definitely be back at 3:30. Right. We'll stay 3:30. Whatever is happening. We're gonna be back at 3:30 for whatever is happening. But I told y'all I need to hear what our good boy stand up at that podium and say again. I need to hear him again. Yeah, it's about right here.
Tell me if he wants all of you to continue to be his lawyers or not, or he's going to have to tell me that he's going to seek other counsel, but I think that needs to happen sooner rather than later.
We concur with that issue. I'm confused, and I apologize to the court. Is the court entertaining this motion for reconsideration and not?
There was no motion or ruling. I think she's entitled to it. I think, listen, Mr. Demons is entitled to heightened due process. The state is seeking the death penalty. It is very clear that one of his lawyers is under investigation right now.
Okay.
he is entitled to have as much information as I have the ability to give him before he has to make a decision. Is there a conflict of interest? Does he want to waive that conflict of interest and continue with that lawyer as part of his representation? Or does he not? Does he want the lawyer to withdraw? And again, the Florida Supreme Court has been very clear on this. He's the captain of the ship. He
Absolutely.
makes this decision. So if there was, again, I'll repeat what I said, I think, to Mr. Aronson yesterday. If you all had some other authority that says I have some additional power to assist in the fact finding here, I would hear what the state has to say about it, but I would probably be inclined to do that. But my inherent authority, or citing the U.S. Constitution, although I very strongly believe in the U.S. Constitution, this is I'm not involved in this. The underlying facts that are going to make a determination is whether there's a conflict and what Mr. Devins wants to do. This is completely 100% a decision between himself and his lawyer. I don't have anything to do
We're
with it.
not disputing that.
So I don't know what else I can do at this point. You've asked me to press pause on all these motions. I'll press pause. I'm not going to move this trial date. This trial is going forward in September. So if these motions are heard next month, or they're heard in March, or they're heard in August, or they're heard contemporaneously during his trial, which again would not be the most ideal way to do things, but that's what ends up happening. That's what ends up happening. But the one thing I can tell you is not going to happen is someone that has been in custody for 2,160 days, his trial is not going to be delayed under any circumstance. So that being said, what else would you like me to do this morning?
Well, a couple things. Since the state filed a motion for rehearing, there are misstatements in their motion that need to be corrected. Since we received this early this morning and saw it for the first time, we did not file any written plea of response. And if I may, just go through the corrections that we saw. It's on number 1, it says the search warrant was issued in December of 2024. It was 23, not 24, a year earlier.
We agree with that, so, yeah.
In paragraph number 2, they said that the state disclosed an ongoing investigation to Miss Liberty. That is absolutely untrue. We learned of it through Apple. They confirmed it yesterday for the first time, over a year after the search warrant was executed. Paragraph number 5 indicates that this investigation is separate and apart from the defendant's current case. It conflicts with paragraph 11 that implies that this investigation is related to the tampering case of Mr. Demons. Is it unrelated or is it related? I think the court needs to know that, because if it's related, I believe, and we will file a written response under discovery, he's entitled to that information, anything that leads to relevant and important information. And I'm not asking the court to rule on it at this point, but I want the court to know that if it's related to his present charges under 3.220, we're entitled to that information. They make a statement that regardless of what Mr. Demons wants and is willing to waive the conflict, they believe that Ms. Raven must get off the case regardless of that. That's their assertion. They have to prove it. And I want to put the state on notice that they must prove. They can't merely allege that the conflict is so extent that even if this young man wants to waive it, they're going to come in here and say she must get off the case. That's what they say in this plea in paragraph number 11. That's a question for the court to determine, and they have to present evidence of that fact. We are still under the same impression that we don't have enough information. Pursuant to Your Honor's request, Mr. Aronson and I spoke to Mr. Demings. I call him Melly if the court will allow me.
I'd actually prefer that you use,
Mr. Demings?
Yeah.
Fair enough.
thank you.
Mr. Demings. We discussed the potential of that. And if the court accepts my representation, or the court can inquire from him, he informed us that he doesn't have enough information to make that decision.
You're
And I
talking to
want
me
to
about privileged communication.
Well,
I'm going to talk to Mr. Devens at the conclusion of the hearing this morning, everything that I'm allowed to talk to him about. I don't want to hear about anything that you all talk
I was just willing to proffer his statement of that fact. And we would, of course, ask the court to deny their motion for rehearing and rule consistently with what you ruled yesterday, that they not only have to produce the search warrant, but the affidavit.
Well, do you want to respond to any of the case law they cited about ongoing investigations? That would relate to the affidavit.
Well, it relates, if it's related to his present charges under Rule 3.220, they must turn it over. So let them come in here and make a representation that it is either unrelated, totally different, or if it's in fact related, he has a right to see that information. And 3.220 is clear on that. Anything that could lead to relevant information must be disclosed. Judge, there is one other matter that we need to go sidebar on.
Okay, well, hold that, pause on that till then. State, is there anything else that you want to tell me today? The only thing I'm going to do is talk to Mr. Devens about the front end of this colloquy, if you will, and then give you a future date, which I'm looking at is February 18th. That's the day before my next trial starts, after the trial that's starting tomorrow. And on Tuesday, February the 18th, what I'm also going to ask each side to do is, if there's any motion pending that you think I can hear that is not interfered with by the pending matters that are up on appeal to 4th DCA, state if you have anything that you want me to hear on February 18th, just file a notice of hearing and identify the motion you want me to hear. Defense, if there's anything else you want me to hear on February the 18th, just file a notice of hearing and identify what it is you want me to hear. I anticipate the murder trial that I'm commencing tomorrow will be done by then. It may not be, but I'm hoping that it is. And if it is, then I'll give you the whole day on February the 18th to address this issue regarding his representation. And if it turns out we can go forward and hear some of these pending matters, then I'll be happy to do that too.
Judge, I could just ask, I know you said file a notice of hearing, if we could have a deadline like by February 1st, so we don't end up in the same position we did this time where it was filed, pre-business
Well,
before.
Let's see, we're talking about February 18th. So how about the end of business on February the 7th? How about that?
That's fine, Judge.
All right, so that goes for both sides. If there's anything you want me to hear on February the 18th, just file a notice of hearing, identify exactly what it is that you want me to hear. And I'm going to see him February the 18th at 9:30 a.m. Again, we'll call it all pending motions. Maybe we'll be able to work all day and maybe we'll be able to do nothing. I guess that's really going to be up to you all. State, is there any other requests that you have this morning?
Yes, Judge, as to the search warrant itself that Your Honor is going to compel us to provide, I'd ask that we have until February 1st, just so we have time to pursue the appellate remedies in the meantime. And then I'd also ask that it provide to Your Honor in camera first, because it's the state's position that there are, even in the search warrant itself, certain things that make reference to other targets of the investigation, which are confidential, privileged, and would jeopardize the investigation. So we would ask that Your Honor review that in camera, if any necessary redactions have to be made, and then it can be provided to defense.
We would object to that procedure, and they've had a year, over a year, to produce these documents, so it's no surprise. We would ask that to be given to us by the end of tomorrow.
Okay, so listen, over the defense objection, state, this is what I'll do. I'm ordering you to turn over a copy of the search warrant. I need you to get that to me. A week from today, that's January 14th. End of the day, January the 14th, that comes to me,
Yes, Judge.
and then I'll review it, and then I'll distribute it as I see fit. I can't imagine there's anything in there I'm gonna redact. I mean, it doesn't matter, the state's free to investigate whoever they want for anything they want. To do this in the midst of a capital case State, I realize some things are gonna happen that you might not find ideal, but that is of your doing because you've chosen to do this in the middle of a capital case, so. Mr. Demon's heightened due process rights will take precedent over every other matter in this case, obviously. So that's just the way it's gonna have to be, but I'll grant your request over the defense objection, at least as to that. Ms. Wilcox can give you a blank order, you can fill it out this morning, I know it's over the defense objection, but show them the order, and I'll be happy to sign it. The search warrant comes to me within 1 week,
Yes,
and
Judge.
then I will review it in camera, and then I will distribute it accordingly, as I see fit. State, anything else you want me to do this morning?
The judge.
Defense, besides your matter that you want to talk to me about, sidebar, anything else
Yes,
you want
since
me to
you're
do this
going
morning?
to, in camera, review the search warrant, we would ask that the state submit the affidavit.
Well, the case law seems pretty clear that you're not entitled to that, but if you have some competing authority, I'm happy to look.
Yes, sir.
Your Honor, on another note, I was a little confused yesterday as to whether or not you have lifted the stay as far as discovery and we can start discovery again on everything, or are we still under that stay order? Just asking for
I asked both sides if you wanted to do that. I thought you both told me that you did want to do that, that you wanted to do the things that you can do.
I want to do everything,
I agree with you.
but,
Time is short, but,
but the state is the one that asked for the stay.
well, see, what do you want me to do?
Judge, we need to speak with the Attorney General's office, because we have that today for a reason with certain things, but we have plenty to do outside of that first, so. we
Okay,
have
well,
some-
why don't we do the things that we all agree we can do? So the answer to Mr. Hanson's question is yes. Without objection from either side, the stay is lifted to the extent that we can litigate any matter that's not currently before.
Well,
the
no,
court
we
this
are
year.
objecting to that, Judge.
That was already done by Judge Murphy.
Right, that's how you've been
Judge
done.
Murphy already lifted the stay.
He modified it,
Right, he
so that we
modified
could
it.
do ongoing discovery
okay.
as to things that were not up on appeal.
Again, if one side notices something for February 18th and the other side thinks that that is included in the matters that cannot be handled because it's currently at the Fourth District Court of Appeals, I'm sure you will file a written response and let me know that. And I guess I'll have to make a decision whether I agree with you or whether I don't. Defense, besides the matter that you want to talk to me about, anything else?
Judge, the only thing I would like to have you possibly consider is that you had said you were prepared to ask Mr. Deming some questions right now. I'm a little concerned that with the lack of information that exists in this case, for him to even opine on where to go right now, based on what? The paragraph in their motion that says that he has to make a decision now because you told him there's a conflict.
I'm not gonna ask him any questions. I'm just gonna explain to him the choices that he's made. No different than a defendant deciding to testify or not testify at a trial. I'm not gonna ask him any questions. I'm telling him what's coming. Because at some point, he is gonna have to tell me what he wants me to do.
And of course, we're gonna object at this point, and until the time that he's fully informed as to what there is that may be a conflict, he is in no position to answer, to make an opinion as to
I'm
whether,
not asking his opinion. You're objecting to me talking to your client about his rights?
it depends on what you say, Judge, but I am prefacing what your comments are because I was under the impression that you were gonna inquire with him as to whether or not that he finds there's a conflict.
No, I'm not.
Okay, great.
I'm not. Okay, again, so the record is crystal clear on this. I'm following this procedure pursuant to a case called Figueroa, Figueroa hyphen Sanabria, Sanabria versus State. It's a Florida Supreme Court case from 2023. It's found at 366 Southern 3rd, 1035. And this was a death penalty case as well. I'll quote what the Florida Supreme Court quotes. In all criminal prosecutions, the accused shall enjoy the right to have the assistance of counsel for his defense. All competent defendants have the right to control their own destinies. He's entitled to his constitutional right of assistance of counsel and there's nothing that makes him relinquish his right. So all I'm gonna do this morning is explain to Mr. Demmons that at some point, this is gonna be his choice. I'm sure his lawyers will give him the best advice, but this is gonna be his decision. And he may not agree with your advice at some point, just like a defendant may decide to testify or not testify and not follow the lawyer's advice. But I take this decision to be the same way. It's a fundamental decision. This is a client decision. This isn't a lawyer decision. So, Mr. Demmons, raise your right hand for me. You don't have to stand. You're okay. You can sit. You swear to tell the truth, whole truth, nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Please state your full name.
Chanel, Maurice, Jim,
How old are you?
25.
How far did you go in school?
I graduated, well, I got my own GED.
You read and understand the English language?
Yes.
Are you presently under the influence of any drugs, medication, or alcohol?
No.
Have you ever been treated for a mental illness?
No.
Are they giving you any medication in the jail right now?
No.
How are you feeling this morning?
Confused.
I understand. I'm a little confused myself. Your head is clear? You're not hearing voices. You
No.
hear your lawyers. You're talking to your lawyers. You understand what's going on this morning?
Yeah.
Okay. All right, so Mr. Demmons, here's the deal. You're, just like any other defendant, you're entitled to have a conflict-free lawyer or lawyers representing you. Okay, a lawyer that has your best interest in mind to the exclusion of anything else. You with me so far?
Yes.
Okay. The state has told you that one of your lawyers is currently under investigation. For what? I have no idea. But there's some ongoing criminal investigation. Okay, you with me so far? Okay. So this, what your lawyers correctly pointed out yesterday, raises immediately what we call a conflict of interest. In other words, maybe at some point during this litigation or some point during the trial, my lawyer's not going to do what's the best thing for me. My lawyer's going to do what's the best thing for my lawyer. And your two interests are separate. You understand that?
Yes, sir.
Okay. So, once your lawyers have had the opportunity to investigate all this, to get you all the information they can possibly get, so they can talk to you about all this, at some point, you're gonna have to make a decision about who you want your lawyers to be going forward. You with me on that?
Yes.
Okay. Even if there is a conflict, you can waive the conflict if you want and say, Judge, I understand there's a conflict, but that's okay. I like these lawyers. They're doing a great job for me. They did a great job for me in the past, and I don't want to change, lawyers this late in the game. You understand that?
Yeah.
Or you could likewise say the opposite and say, Judge, I don't feel comfortable with this. I think there's a conflict. I don't think Miss Liberty should be my lawyer anymore. I don't think any of my lawyers should be my lawyer anymore. And I want to go get some new lawyers. And if you want to hire your own lawyers, you can go out there and hire anyone you want. And if you want me to appoint lawyers to represent you, you would have to file an application with the clerk's office. And if they find that you're financially qualified, I could appoint lawyers to represent you. You understand that?
Yeah.
The whole point I'm trying to make with you today, sir, is that this is going to be your decision. Your decision. Your lawyers will give you their best advice, and you have some excellent lawyers, okay, about what they think you should do. But at the end of the day, you can follow their advice, or you don't have to follow their advice. It's your decision. Do you understand that?
Yeah.
Do you have any questions for me about anything that I've said so far?
We have a moment, John.
Sure. No questions? All right. So, Mr. Jennings, I'm pressing pause on the conversation at this point. We're going to have the second half of this conversation at some point in the future. I hope it's sooner in the future rather than later, because the last point I want to make sure, and I'm giving you and your family and your lawyers as much notice of this as I can, your case is set for trial September the 10th. And that's not that far away. Do you understand that? Okay. Your case is going to go to trial on September the 10th. So if you change lawyers, you're going to get a group of lawyers in place that are going to have like 7 months to prepare a capital case, okay? So the longer it takes to make this decision.
I'm going to object to what the court has just said. What you're telling him is right now that he is basically having to stay with us as his attorney, because if not, then he'll get another set of lawyers that will not be prepared, and they will only have 8 months to do what has taken years to do, and therefore you're pushing him into the corner that he has to stay with us. I don't think that's fair what the court has said.
Over your objection, sir. That's not what I'm saying at all. I want to make sure that you understand that time is of the essence. Do you understand that?
Yes, sir.
Okay. So I'm gonna put them back on the docket, February the 18th at 9:30 a.m. This issue with the warrant will be resolved at this point, and whatever's gonna be distributed to the parties will have long since been distributed to the parties. You all can file whatever additional motions you think are appropriate. If there's any motion the state wants me to hear, we're gonna do that in a notice of hearing. That's by the close of business on Friday, February the 7th. Defense, if there's any motion that you want me to hear, we're gonna do that in a written notice of hearing by Friday, February the 7th. If I don't have something noticed in writing by Friday, February the 7th, at the close of business, we will not be hearing it. On Tuesday, February the 18th, Mr. Deming's case remains set for trial September the 10th at 9 o'clock. State, anything else that I can do for you this morning?
No, Judge.
Defense, with the exception of your,
Yes.
all right, is the state coming up here too?
Yes.
Okay. Mike, this is not on the record. Dan, I think there's a microphone here. That needs to go.
For whatever reason, I can't get myself off of mute. But okay, so we learned a few things today. All right. So one, the state has to fix some things that they called out in their motion. All right. There were 4 things that I actually did capture them right. So it seems like my little mind it moved fast, but hey. It moved fast, but it got everything. What we do know is that the state has to turn over the warrant. The warrant has to be turned over by the close of business on January the 14th, for that January 15th deadline. Right. What the judge has agreed to is an in-camera review of the search warrant, and then we'll distribute it as they see fit. The state actually asked for the judge to redact some things, but the judge was like, yeah, I don't really think I'm gonna be doing all of that. But if you want me to do an in-camera review, I'll do that for you. We are going to pick back up on February the 18th, 2025. They said, hey, Marley. Say hey. She just waving. She waving, Cindy. The defense wanted the affidavit, but they are not getting the affidavit because it is an ongoing investigation. Unless they have some case law to present that, basically states that they have a right to the affidavit. Right now, they're not getting it. So I feel like that was something very important to call out. Now, yes, Jen. So at 3:30, we are in recess right now until 3:30 today. So we will be back at 3:30 to see what's going on in here. But as far as like the actual motions hearing, that's going to be February the 18th, 2025. Anything that they want the judge to review has to be submitted by the 7th of February. A few things that we've been talking about is the fact that Melly is going to have to make a decision on whether he wants to continue on with the legal team that he has, or if he wants to switch. The judge was pretty much adamant that he is not going to change his court date. So what does that do? It backs Melly into a corner, into a wall to say if he's going to keep that team or if he's going to switch. 7 months to prepare for a capital murder charge is crazy. It's crazy. It's wild. It's unprecedented. It's unheard of. So I'm curious to see what happens. I wish we could see that affidavit though, y'all, because I want to know why they feel like they have the authority to tell a defense attorney that they must recuse themselves. You must recuse yourself. Like, where they do that at? Demanding a recusal, but hasn't presented anything or even told them what the conflict of interest is. So I want to know what it is, y'all. I want to know what it is. And if it's based off of the stuff that was said in that habeas corpus, baby, they better have some proof. And the defense put them on notice that you better have the proof to support what you're claiming. Really did. Okay, so we are going to take.
Okay, so I'm going to see Mr. Evans on February the 18th. If you need to get in front of me sooner, just contact my office. Although I am starting another first-degree murder trial tomorrow, but that trial may end earlier than I suspect. I'll just play that one by ear. Ms. Wilcox, FT, that concludes FT for today. That concludes FX until 3:30?
Yeah.
Okay. So then the division FX will otherwise be in recess until 3:30 this afternoon. Hope y'all have a nice one. All right, Mr. Court Reporter.
3:30 from here.
All right, my love. So we will take a quick. I mean, I could put on Karen Reed right now for y'all, but I won't be able to watch it with y'all. Or we could take a 30-minute break and start on Karen. So tell the gang what y'all want to do, because y'all know we are inclusive over here, and I do what the people want. I could start Karen Reed for y'all, or I could wait a couple minutes and start it with me watching with y'all. Otherwise, yeah, that's crazy to me too, Hershey. That's crazy to me too. Because I know the people said they wanted to watch Karen, so I'm just waiting to see where my what my people want to do. They say you need to watch it too. They better leave Lady Liberty alone. If you ever get booked, you want Miss Liberty. Okay, so we're gonna take a quick 30-minute break. So we'll be back in 30 minutes to start watching Karen Reed. So look, Hershey said she need to do work for 30 minutes. So we're gonna take a break. You got to get your green back. Oh, you got to get a membership. Make sure y'all get y'all memberships. And honestly, I just use the little dollars that we get from the membership to pay for premium. So I think the premium is like $20. So 10 people having a membership pays for our premium account so that we don't have to watch commercials. So if you don't have a membership, get one. We only need 10 people to have one. And that just pays for our premium again, so we don't have to watch commercials. Because I think they're only like $2.99. Oh, Marley. Thank you, Mix Chicks. I appreciate it, y'all. Everybody, if you snatch one of these gifted memberships, make sure you thank our girl. Thank you, thank you, thank you.
this way.
I'm not sure I'm understanding what you're
Yep.
saying.
You see that this here, 2 teeth,
Mm-hmm.
if the dog's canines started here and worked their way down this way,
All right, friends. So we are going to come back and get started on Karen Reed. Thank you, Fancy, for becoming a member. And also, make sure if you haven't done so already, grab you a membership that our girl Mixed Chick gifted. Okay. And again, y'all, our memberships over here, they just pay for our premium account so that we don't have to watch commercials. So thank you for doing that, because now we're good for another month. Let's see. So we'll get started with Karen Reed. And I'll be honest with y'all, I'll have to go back and watch Karen because I'm not all the way up to speed on what is going on with her case. But a lot of the people who are in part of Taylor Game are. So if this is what my people want to watch, y'all know I will get up to speed to support y'all. So here we go.
Good morning, Mr. Brennan. Good morning, Mr. Lally. Good morning, Ms. McLaughlin.
Good morning, Your Honor. Alan Jackson on behalf of Ms. Reed.
Good morning, Mr. Jackson.
Good morning, Your Honor. Robert Alessi on behalf of Ms. Reed.
Good morning, Mr. Lessie.
Good morning, Your Honor. David Unetti for Karen Reed.
Good morning, Mr. Unetti. Good morning, Ms. Reed. All right, is Dr. Russell in the courtroom? All right, so why don't we have Dr. Russell take the stand?
Doctor, I'll remind you, you're still under oath. Thank you.
All right, good morning, doctor. All right, Mr. Brennan, whenever you're ready.
Thank you, Your Honor. Good morning, Dr. Russell.
Good morning.
Dr. Russell, it's fair to say that your opinions have changed between the time when you first testified at the voir dire to when you testified at the trial and then at our last time we met at the Lanigan hearing. Do you remember we spoke about when you testified at the voir dire hearing, you had uncertainty about what had actually caused the wounds?
I did not.
Do you remember using the words like most likely a dog?
No.
Let me remind you, in the voir dire, do you remember the court asking you what kind of animal caused the wound? And you said most likely a dog, a large dog?
May I see that?
Yes, you may. Counsel, page 51, line 18. May I approach, Your Honor?
Yes.
Dr. Russell, I'm showing you a copy of your voir dire transcript. I'm going to ask you to read it to yourself when you're done reading it. When you're comfortable with that time, I'm going to ask you the questions again. You can look at any part of that you would like.
Yes.
Thank you. Do you now remember when the court asked you what kind of animal you said most likely a dog, a large dog?
Yes.
Do you remember at trial your perspective and opinion changing?
No.
Do you remember you were asked at trial whether or not the patterns appear to be injuries you would see consistent with an animal or a large dog, and you said yes? Do you remember that?
May I see that?
Yes, you may. Trial transcript, page 23, line 3. This is a copy of your trial transcript. Feel free to look at any part you like.
Okay, I've seen, yes.
Okay, thank you. Do you remember now saying that?
I didn't say it.
Okay.
The question had that word possibly in it. I didn't say,
I'm sorry. You can finish, please.
I didn't use the word possibly.
You were asked, does this appear as a pattern of injury that you see appear consistent with an animal or a large dog? And you said yes. Do you remember that?
You sure that's me again?
Yes.
Okay.
Let's read it together.
Okay, that's a good idea.
Your Honor, may I make a suggestion if I could, please? I realize it's cross. Mr. Brennan and I have agreed that with regard to transcripts and the use of them, I have as well. Given that we've agreed for transcripts being in evidence, can the witness keep the transcripts and look at
Do
them?
you have an extra copy for her?
The answer is I have a copy, yes, that
Do
she
your
can.
colleagues each have a copy?
I don't know if they do, but I can give mine
Okay.
so that she
Problem
can
with
have
that,
it.
Mr. Brennan?
I'm coming with that.
Okay.
Is this on the copy?
It's okay, I know what they say.
Well, you might, I'm gonna go through a lot of it, so you might as well give her the whole trial transcript.
Okay.
What I'm going to do is I'm going to ask Mr. McDermott to make a copy of mine. All right, so that we can continue. You can give yours to the witness for a few minutes, and then when these are done, you can have yours.
Thank you, Your Honor, I appreciate that.
Thanks, John.
She's gonna do both. They're both yours. Yes. That's the 20.
Why don't we take a 5-minute recess? Mr. Brennan, Mr. Alessi, why don't we take a 5-minute recess? Mr. McDermott will be back with clean copies of the transcripts that I have as part of your exhibits.
Thank you very much.
And the witness can
So
have.
Mr. McDermott doesn't have to do it twice. Mr. Brennan has just indicated to me he's going to go back to the June 18th. So is Mr. McDermott going to copy the June 18th and the June?
I have the voir dire and the trial testimony, so we'll take a 5-minute recess.
Thanks very much.
All right, please.
I'm sorry, Your Honor, I'm just conferring if Your Honor's permission, Mr. Brennan, I want to make sure.
Hold on. Only one person can speak at a time. I don't know. All right, so you were speaking to me, Mr. Alessi. I think Mr. Brennan was speaking to his co-counsel. No, that's okay. I just
wanted to let you know what we were doing. Mr. Brennan and I are conferring to make sure we maximize the chances of the exhibits being right. So I've offered to Mr. Brennan something he wants to consider and look at what he has to make sure we do this efficiently.
Okay. So the copies that Mr. McDermott made are the attachments to the motions that were filed.
And provide a copy with the court's permission of the voir dire testimony, the trial testimony, and the Lanigan hearing.
Sure. Okay, I did not have Mr. McDermott do a copy of the Lanigan hearing.
I've had an extra copy that I've given to
Great.
Ms. Russell. I'm
Oh.
sorry, Dr. Russell.
Okay.
And if I may, can I write on the top of each transcript which each one is. That way it'll be easier for.
Is there a
Dr.
problem with that, Mr.
No problem
Leslie?
at all.
Okay.
May I again approach the witness?
Yes,
May I speak, Your Honor?
yes.
Dr. Russell, I'm handing you two documents. You have a third. The one before you is a transcript of the last hearing called the Lanigan hearing that you attended. This is a copy of your voir dire testimony. I've noted it on the top right for you, and also trial testimony.
Thank you.
Thank you. May I proceed, Your Honor?
Yes.
I had asked you if you had expressed any uncertainty in the past about your opinion as it relates to the opinion you gave at the Lanigan hearing, at the last hearing, whether your position has changed or evolved is what I'm getting at. And you said that your position has not changed. Is that right?
That's correct.
You were asked at the trial about the injuries and how you think they happened. I want you to turn to the trial transcript. If you'd turn to page 19, line 21.
Page
Page
Line-
19, line 21, may I approach, Your Honor?
Yes.
So the page number is here.
Yes.
And then line would be. Sorry. My apologies. This one is the trial. Okay. Do you recall at the trial, you were asked about the injuries, and you said, I believe that these injuries were sustained by an animal, possibly a large dog, because of the pattern of injuries? Do you remember saying that?
That's not here in front of me.
Okay, but I'm asking, do you remember saying that at the trial, that you believe the injuries were sustained by an animal, possibly a large dog?
Something to that effect, yes.
And when you said that, you used the word possible because you weren't certain, were you?
Can you show me where that is?
Well, I'm asking a question, not asking about the transcript. The reason why, when you were asked and you said it was by an animal, possibly a large dog, is because you were uncertain.
You know, Mr. Brennan, I think I explained that before, that in medicine, there are no absolutes. And that's what, physicians are ingrained to think, is there are no absolutes in medicine. So that's why I expressed it that way. But
Yeah,
I was certain that it was a dog.
Yet you were testifying as an expert witness, weren't you?
Yes, I understand that, but I was thinking like a doctor.
I see. You understood as an expert witness that you were asking the jury to rely on your opinion. You were trying to be as accurate as possible, weren't you?
Yes, I usually do, yes.
You were trying to be precise in your testimony under oath, weren't you?
Yes, and I don't see a difference really between those.
And when you use the word possibly a large animal, that's different than an opinion to a reasonable degree of medical certainty, isn't it?
Objection, Your Honor.
In this witness's view. She can answer that.
That's not what the transcript says that he's referring to.
So he's not asking about the transcript. I'm going to allow the question.
Would you like me to repeat that?
Yes, please.
When you chose the words during your testimony to precisely describe what you thought, and you said possibly a large dog, that is different than to a reasonable degree of medical certainty, isn't it?
No, I don't think so.
You were asked whether or not you could tell what type of animal left these marks, and you said you couldn't with 100% certainty. Isn't that true?
With 100% certainty, that's correct.
And The reason why you don't have certainty when you first testified is because there really is no methodology in identifying dog bite wounds, is there?
That's incorrect.
I see. When you talk about methodology, is there any standard you're comparing your comparisons to?
There are multiple published peer review articles that describe what dog bites and dog injuries look like.
Is there any standard that you use? Is there any particular things you look at with specificity that you compare to a standard model?
The pattern.
The standard model of patterns, where do you get that from?
Pattern recognition is used throughout medicine. And, it's something that I have been trained on since actually before medical school, but certainly in medical school.
Pattern recognition, you understand, is different than a standard of comparison. You understand there's a difference between those two things, don't you?
Oh, yes.
Okay, we'll talk about pattern recognition analysis in a minute. But what you're saying is that there's a methodology in identifying dog wounds. I'm asking you, where does that standard come from?
It comes from multiple published peer review articles.
Okay, tell me one.
To Munich.
I'm sorry?
To Munich. We talked about that one last time.
The gentleman who studied human teeth.
No, he wrote about dog bites.
Okay, what's the name of the article that you've relied on?
The name of the article, I have to refer to my report, but it's something to the effect of forensic evaluation.
Do you have any specific memory about what you're relying on as a standard of comparison to identify dog bite marks?
Yes.
Okay, share that with us.
Again, the standard would be what the wound looks like, and the pattern recognition that goes along with it, along with the configuration of the wounds. It's a multifactorial
I'm
process.
trying to have you assist us in distinguishing between pattern recognition analysis, which we're going to get to, and when you're looking at a wound, the standards in the science, the methodology you would actually use to look at it and see if there's points of comparison, to see if there's similarity. What standard are you working with?
I'm not so sure I understand what you mean by standard then, because I know how I evaluate wounds.
You have personal experience where you've treated dog wounds and you look at it and you're simply deciding whether or not to you this looks similar. You're giving your personal aside, aren't you?
I actually find that offensive.
Oh, okay. Well, is that what you're doing?
No.
So if you're comparing it to an actual science, a standard, a methodology, I want to learn that methodology from you. So what I'm asking you is, tell us, where does that come from? The methodology where you have a point of comparison, where you look at a wound and you compare it for similarities to another item.
There are several published peer review articles that describe what to look for, how to observe, evaluate, and then sometimes treat wounds, dog bite wounds. There are several authors that have published similar things. And in terms of there being an organization that says, here is the standard for dog bite wounds,
Right.
I don't think that there is one.
When you say you don't think there is one, if you're an expert in this field, you would know that there is not one, is there?
There is not one that I know of, correct?
Well, you're not guessing there might be one you don't know of.
I don't know of any published standard by an organization.
So it'd be fair to say, when you are giving an opinion, what you personally believe to be a dog bite wound, there is no standard in dog bite science that shows you what the standard is. There's nothing to compare it to.
Again, it's based on a combination of the experiences that I've had over the last 30 years, observing, evaluating, and treating dog bite wounds, plus the numerous articles that I have read on dog bite wounds, their characteristics, morphology, patterns, and other things like complications, et cetera.
Okay, so to get back to my question, I know that you're using your experience and your memory, but there is no standard of comparison. There is no methodology that is accepted as a practice.
I disagree.
Okay. Can you share with us one of those articles that you've been relying on to combine with your personal experience to come to conclusions in dog bite analysis?
Well, there's the Munich that we talked about.
I didn't talk about. Can you tell us a little bit about it?
Oh, certainly.
Okay, please.
Okay, would you like to go through it together?
I'm asking you to tell us about what you're basing your opinion on, and you said it's Munich, so I don't know much about
Okay,
it.
that's one of them.
Well, tell us a little bit about that.
Okay, well, in that article, the authors described a fatal case, but also described what some of the characteristics are in dog bite wound cases. What types of wounds you see, their appearance, their distribution, their configuration, the different aspects like that. Many of them are parallel. things that would affect the appearance of wounds that physicians know about, such as elasticity of skin and other ways that wounds can be distorted from one to another wound. So you have to know a little bit about wound characteristics and basically things to look for in the forensic evaluation of dog bite wounds.
Did that article lay out a standard of methodology?
I guess I don't understand what you're getting at.
Rather than having a particular case study where that article talks about a person that was attacked by a dog and deceased, correct?
In that case,
Yes.
however, it
And
referenced,
and
I'm
it's,
sorry, Your Honor, just to finish the question.
I'm going to let her finish.
please.
And Mr. Leslie, for objections, just simply objection.
I'm sorry, Your Honor, I will, thank you.
that article, it was a case report, but it was also a review of previous literature. So in the review of previous literature that had been published, they came up with recommendations. So yes, there are recommendations in that article.
In that article, it talked about a wound to the neck where the deceased bled to death, correct?
Yes,
Okay. It didn't talk about pattern recognition analysis.
I
in that article.
disagree.
Okay. And did it talk about a standard of practice of methodology?
Recommendations.
But that's not what I'm asking you. I'm asking you, did it have a standard, a methodology that it discussed?
These were authors that were practitioners, and they weren't, I don't believe they were in a position to create a standard.
In fact, you can't point to one place where there is a readily accepted standard in the dog bite community for identifying dog bites. You can't point to one article, journal, book.
That's correct.
And so because there is no methodology or standard for you to look at, it involves a great deal of your subjective opinion based on your experience treating dog wounds, doesn't it?
With all due respect, Mr. Brennan, I'm not somebody that just came in off the street. I have at least 30 years as a physician, and I use that information in helping me form my opinions about wounds. I've seen all types of wounds.
Okay, so my question was, because there is no methodology, because there is no standard comparative analysis, you need to rely almost virtually on your personal experience treating wounds.
No, I believe you're again mischaracterizing it. I'm relying on my personal experience plus what I've learned from these numerous articles.
And so because there is no methodology and standard to compare to, you've introduced the idea that you have used a process known as differential diagnosis.
That's one of the processes used.
And as far as differential diagnosis, what that suggests is when, as a doctor or a person looking at symptoms, you try to rule out other conditions that have similar symptoms.
Correct.
Okay. And so you said, although that's traditionally used in a doctor assessing a cause of a patient's symptoms, you're using that in identifying dog bites, this differential diagnosis you speak of, right?
I used it to assist me, yes.
Okay. And so when you're using differential diagnosis, it means that there are many other ways or reasons why the same symptoms can occur.
Not always. Not always. It could mean that there's just one or two other conditions that would resemble this, but it's a process that a responsible physician would go through.
And in this case, you went through differential diagnosis to exclude other causes of these abrasions on Mr. O'Keefe's arm?
I did.
If you had used your training and experience and you were certain to a reasonable degree of medical certainty that these were dog bites, you would not need to go through differential diagnosis.
Oh, that's so incorrect.
Okay.
I'm not perfect. I'm not 100% perfect human being. And so so I have to, as a responsible physician, in every case, go through a differential diagnosis to make sure I'm evaluating and treating the right thing if there's treatment involved.
When you chose to go through differential diagnosis, you recognized that these abrasions could be caused by a lot of different mechanics of injury, didn't you?
I considered that they could have been caused by others, but I went through the process.
Well, you were uncertain, weren't you?
No.
Yet you went through this process of differential diagnosis anyways.
Yes, absolutely.
Okay. And when you did that, you decided that you should focus on car accident.
No, I didn't focus just on car accidents.
Well, what other subjects did you focus on in differential diagnosis other than car accident?
Could these have been self-inflicted, for instance?
You went through that process?
I did.
I didn't see that anywhere in your report
It's in
whatsoever.
my head. I didn't write it down.
Well, aren't you supposed to report the process you go through before coming to conclusions? Isn't that why you wrote a report in discovery and disclosure?
Yes, but
Okay. Is there anything else in your head that you thought about that you didn't put in the report or tell anybody? So we have car accident, we have suicide, we have dog bite. What else did you think of in your differential diagnosis?
well, I thought, could it possibly be road rash?
Okay. What else did you think?
Oh, I don't remember all the things I thought of at the time, but it wasn't a very large list, but it was a list, and it was a differential diagnosis.
Well, if it was important enough to think about and distinguish and go through differential diagnosis, can't you remember what it was that you thought it could have been the cause other than suicide, road rash, car accident.
Well, of course, I mean, there were some things I thought of and immediately ruled out, you know, were these stab wounds inflicted by someone else? No.
Okay.
You know, so the list, there was a list that I went through in my head. Would it be worth writing down? No, I don't think so.
Well, was there any other significant causes that you went through and vetted through differential diagnosis that you didn't write down?
Not that I remember at this time.
And that's why it helps to write it down. Okay. So one of those causes of these abrasions that you went through differential diagnosis for was car accident, wasn't it?
Yes.
In fact, when you first met the defense attorneys, you had an interest in this case, didn't you?
I thought I could clarify the issue of what those wounds were caused by.
So you were learning about information about the case publicly before you got involved in this case,
No.
didn't you? Well, you knew there was an issue.
I heard, yes, I did know that there was an issue. I saw something in the Boston Globe, and Mr. Brennan, I wasn't following the case at all. I don't even subscribe to the Globe for information about this
You don't-
general region.
You don't have to be defensive about it. I'm just asking you.
Okay.
You knew
Just
enough
clarify.
that you wanted to get involved and you made some phone calls to offer your services.
I didn't want to get involved, but I thought that I should.
I see. And so you learned enough through your study or the Boston Globe or television that you knew generally that there was an issue about the abrasions, correct?
I knew there was a question, yes.
You knew that the defense was claiming that a dog caused those injuries.
I wasn't even sure who was claiming what at that point.
So you didn't know much about anything, but you still made phone calls to introduce yourself to get involved in the case?
Again, I know that there are very few people in this country that have the combination of experiences that I do, and I thought that I could just clarify the issue and maybe, help people move along in the case.
Before you decided that you were going to offer your services, what did you know about the case?
I knew that a police officer had died. I was a former police officer, so I knew that a police officer had died. And I knew that there was a trial, and I didn't know details really. I just knew that I believe I read that there was something about a car accident versus dog bites. That's about all I knew about the case.
Had you seen any photographs?
No.
So just generally knowing that there was an issue, you thought you could help because of the word dog bite in your experience?
Correct.
Okay. So when you ruled out motor vehicle accident, is it fair to say that your perspective was a motor vehicle accident would have caused injuries to the other parts of the body, and that's why you considered car accident as not part of the cause of these abrasions?
That was not the only reason.
That was one of the reasons?
Yes.
Did you look at the wounds and you thought based on the accident, there would have been broken bones or other injuries?
That was one of the reasons.
Okay. So based on those two reasons and other reasons, you decided to exclude car accident as the cause of these wounds, correct?
Correct.
And when you made that decision to do that and exclude car accidents, you didn't really have the experience in car accidents to decide whether a car accident was the cause of these injuries, did you?
Mr. Brennan, I've seen thousands of car accident victims through my emergency medicine career. So I had plenty of experience.
Had you ever been trained as an accident reconstructionist?
No, I'm trained as a physician to treat car accident victims.
But that's not what I asked. What I asked you is, you ever been trained as an accident reconstructionist?
No.
Have you ever taken classes and certifications in accident reconstruction?
No.
Have you ever gone to a scene of an accident and been asked to give your opinion and help reconstruct the accident?
No.
Have you ever served as a witness in court as an accident reconstructionist?
No.
In fact, when you decided that this accident couldn't have happened, you hadn't even read the investigative reports, had you?
No, I didn't decide that an accident didn't happen. What I decided was that those injuries were not from a motor vehicle accident.
When you first gave your opinion in this case, she was done.
Hold on, Mr. Leslie. Next question, please.
When you first gave your opinion in this case, excluding car accident, you had not even read the investigative reports in this case, had you?
That's correct.
And when you were asked about materials that you reviewed to give your opinions, you said you were just trying to focus on the wounds and you hadn't read those reports, right?
That's correct.
Have you read the reports to
Yes.
date? You now have read the reports?
Yes.
Okay. When you excluded the car accident, did you know anything about this collision between the Lexus and Mr. O'Keefe? Did you know anything about it?
Objection, Your Honor.
Can you answer that question, Dr. Leslie?
Did I know anything
Yeah.
about?
Did you know anything about how it happened?
I was somehow I knew that. Well, I believe I knew that the car was backing up. That's what I was. Somehow I got that information.
So
The
when
car
you were
backed up.
excluding the collision in this differential diagnosis, did you know how fast that Lexus was going back when it struck Mr. O'Keefe?
No.
Do you know how far it traveled when it hit Mr. O'Keefe?
Objection, Your Honor.
So it's a question, the question's proper. Let's see if she can answer it. She may not be able to answer it as asked.
Mr. Do you know how far the Lexus traveled backwards when it hit Mr. O'Keefe?
Your Honor, I'm objecting to the
I
assumption.
understand. I understand, counsel. Can you answer that question as asked, Dr. Russell?
As asked, no, I don't know.
When you excluded this collision as differential diagnosis, did you know the angle of the collision between the car and Mr. O'Keefe?
I'm going to see counsel at 7.
Ma'am,
Yes.
when you engaged in differential diagnosis, excluding a car collision as the cause of these abrasions, did you know or learn any information about the angle of the strike between the Lexus and Mr. O'Keefe?
No.
Do you know whether or not the person, John O'Keefe, who had these abrasions on his arm, do you know if that person used his arm in any way to defend himself from an oncoming vehicle?
I considered that,
You did.
yes.
And in considering that, did you consider the body position of John O'Keefe?
Oh, yes, I considered various possibilities.
Okay, what was his body position at the time the car allegedly collided with him?
Your Honor.
Use the word allegedly. I'm going with that.
What was his body position?
I considered several possibilities. I considered if he was standing, I considered if he was kneeling or sitting or even lying down. I considered multiple
Was
possibilities.
he standing?
I don't know that. I don't know, but I considered all of those possibilities.
Was he kneeling?
I don't know.
Was he lying down?
I don't know.
So you considered all these things, but you have no information, fact, or understanding of what body position he was, do you?
I went through the process of what the wounds would look like in those various positions.
I see. So if John O'Keefe was trying to defend himself, pulling his arm up to brace himself, what would the injuries have looked like?
Well, if they penetrated his clothing,
If what?
if there was penetration of his clothing,
Uh-huh.
from broken parts, for instance, they would have been quite irregular. It would not have been multiple parallel abrasions and punctate wounds that were seen in those pictures
How do you know that?
from my many years of experience.
Did you do any comparison analysis of the broken taillight in Mr. O'Keefe's arm
Actually, eventually I did.
before you gave these opinions, did you?
I didn't need to because I've seen thousands of accident victims.
Every accident is dynamic and changes, isn't it?
Yes, but I also had that in consideration. That's why people train for the number of years that I trained.
Every accident is different, isn't it?
Yes, probably.
And so you can have a number of people in an accident and they can have different injuries from the same accident, can't they?
Oh, absolutely.
Right? If a car drives down the street and runs into 20 people, they may all have different injuries.
I agree.
Same car,
I agree.
might be the same speed, but they could hit people differently. Some people, unfortunately, they could kill, right?
Yes,
Some people could be catastrophically injured but still alive.
correct.
Some people could have scratches and bruises.
Correct.
Some people could be in that type of situation, bounce off the car and escape without a scratch.
Possibly, yes.
Right? So there's no science or standard when you say car accidents would have had a certain result. The truth is you don't know.
I disagree with you.
Okay. And so when you were excluding these causes, you have no idea his body position or angle, correct?
I went through various scenarios in my head.
But I'm asking you, not the scenarios in your head, Dr. Russell. I'm asking you about detail, fact, science, okay? I'm asking you, do you have any idea the position of John O'Keefe's body when he allegedly was struck by the car?
Objection, Your Honor.
I'm going to 11.
I considered multiple scenarios.
Tell me the facts you have. Tell me the facts you have. You can tell us how is his body postured on fact. What facts do you have?
Again, I considered multiple scenarios.
When you did you go to the scene of where Mr. O'Keefe was found lying on the ground? Did you go and visit the scene?
No,
Did you take and look at photographs of the scene?
I looked at some photographs.
What did you see in those photographs?
They were very difficult. It was very difficult to see much useful information in the photographs.
When you're engaging in differential diagnosis and you're excluding causes of abrasions to Mr. O'Keefe's arm, wouldn't it be important to either go to the scene or look at clear photographs so you could see all the debris and the land and the turf and see what it looked like? Wouldn't that be important?
No, in the 30 years of or emergency medicine experience I've had, I've never gone to the scene of a car accident victim that was brought into the emergency room.
And you've never gone into court and testified as an accident reconstruction expert.
A reconstruction expert? No,
You've
but I've
never-
testified about vehicle
And
accidents.
you've never gone to court and
Victims.
testified as a dog bite expert before this case. Yes?
I was never asked.
And so when you say what you used to do, you treated people who came in with injuries. I'm talking about when you're going to exclude something as a cause. I'm asking if you have any experience in actually going out and looking at the facts and using science to exclude something fairly.
I used medical science.
Do you know what the ground looked like when Mr. O'Keefe lay that morning?
There was snow.
You know how many inches of snow were under his body?
Under his body?
Yeah.
No.
Do you know what the ground was? Do you know if it was smooth like a turf football field or frozen jagged like dirt tends to do in the Northeast during the cold winter?
I considered several different possibilities: grass, dirt, asphalt. So I considered several different possibilities to see in my differential diagnosis.
You considered all these different possibilities, but you never even went and looked at the scene to see what it looked like, did you?
I didn't have to.
Do you know if there was twigs or roots or a brush nearby?
I don't know.
Do you know if there was a fire hydrant nearby?
There was a fire hydrant
Do
nearby.
you know if there was a curb nearby?
That I don't know.
So you have no idea really, other than a fire hydrant, what this area of impact, alleged impact looked like, do you?
Well, again, a curb would not have caused those wounds, so that's irrelevant.
You have no idea.
I disagree.
Did someone tell you what it looked like?
No.
Okay. You said that you ruled out car accident or collision in part because there were no broken bones. Yes?
In part.
And we've
Except
agreed,
for, excuse me, except for no skeletal broken bones.
and we've agreed that car accidents are a dynamic process. Not all car accidents result in broken bones, do they?
That's correct.
It depends on how and where and a number of other factors in the collision. Yes?
That's why it was only one of the factors I used.
It's one of the factors you excluded. Do you know the difference in force between head-on collision and a side swipe?
I have a general idea.
Is there less force when someone is hit on the side of the car as opposed to being run over?
Is it supposed to be run over?
Yeah.
Generally, yes.
Right. And I'm sure in your thousands of treatments, you have treated people in the hospital who have come in contact with a car who did not have broken bones.
Oh, yes.
Plenty of times.
Excuse me?
Many times.
Yes, but they weren't dead.
What's that?
They were not dead.
Right. Okay. Well, you don't know when Mr. O'Keefe died that morning, do you? Do you know what time he died?
I have I have a range.
You didn't think he died from the abrasions on his arm, do you?
No, he did not die from the abrasions.
Okay. He died from a break in the back of the skull from hitting the ground, right?
Oh, he died from a skull fracture and brain injury and
Yes.
hypothermia.
Hypothermia.
Yeah,
Okay.
not from an abrasion to his skull.
Right. The abrasion for his arm had nothing to do with his death, did it?
It did not cause the death.
Okay. And so is there a difference between the force when a car hits somebody directly on or hits them on the side?
Generally, yes.
Right. And you've seen many times somebody has been in contact with the motor vehicle with no broken bones, many times.
I have seen that, yes.
I mean, there's a difference between being run over and hitting the side of a car, isn't there?
That's correct.
So if someone didn't hit them, they just clipped them, that might be different than being run over in the middle of the crosswalk in the middle of the car. Yes?
Yes, that'd be correct, but you have to put it in context.
Now, you said in addition to your experience treating injuries, you also have experience as a police officer.
Yes,
Yes. And you've responded to many car collisions as a police officer, didn't you?
I did.
And when you respond to car collisions, whether it's a pedestrian or another car, there are certain things as a detective you detect that are in the street, right?
As a detective?
Yeah, a detective or a police officer, you go to a scene
Mhm.
and there's a collision, you certainly see things often as a
Yes.
result of the collision, don't you?
Yes.
Tell us some of the things that you'll see as a police officer after a collision. What do you
Oh,
see?
After a collision, you oftentimes see debris from the car.
Right.
From
Debris
vehicles,
car.
yes.
You can see rubber, right?
Probably. I don't know if I have, but yes.
Sometimes metal pieces, parts of the car.
Right.
And sometimes when there's a collision, maybe often, you see glass, don't you?
Yes, you do.
Yeah, glass breaks when a car collides with something oftentimes, doesn't it?
Yes.
And so when you were doing this, engaging in this differential diagnosis, did you consider the circumstances, the physical evidence at the scene from where Mr. O'Keefe was found?
I considered the possibilities. Yes.
Okay, well, there's a phrase, getting knocked out of one's shoes. You've heard that phrase, right?
I've heard the phrase.
Well, you've heard the phrase in relation to car collisions, haven't you? A person getting knocked out of their shoes.
And other things, yes.
Yeah, but not other things. We're talking about car collisions.
Okay.
That's what we want to talk about today.
Okay.
You've heard the phrase knocked out of one's shoes in car collisions, haven't you?
Yes.
Yes, because the force is so great when a car hits a body, it moves the body, and the shoe from friction on the ground can sometimes be left behind. Yes?
I don't know the actual causation, but yes.
Well, you did know when you review this case that at the very area where that car backed up and Mr. O'Keefe was found, one of his sneakers was found next to the curb on the street. You know that, don't you?
Objection, Your Honor.
Are you aware of that fact?
No.
Okay, next question.
You were never given any of the information, the physical evidence at the scene where Mr. O'Keefe was found to help you engage in this differential diagnosis?
I eventually saw reports.
So you do know. You do know about the sneaker.
I also, well, I don't know that. I don't know where the sneaker was found. No.
Well, what do you know about the sneaker? It sounds like you know a little bit about the sneaker. Tell us
No,
what you-
I know that in hypothermia, there's a condition called paradoxical undressing, where people are sometimes are found without their clothes and shoes. Because and in this case, there was hypothermia.
Do you have any opinion that Mr. O'Keefe undressed his shoe before he died?
I have no opinion about that.
Do you have any information, evidence to support such a comment like that?
I'm just advising you that there is a phenomenon called paradoxical undressing. So that is possibly a cause.
In that phenomenon, does somebody take off one shoe and leave all their other clothes on?
It's possible they could, yeah.
Right, and you have a case that you've seen
No,
like that?
I have not.
No. Okay. And so in this case, at what point did you learn that Mr. O'Keefe was knocked out of his shoe?
I don't know.
Objection, Your Honor.
Phrase it differently.
At what point in this case did you learn that Mr. O'Keefe's body was about 7 feet off the street, fully clothed, not undressing himself, and that his sneaker was on the roadway right next to the curb?
Objection, Your Honor. Same page.
So, did you learn that fact?
No,
Next question.
So as you sit here and testify today, you didn't know that?
that's correct.
When you're ruling out car collision in your differential diagnosis, wouldn't it be helpful to know a little bit about the physical evidence of where it was found at the scene?
Again, my focus is injuries. The injuries caused by car accidents, not the scene itself,
Right.
injuries. So that's what I focused in.
A dog wouldn't knock somebody out of their shoe, would they?
Excuse me?
A dog wouldn't knock somebody out of their shoe, would they?
I don't think so.
Okay. When you are excluding car collision as the cause of these abrasions, and you consider circumstantial evidence as a police officer, if there was trace evidence on that shattered taillight, would you want to know about that?
Yes, I would.
Yes. And DNA is a form of trace evidence, isn't it?
Yes.
It's a pretty sound piece of trace evidence, wouldn't you say?
Yes, if collected properly and chain of evidence, yes.
One of the most formidable pieces of scientific evidence that is used in medicine and science, isn't it?
In forensics, yes.
Yeah, forensics. And so when you used differential diagnosis and excluded the car collision as the cause of the abrasions to John O'Keefe's arm, did you know that there was DNA on the taillight of the defendant's car?
I did not know that.
Would you wanted to know if there was DNA, particularly would you wanted to have known that the DNA on the taillight of the shattered taillight was John O'Keefe's DNA? Would you want to know that in your differential diagnosis?
That would be helpful. However, again, that the car accident did not cause that configuration of wounds.
And when you're considering the cause of the wounds and you're trying to rule out car accident, you know that that taillight had been shattered, leaving glass and jagged edges. If you had known there was John O'Keefe's DNA on that taillight, would have you wanted to have taken a closer study of the taillight casing and the broken glass?
I don't think it was necessary. Those wounds are so characteristic of a dog attack.
Do you know there was other trace evidence on the back of Miss Reed's car that morning?
Such as?
Hair?
No.
You didn't know that one of John O'Keefe's hair was left on the bumper?
No.
And engaging in your differential diagnosis, considering the mechanic of injury, wouldn't it be important to know that the trace evidence coming from John O'Keefe was left not only on the defendant's car, but in the particular area where the damage to the car, the taillight?
Objection, Your Honor.
Were you aware of that fact, Dr. Russell?
No.
Next question.
When you were excluding a car collision as the cause, did anybody share with you the digital forensics, the black box information showing and demonstrating where the car was, the speed it went back and the distance? Did anybody share that with you?
No.
Did you know that John O'Keefe had a cell phone?
Not surprised.
And do you know that at a certain point when that car left, his cell phone, which was found near his body, never moved? Did you know that?
I read that, yes.
And when you were using differential diagnosis and thinking about the potential causes of abrasions in the arm, did it seem important to you that all these facts coincided? The car reversed, the damage, John O'Keefe on the ground, the phone under him?
Objection, Your Honor.
I'm going to allow that question.
Did you consider those things, Dr. Russell?
As I mentioned earlier, I considered various possibilities of a car accident and a pedestrian accident, I should say. And I went through many scenarios in my head, and no car accident scenario could create that configuration of wounds that's on the arm.
You've done advanced studies on wounds related to car accidents and broken taillights?
I've seen thousands.
Oh, no. Have you done any studies? Do you have any journals that you rely on to say that there's a expected pattern that's going to happen when a taillight intrudes through a sweater and into one's skin?
I have, yes, there are many textbooks that I have relied on.
Okay.
It's a fundamental area of study in forensic medicine and emergency medicine. And in fact, the examination of the exterior of the body in a motor vehicle accident case is emphasized, and special lectures are given about that topic to the forensic doctors.
You never examined John O'Keefe's body.
By photographs, yes.
You never examined his body.
Personally, no.
No, personally, you never examined his body.
I never touched his body. I examined
No,
the photographs
you
that were taken in the hospital and in the coroner's office, medical examiner's office.
When you're treating at the hospital and people are coming in telling you there was a dog bite, you're relying on that reporter's history, aren't you?
Usually, yes.
Or an eyewitness who saw it and told you about it.
Correct.
When I asked you before when we were here the last time about any cases where you had to make a diagnosis without information, you couldn't point to one. I asked you to give me one example, and you couldn't give me an example, could you?
I don't remember patients' names.
And so when you rely on the reporter as a medical expert, you take what they say, right? And you assume it's true.
Oh, not always.
I see.
No.
You
No,
look and see if it's
absolutely
not.
One, excuse me, one person speaks at a time. Let
Please.
her answer, Mr. Brennan.
No, I don't always take what they say is true because there's many reasons why people do not tell the truth.
Did somebody ever come in and say it was a dog bite and you did differential diagnosis and pattern recognition analysis and determined they were lying, it was not a dog bite?
No.
In all the hundreds, thousands of cases, never has anybody reported to you a dog bite and you determined independently through your powers that it wasn't a dog bite.
Not dog bites, but other wounds, gunshot wounds, stab wounds, many other kinds of wounds. People report that they occur a certain way and actually they have occurred a different way.
With respect to dog bites,
Mhm.
every time you've treated a patient, they've either told you what happened or somebody with them has told you what happened.
Or they didn't know what happened.
Okay. In this case, when you were excluding the collision as the cause of the abrasions on Mr. O'Keefe's arm, did you look at witness statements?
As far as I know, there were no witnesses to the event.
Okay, well, did you read the testimony of Officer Sarif? Because the witness who talked to him was Karen Reed. Did you read that?
Objection, Your Honor.
So ask the question differently, Mr. Brennan.
Okay, did you know that Officer Sarif reported that Karen Reed said, "This is all my fault. This is my fault. I did this." Did you consider that or know about that when you made your differential diagnosis regarding the collision?
At some point, I did know that there was a statement like that.
Not like that. Did you know about this statement? "This is all my fault. This is my fault. I did this." Did you know about this statement?
Objection, Your Honor.
Did you know that statement? I'm allowing the question.
No.
Let's move on.
Did you know
Mr.
about the statement to Mr. Flamati? "I hit him. Oh my God, I hit him." Did you know about that statement?
Not that statement, no.
Did you know about the statement that you repeated repeatedly? "I hit him. I hit him." Did you know about that?
I learned that there was some question about whether there was a statement or a question, did I hit him? I learned that, but that doesn't, I mean,
Where
okay,
did you learn that from?
I don't remember.
Okay. You said that you had experience in domestic violence cases? Okay. Did you know that it's reported that the defendant and Mr. O'Keefe got in an argument shortly before this happened?
Yes, I know that.
when you were considering the cause of these injuries, did you consider Ms. Reed's statements herself to not just witnesses, but to the public, to national magazines and programs? Did you consider any of that?
I don't read the national magazines.
Well, would it help you if you knew she told Boston Magazine that maybe John hit the back of her car, telling her to stop, and then she ran over his foot, or she clipped him in the knee, and in his drunkenness, he passed out? Would that help in your differential diagnosis?
Objection, Your Honor.
I'm going to allow that.
It wouldn't help because those wounds were caused by a dog.
Well, if you believe that statement that she said about running over his foot and clipping him, it would help you conclude that it wasn't a straight-on accident, that it was on the side, right?
Objection, Your Honor.
I'm going to allow it.
Even if it were on the side, the car did not cause those injuries.
And we talked about when someone's hit on the side, they could brace or defend themselves, correct?
Oh, correct.
Right. And do you know that if John O'Keefe was standing up and his arm was bent, it would be about the same height as that taillight?
Yes, that I understand. I've been hit on the side. I know about side injuries, side swipe injuries.
Yeah, clip. It's different, right? And so knowing that his height matches up with the taillight, what other evidence would you want to know before you excluded the taillight as the cause of the injury? To be thorough, what else would you want to know?
Well, I see pictures of the fragments of the taillight, which I eventually did, and were there any pieces of metal that had the configuration, anything that could cause those parallel lines with the punctate injuries in between?
How about taillight fragments?
Yes.
Little pieces of glass, right? When glass shatters, it shatters randomly, doesn't it?
Well, it depends on what kind of glass. So
How about, I'm sorry, please.
it depends on what kind of glass.
I want you.
Well, motor vehicle glass, a lot of motor vehicle glass is tempered glass, and that shatters a certain way and creates a characteristic injuries.
Okay. Tell me about your experience in Lexus rear taillight coverings. What is the pattern injury on that?
I'm not aware of any pattern injuries.
And are you aware when the rear taillight of a Lexus breaks, the different pieces it breaks into? Is it random or is there a standard in how it breaks?
I'm not sure, but I have an idea.
I'm sorry?
I'm not sure.
Okay. Did you look at any photographs of the scene in the debris field showing the different size taillight fragments at the very scene where Mr. O'Keefe was found on the ground? Did you look at any of those photographs?
I attempted to, but I couldn't see much detail.
Okay, so
Photographs were not good.
Okay, so you don't really have a command of what the debris field looked like relative to the taillight fragments that were on the ground that morning.
Again, I imagine various scenarios of what broken glass and taillight would look like. And again, I could not come up with any scenario that would cause those parallel marks and the pattern that we described.
Well, I don't need you to imagine a scenario. I only want to talk about one scenario. That's the scenario that led to the death of Mr. O'Keefe that morning. That's the scenario I'm asking you about. And the debris field that actually existed that morning. So what I'm asking you, when you engage in differential diagnosis and you take the position that this couldn't have happened, I need to understand what you actually know about the physical evidence that's at the scene. So that's what I'm going to ask you about, that scene. If you don't know, it's okay. But I want to ask you about that scene that morning. Do you know how many pieces of taillight were found on the ground where Mr. O'Keefe was found?
No.
Do you know the shapes and sizes of the shattered parts of the taillight that were found in that debris field where Mr. O'Keefe was found?
I've seen a picture of various pieces of taillight. Yes.
And if you've seen that, you would see that there are a number of different pieces of shattered taillight. Yes?
Correct.
Of different sizes.
Yeah.
Of different shapes.
Uh-huh.
Different diameters, right?
Yes, they're irregular, very irregular.
Different, irregular.
Yeah.
Irregular. Many of them sharp.
Yes,
Perhaps almost all of them. Yes?
possibly.
Well, you say possibly because you never actually have looked at the physical evidence. You just looked at a couple of photos.
I looked at photos, correct.
And as far as the housing for the taillight, what is that made out of?
I believe it's made out of a plastic, and there's a metal around it.
It's metal.
Yeah.
What's the shape of the metal around it?
What's the shape?
Yeah, what is it, when you're describing the metal that you saw, what does it look like?
Well, it looked like there was some curves in it.
Curves?
Yeah.
Any straight lines in it?
Yeah.
Yeah. Any jagged parts of it from the breaking?
Yes,
Okay. And inside, were there other parts other than just the casing, like wires or metal sticking out?
yes.
How many pieces?
I don't know how many.
Did you ever measure those angles or study the angles of the pieces of metal in the casing?
No.
And you never studied the angles or took measurements of any of the shattered taillight, did you?
No.
Okay. Now, sharp objects can cause puncture wounds, can't they?
Yes,
Sharp objects can go through clothes and tear a, no, let me finish, you can answer. Sharp objects can puncture a hole through something like a sweater, can't they?
They can.
And if that object comes back out, it can pull the threads back out with it, couldn't it?
Theoretically, yes.
Yeah. And a sharp object like glass can poke or push a hole in a tear in a sweater and then rub up against the skin, causing an abrasion, couldn't it?
And, well, yes. Yes.
And if the glass and the angles and the shattering is irregular, it could cause irregular type abrasions.
Not like that pattern.
No, that's not what I'm asking you. I'm asking you, can irregular glass that penetrates a sweatshirt or a sweater and rubs up against the skin, can it cause irregular looking abrasions?
Yes.
And if there's two pieces of metal or glass that are straight, could it cause a linear abrasion?
Yes.
Would you agree with this statement? In a car accident, linear wounds are most commonly caused by contact with shattered glass from the windows, particularly tempered glass, which breaks into small, sharp shards that can create linear cuts on the skin when the body impacts it during the collision. These are often referred to as dicing injuries in forensic medicine.
Yes, and so they're not really very long linear. They are tiny linear abrasions or lacerations.
Abrasions come in all different sizes.
Right, but the ones that are caused by tempered glass are very, very characteristic.
Does glass cause a slicing pattern?
It can.
And it can cause a linear abrasion.
Yes, but there's a specific pattern with tempered glass.
You have an opinion.
Oh, no, it's fact.
Okay.
It's in textbooks.
Yeah, it's in textbooks that glass can cause linear abrasions.
The tempered glass pattern is in textbooks.
Glass from this broken taillight could cause linear abrasions.
Yes, I agree.
Okay. So the glass that was in this debris field that you got a little look at, it had sharp edges, some of it, right? Yes?
Yeah, I
Yeah.
imagine so. I don't know for sure.
Do you know if it had parallel edges?
Parallel?
Yes.
I don't know.
Now, when you're looking for trace evidence to see if something caused an injury, you look for remnants of that.
Yes.
In this case, you didn't do any study of the clothes and you didn't do any study of the actual Mr. O'Keefe's body, right?
I did not have hands-on
Okay.
study. Correct.
But you did learn that there was something remarkable in Mr. O'Keefe's sweater, didn't you?
Can you be more specific?
I can. Glass shards or broken taillight plastic shards. You understand they were found in Mr. O'Keefe's sweater, right?
Doesn't surprise me.
Well, I know it doesn't surprise you, but the question I'm asking you is when you decided to engage in differential diagnosis and you decided to exclude collision as the cause of this abrasion, didn't you want to know all the facts and information in considering whether it was the taillight that caused the abrasion? Didn't you want to know that information?
Yes.
Okay. And when you were considering that information, did you know from the criminalistics reports that shards of that broken taillight were littered in his sweater?
I did not know that.
When's the first time you learned of that?
Right now.
Right now. And so when you've prepared for this case and you've received materials from the defense, nobody has ever sent you, ever, the criminalistics reports that show taillight shards were in his sweater where the abrasion was. No one ever showed you that?
I don't recall seeing that at all.
Oh, boy. Well, talking about being a detective and using circumstantial evidence and trace evidence, I want you now to consider this new evidence that you didn't know before you testified at the voir dire in the trial in the first Lanigan hearing. I want you to,
I'm sorry.
Let's hear the question.
when you were ruling out the taillight as the mechanism of injury, when you excluded it in your differential diagnosis, and you said to a reasonable degree of medical certainty that these injuries that you looked at were caused by a dog bite. Now that you know that there's a debris field of shattered taillight right near the body of Mr. O'Keefe, and now that you know in his very sweater with the abrasions, the same arm under them, is littered with shards of taillight from that Lexus, does that in any way change your analysis in your differential diagnosis, excluding the car as the mechanic of injury to that abrasion?
Objection, Your Honor.
I'm going to minus the police officer, the detective.
No, it doesn't change my my conclusion that those injuries, those abrasions were caused by a dog bite.
How do you think the shards of taillight got into his sweater?
They could have got into the sweater from an accident, correct?
From an impact with the taillight, yes?
Could be.
Right. And when the taillight breaks and there's jagged, irregular, linear, sharp edges from that break, what do you think is going to happen to the skin when those shards impact the skin.
They could cause injury, yes.
They could cause puncture wounds, couldn't they?
Yes, they could,
They could cause scratches, couldn't they?
but not in that configuration.
I need to ask you the question so you can answer my question. They could cause scratches, couldn't they?
They could cause scratches.
And you have no studies on how abrasion looks after an impact with a taillight that is shattered. You don't have any studies or comparative analysis there, do you?
I have no studies. I just have my years of experience.
You know what wasn't found for trace evidence in that sweater? DNA of a dog.
I understand that.
You know when dogs bite, saliva, foam, sweat in their mouth, correct?
I also understand that there were issues with the collection.
Well, we're going to get to your claims and see if there's any basis for it, but that's not the question I asked you, but I will invite you to talk about that in a second. Looking forward to that. What I'm asking you, you know when dogs bite, they can froth at the mouth,
Yes,
sweat,
probably.
yeah, saliva,
Saliva, yes.
right? And when they get active and aggressive, it increases the production of those viscous materials, doesn't it?
I believe so.
Yeah. Well, it's in some of those studies and reports and books you've studied all these years, isn't it? That that's exactly what happens?
That they increase their production
Yes.
of saliva? No, I haven't seen that, but
Okay.
it makes sense.
And so when the dog bites a person, if they're biting through material, that saliva naturally could be embedded in the material, couldn't it?
Could be, yes.
Yeah. And something like a sweater, right? It traps liquid, doesn't it? Been out in the rain in the sweater. You don't want to wear a sweater in the rain. You'd be soaking all day, right?
That makes sense,
Yeah.
yes.
There was no dog DNA found anywhere on the holes in that sweater, was there?
No.
You understand that the crime lab took swabs of every one of those holes, right?
I don't know how many holes they took, but
Well,
yes.
before you
multiple.
discount or allege a conspiracy about DNA taint, wouldn't you want to know what they did before you criticize them?
I know that they took swabs.
Okay. Do you know that they took swabs of every hole?
No.
Do you know that they then packaged them and they tested and they sent them to UC Davis?
I know there was an interval of time
Well,
between the,
people are exonerated.
Your Honor.
Hold it, I just need to hear the answer. Next question. please.
People are exonerated decades after they've been wrongfully convicted based on DNA. Yes?
yes,
DNA lasts for a long time sometimes, doesn't it?
it can.
Okay. And so you know that the DNA or the samples that were swabbed from the sweater was sent to UC Davis. You know that.
Yes,
And you know when they did the analysis, there was no dog DNA,
right.
right, on any of those holes.
Right.
And you've opined that these are bites, teeth going in and out of those holes all the way up and down the arm.
Yes,
Now, it is remarkable that there is no dog DNA on any of those holes in the sweater, isn't it?
again, there's an issue with the collection and transportation of that.
I'd love to talk to you about that. We're going to, but you got to get through my questions first. It is remarkable as a doctor, as a scientist, that there is no dog DNA in any of those swabs or holes. It's remarkable, isn't it?
Remarkable would not be the word I use.
Extraordinary.
No, I disagree.
Hard to believe.
I disagree.
Okay. Now, there is no dog DNA. Do you think somehow that hurts your cause or your case or your opinion?
Objection, Your Honor.
Assistant.
Do you think that somehow challenges your opinion that there's no dog DNA?
No,
Because many times you've interrupted and tried to talk about a suggested or a supposed taint that doesn't exist. And I'm just curious, why is it so important for you to discount dog? Why is it so important for you to discount the fact that dog DNA does not exist on any of those holes?
Objection, Your Honor.
I'm going along.
I'm aware of many of the steps that are involved in the collection, preservation, and transportation of evidence. And there are multiple places where that can go wrong. So the absence of the evidence is not as remarkable as the presence of the evidence.
What training and experience do you have with regard to DNA evidence? Your answer, not very much. Does that still stand today?
Correct. I've had lectures, but I'm not a DNA person.
Not very much, right? And so now you're suggesting, without any fact, that many things could have gone wrong.
Absolutely, with any specimen.
Right. So you're willing to come into court and just float an idea without a good faith basis or fact?
Objection, Your Honor.
Assistant.
What went wrong in the collection of this DNA? What went wrong in it?
I can't tell you what went wrong, but I can tell you that there were possibilities that there were errors at various steps.
Okay, well, if you want to claim and allege an error to demean or discount the evidence, tell us what the error was that happened with the production, the preservation and testing of this DNA. What was it?
I can't tell you the exact error, but there's, first of all, the
decedent was in the snow for a while.
Mhm.
So it may have washed off some of the evidence.
What evidence do you have that it washed off?
I don't have any proof, but you asked me possibilities.
No, I didn't ask you possibility. You're raising possibilities. I'm asking you what evidence, what fact do you have that DNA was degraded or taken from that sweater because he was lying in the snow? What evidence do you have?
I don't have evidence. I'm considering different possibilities.
Uh-huh. What about the preservation of it? What evidence do you have before you make such a claim that somehow there was an irregularity or a taint? What evidence do you have that there was something about the accumulation of this evidence, this item that was tainted?
I didn't say, or I didn't mean to say that there was a definite error in the process. I'm telling you that there could be. So that's why a negative finding is not all that remarkable.
When you're in a courtroom, you know as an expert witness and as a doctor, you can't speculate. That's not a reasonable degree of medical certainty, is it?
I'm telling you, with a process, just like when blood is drawn from a patient, for instance.
This is coming from somebody who says they don't know very much about DNA. You're floating an idea that you have no factual basis for.
I'm talking about a specimen in general.
I'm not
It doesn't have to be DNA specimens. Specimens in general there can be errors in the process.
But we're talking about DNA here because you brought it up last hearing. You suggested that there was an irregularity at the last hearing.
There could be. You asked, for an explanation why DNA was not found. Well, that's a possibility.
So when you're using words like something could have gone wrong, you're not suggesting in good faith, and in fact, that you believe something went wrong, are you?
Objection, Your Honor.
I'm going to allow it. Are you suggesting that, Dr. Russell?
I'm suggesting there's a possibility that something could have gone wrong.
But you can't tell us what that was.
No, there are multiple steps.
Tell me one of the steps that went wrong. Tell me anything.
No, I can't tell you definitively that anything went wrong on a particular step. I'm telling you that there are multiple steps where error can occur. That's all. So and any physician, even not only scientist, but physician knows that not all test results are 100% accurate.
All right, let's wrap this up. So
Okay.
you've been through the UC Davis report.
Yes.
You've been through now you know there's a criminologist report and they swabbed all the holes, right? There is an absence of dog DNA. We agree about that, right?
That's what you're telling me.
Right. And we also agree that you have no actual science, medicine, or fact to suggest that there was anything wrong whatsoever with the collection, preservation, and testing of this dog DNA.
I have no evidence. That's correct.
Okay. I want to now turn to the actual exhibits and photographs and ask you some questions about the photographs and about some of the statements you've made prior about those.
Okay.
Okay. Have exhibit 5, please. You've seen this exhibit before.
Yes.
You've testified about it a number of times.
Yes.
And you understand this is a photograph of Mr. John O'Keefe's right arm.
Yes.
You've described different abrasions on that arm on different dates in court, haven't you?
Yes.
I want to start from the left to the right. And although we haven't used numbers, I'm going to characterize it as a number so we know which wound we're talking about, so that we can discuss the different statements you've made about each wound. The wound closest to the shoulder, you see that wound?
Yes.
I'm going to call that wound number 1, if you don't mind.
Okay.
When you look at the wound closest to the shoulder, is it fair to say that you've given different versions or statements about what you think was the cause of that abrasion?
Not that I'm aware of.
Remember testifying in the voir dire in this case when you first came in before the trial?
Yes.
And you described that that is a pattern, saying there are 2 wounds with potentially a scratch in the middle?
Yes.
Okay. And do you remember saying in that voir dire that they were consistent with teeth marks?
With teeth marks?
Yes.
I believe I do.
And do you remember when you first testified in this case at the voir dire, you said they could also possibly be consistent with nail marks?
Yes.
Okay. So when you were looking at this, and isn't this an example of no methodology in dog bite science? Because when you're looking at that, there's a very big difference between what teeth would have caused and what nails would have caused, isn't there?
No.
Oh. teeth on a wound start with a puncture and then pull down, or the bottom teeth puncture and then pull up? Is that fair to say?
Not always.
And a nail, a dog's nail shaped kind of like a horseshoe, right? The nail. And so when it pulls, it's going to leave a very different pattern than a tooth, isn't it?
Not necessarily. It depends on how deep the contact is between the nail or the tooth and the skin.
Suffice to say, when you first testified under oath about wound number 1, you expressed uncertainty whether it was teeth or whether it was nails.
Yes.
And so you didn't have any standard criteria to look at the wound to try to match up a comparative analysis. There's nothing specific where you would have a standard where you would say, well, this is what I would need to determine it's a nail, and this is what I need to determine it's a tooth. You didn't have that, did you?
There is none. And in the literature, authors have mentioned that it's very difficult to tell the difference between a claw wound and tooth mark sometimes.
When we look at wound number 1, when you originally said it was either teeth or nails, you then testified at trial, and you said the same consistent thing at trial, that this could either be teeth or it could be nails.
Would you repeat that?
Sure. After the voir dire, when you said that this wound, number 1, could have been caused by a dog's teeth or a dog's nails, you then testified a few days later at trial. And you said the same thing, didn't you? That this wound could have been caused by teeth or nails.
May I look?
You don't remember?
It sounds right.
Okay. Well, I want you to look and be sure. It is trial transcript, page 20, line 3. Thank you. Page 20. Sorry, line 3. Yeah, right there. Okay. Dr. Russell, do you have the same transcript as us?
Yes.
Okay. When you were talking about the number of patterns, you started with the upper part of the arm. You talked about the parallel lines, and you said they were inflicted by either teeth or claw marks.
Line 3?
Well, start at line 3. Teeth or claw marks is actually line 5.
Line 5 says the word photographs here.
Okay. You must have a different version of this.
Are you talking about the trial?
I am, so you have a different copy than we do. My apology.
20, line 3?
I'm gonna have to show my copy only because there's different versions of the transcript going around.
All right,
It's not
so
gonna reconcile.
what I have that Mr. McDermott copied on the trial transcript is what you just read from page 20, starting at line 3.
And that's what we have, but it's not the copy that Dr. Russell has. So if the court would allow me, I'll show her my transcript.
All right, I thought Mr. McDermott's copy went to Dr. Russell. Okay. Sure, go ahead, Sherry.
I mean, I believe one copy has the sidebars and one copy does not.
Okay. Okay.
Do we have a second copy of this trial transcript that I can give her? Here you go. So the trial, you similarly said that this was caused by either teeth or claw marks.
Yes.
Okay. And so there was obvious uncertainty by you whether this was teeth or claw marks when you testified at the voir dire and when you testified before the jury at the first trial.
Yes.
You told counsel when you had your direct examination on the last case that between the time of the trial and between your testimony at the first hearing and this Lanigan hearing, you had not reviewed any further materials.
No, I don't think I said that.
Oh, you did review further materials,
In the process of writing my report,
which Mr. Lisi helped you with, yes?
Objection, Your Honor.
in the process of writing my report, I did review articles. I re-reviewed the photographs, and and my opinion even became a little clearer.
So when you testified in front of the first jury, expressing an expert opinion, you weren't very clear?
No, I was certain that these were either teeth or claw marks.
Okay, but things have evolved, haven't they?
Yes, I have in the course of reviewing and also being challenged. You know, I'm being challenged. So I needed to re-review everything. Yes, things have evolved.
So things have changed.
Changed? No,
Well,
It's one of the, I said teeth or claw marks.
well, it's not one or the other. You're supposed to testify with specificity.
Again, in the articles, in the literature, medical peer review literature, it's mentioned that it's very difficult in some sets of marks to determine what's a claw mark and what's a tooth mark.
So based on your reading of literature that tells you it's very difficult to distinguish, you nevertheless then come into the hearing and you change your testimony and distinguish, because what you said now at the last hearing is this wasn't claw marks. Your position now is that these were teeth marks, not claw marks.
I also mentioned that I saw some punctate wounds up here, these two little wounds up there, and that helped clarify.
That picture hasn't changed since you looked
Yeah.
at it before voir dire.
Perhaps I didn't see them the first time. They're very faint.
You made a mistake.
No,
Oh.
either teeth or claw marks included, both of those.
So because you overlook certain things, your opinion you gave to the jury was not an accurate opinion.
At the trial? Is
Yeah,
this
at the trial.
Is this a trial?
Yeah.
This is the trial. It isn't accurate. It's
Well,
either
the-
teeth or claw marks.
Well, that's not what you're saying now. Now you're saying it was teeth, not just teeth. You're saying it was canine teeth.
Yes, I believe now
Right.
that they're more likely canine teeth.
Well, you didn't say more likely. You said to a reasonable degree of scientific certainty.
Well-
Is it more likely or is it to a reasonable degree of scientific certainty?
Reasonable degree of medical certainty.
Is that what you're saying?
Yes,
To a reasonable degree of medical certainty, those are now dog bites.
those are, teeth marks.
These right here.
Correct.
All right, and to a reasonable degree of,
It's my opinion that to the reasonable degree of medical certainty, those are marks made by teeth.
and the teeth that you claim that these are now made are the canine teeth.
Yes, I believe so.
Well, not you believe so. I want to know if you're certain about this, a medical certainty.
Yes, to a reasonable degree of medical
Okay.
certainty, those are made by canine teeth.
Okay. And so your opinion from the time when you first testified at trial, the opinions you gave to the jury, it's now different.
I don't see it as different.
Okay. What else did you overlook in this wound when you first gave your opinion to the jury? What else did you miss?
I don't think I missed anything. There's another abrasion in the middle.
Well, no, we're not going to move on. We're going to stay right here in one until we're done.
Excuse me.
Staying
I
on
mean,
this-
there's an abrasion right there in the
Right.
middle.
What's that caused by?
It could be caused by one of the incisor
Well,
teeth.
when you say it could be, I want you to use science and not just speculate. How many incisors are on the top row of a healthy dog
6.
and the bottom?
6.
Okay. And if a dog has healthy incisors that are not irregular, that are even, you know it's not going to have one incisor leaving a scratch and the other one's leaving no mark.
No, I disagree with that. It's very possible. Skin is very elastic,
Mhm.
and teeth are not always the exact same
Right.
height and have the exact same configuration.
And if they're irregular, one's bigger or missing or there's a gap, it could leave an irregular mark. Could.
It could.
But you don't know that. You don't know anything about the dog that is claimed to have caused this wound, do you?
I don't know about his specific teeth. No.
And do you know whether there's any irregularities in Chloe's teeth that would cause this irregular scratch by the incisor in the middle and leave out any other marks?
Even if there were no irregularities, the fact that skin is elastic and that that it could mean that not all teeth made contact.
Do you know anything about Chloe's incisors on the top and whether there's any irregularities or missing incisors? Do you know?
I don't know.
Would it help you to know that?
It'd be nice to know, but
Well,
but
when you say
I don't
nice,
need
when you say nice, is that a medical term of yes, it would be helpful to know that?
it could be helpful.
And so when we look at wound number 1 that you now say is a bite mark, not a scratch mark, caused by canines, how many canines do you think caused these 2 linear lines?
I believe that those are caused by 2 canine teeth.
Okay, so did the canine teeth start at the top and work their way down, or did they start at the here and work their way up?
I can't say.
Well, wouldn't you, if you're going to say the canine teeth, wouldn't you want to look at the wound and see where the puncture starts and then where it tears from? Wouldn't you want to know that?
You know, excuse me. There is no puncture.
Uh-huh.
There is no puncture in this one.
Right. And when a dog bites, the bottom jaw with their canines grabs and anchors, and then the top pulls and tears. That's how a dog bite works, isn't it?
Sometimes, if both the upper jaw and the lower jaw actually make contact, but not always do both jaws make contact.
It's a 3rd-prong lever, a jaw, the way it works. It traps and pulls. Yes?
If there's contact, yes,
Right. And so
with both jaws.
most animals don't just bite with their top teeth and drag.
It happens quite a bit.
What happens with frogs, right?
I don't know anything
vernal pool
about
in the area.
frogs.
It doesn't
Right.
happen with dogs. Dogs bite and pull.
They try, but they don't always contact with their lower jaw.
Did you look at the underside of Mr. O'Keefe's arm to see if there was any punctures or abrasions as an anchor that would allow the top canines to pull on this?
I did.
Yeah. And what'd you see?
I didn't see.
And so what would have had to happen in your version of events is that the dog would have had to not create a puncture, but just scrape with its top two canines and not anchor into anything else.
And that happens often.
Uh-huh. And you can't tell whether the canine started here or started here.
That's correct. I'm not
Right.
sure.
Well, here is not a puncture, but it's a rounder wound. We're still on wound number one. The right linear abrasion is wider and rounder, isn't it?
It appears to be.
Okay. And this is a little more narrow up here than it is down here.
Correct.
Right? But there's no way the canines from the top mouth could have started here and worked their way down here. There's no way that could have happened, right? Because this arc would mean that the dog's mouth is backwards. The dog's mouth is backwards if it went this way.
I'm not sure I'm understanding what you're
Yeah.
saying.
You see that this here, two teeth,
Mhm.
if the dog's canines started here and worked their way down this way, they don't line up. They're not even. It's backwards.
It would be an odd configuration.
Well, odd. It would be like Ripley's Believe It or Not. The dog would have to have their teeth the opposite way.
No, I could see how that could happen.
Really?
Yeah.
Okay. And these two scratches, there is no puncture, you say. You don't know what direction it's going in. There's no anchor on the bottom. But yet, your opinion is that these are dog bites.
I believe they are, yes.
Based on just simply looking at them. And you've seen something before in your experience that makes you think it looks similar.
Again, based on my 30 years of experience.
But you don't have any comparative sample or any type of model where you're looking at this and matching up particular points of interest with specificity, like a fingerprint, a squirrel, or a whirl. You're not looking at this and saying, well, this is endemic of a dog bite or a canine. There's nothing about this that is particular or specific.
The pattern is fairly specific. It's highly specific, actually.
This pattern here
The
can only
pattern
be
of
caused by
the whole configuration, the whole arm.
Let's start with this one, though.
Yeah,
There's
but you have
nothing-
to take things in context.
We're going to go through all of them, then we can talk about all of them in context together. Because I know what you said at the last hearing, but I'm talking about these. There's nothing about these that are particular or specific or endemic to a dog bite, is there?
If the arm only had those two
Right?
abrasions,
Uh-huh.
yes, it would be extremely difficult to say that those were a dog.
Well, it's not difficult. There would be no objective evidence that it was a dog bite. It wouldn't just be difficult. It wouldn't be accurate. There's nothing about these that's just dog bite. There's no puncture. The abrasions consistent here. They're different.
There's a
Objection, Your Honor.
Part of you shouting objection adds to the overlay.
What would you like to
So
do?
when you start to stand and say object, that's fine. Dr. Russell, you finish your answer, and
I'm
Mr.
back.
Brennan, wait until she finishes her answer before your next question.
I'd like to see the court.
Dr. Russell, we were talking about these two scratches or abrasions as wound one. I want to continue asking some questions about wound one. And I'd asked you, now that your position is that these were caused by the canines of the dog, was it the upper or lower canines?
I can't tell 100%.
Well, not 100%. What's your opinion? Are these upper or lower canines?
I believe they're upper canines.
Okay. And why do you believe these are upper canines as opposed to lower canines?
Because when the mouth of the dog opens and attacks, it's usually the upper canines that grasp first.
And you're saying because there's an absence on the other side that this must be the upper canines? Is that your logic?
I'm saying because it's usually the uppers that grasp first.
There's nothing in methodology or comparative study that would tell you that these are consistent with upper canines. You're just deducing that based on there's only one pattern instead of two?
There's nothing that makes it definitive, correct?
Well, not just definitive. There's no cues. There's no clues. There's nothing here that says to a person or even an expert that these are caused by canine teeth.
Well, the other consideration is if the victim was trying to defend himself, it's the upper canines that would impact first on that surface of the arm.
What if the victim was defending himself from a 6,000-pound car?
I
That'd be a
don't think,
different
this-
type
I
of
don't
wound than
believe
this?
this is not caused by a car. I
So
don't believe
what
so.
evidence do you have that the victim was defending himself, which caused the shape of wounds?
Again, it's very common for someone who's under attack to take their arm and flex it in front of them to protect their vital organs,
Okay.
the neck, head, face.
So if Mr. O'Keefe is flexing his arm to defend himself, that doesn't answer the question, what identifying feature with specificity in these support any conclusion that it was a canine tooth that caused either of them?
Well, first, in general, it's the canine teeth that are going to impact because they are much longer than the incisor teeth.
Right. The question I have is, look at these two scratches here. What objective evidence do you have based on methodology, comparative analysis? What evidence do you have that either of these were caused by a dog tooth, a canine?
Again, the methodology is that I looked at the overall pattern of the wounds on the arm, not just those two wounds up by the shoulder, but the overall pattern.
So your testimony is, if I look at everything together, I can have an opinion. If I look at this separately, it means nothing.
If I look at it separately, I cannot be as definitive, correct?
Well, not as definitive. I'm asking you for an opinion. You don't have any evidence that this has any relation to a dog bite. Without looking at the whole arm and giving that general opinion we'll get to, you have nothing as far as facts or comparative analysis or studies that would say that this was caused by canines on a dog, do you?
It's consistent with two canine teeth. There's a distance between those parallel marks.
Did you measure the distance between where this begins or ends, because you don't know, and this begins or ends?
I would have loved to,
And
but
if I could just finish, I'm sorry. Did you measure the distance between this and this and this and this?
I could not measure it because there's no ruler in that picture.
You know that when a dog bites, the canines don't move. Unlike paws that might open or close, teeth stay the same distance apart, don't they?
Correct.
There's nothing that you know of in any dog science that canines, when they bite, they open or close, they get wider or more narrow. They're always the same distance, right?
With it, for that dog, yes.
Right, that dog.
Assuming that they're healthy teeth, yes,
And you don't know if they're healthy teeth or not because you never looked at Chloe.
correct.
Okay. And you're not saying there's any punctures anywhere in here, are you?
I don't see a definitive puncture.
Or do you see a puncture that's not definitive?
At the very lower aspect of the photo, this area is not well defined.
So you're saying this is possibly a puncture?
I can't rule it out by that photograph.
Well, couldn't you rule it out through other analysis and evidence? Couldn't you rule it out as we just spoke about? Because if this was the puncture, that means the bite is going this way. And if
That's
it's going
making
this
us-
way, the arc is in the total opposite direction. Couldn't you rule it out just on that?
I couldn't rule it out, but it certainly makes sense that it would not, that the punctures would not be down below.
Well, not does it not make sense. It makes no sense that it would go this way. It wouldn't be going up if the dog has an arc going this way. The arc would have to be this way.
It depends on the position of the victim.
A dog's arc is not going to change depending on the position of a victim.
No.
And the dog's canines are not going to move depending on the position of the victim.
That's right. But if he's bending over and depending on the position of the arm, the wound can change. The wound can have a different appearance than what you would expect.
Okay. Let's move on to number 2, which I'm identifying as these two layer scratches and then the scratch on the bottom. You've testified about this wound number 2, although you didn't characterize it as wound number 2, right?
Yes.
Okay. When you first testified under oath in the voir dire about wound number 2, do you remember what you said that you thought that might be?
I believe I said bites or scratches.
Teeth or claws, right?
Yeah.
Okay. Now at trial, did you change your opinion at all about teeth or scratches?
I'm not sure.
Do you think you said at trial that this was not scratches, but most likely teeth?
I may have said that.
And then you testified at this hearing, didn't you?
Yes.
And now definitively, you're saying this wasn't scratches at all, it was teeth.
Definitively, I cannot say that. They
Okay.
still could be scratches. There's a possibility that two adjacent nail marks made that.
So you're saying this could be nails or could be scratches? I mean, this could be nail
Bite
scratches
or-
or could be teeth?
Yes, there's a possibility that those could be scratches.
When you were asked on direct examination, that wasn't your testimony, was it? I turned you to page 101, line 13.
On what day?
I'm sorry, the last hearing date is the thickest of the 3. Yes, it's page 101, line 13.
Yes.
One.
It's the thick one.
Mhm. Okay.
No, that's the wrong site, so we're gonna, you got that one. At that hearing, when you last testified, did you say that teeth made those marks? You were unable to say which teeth, but it was teeth?
Yes, I believe I did.
Okay, so your position from the voir dire and from the trial testimony changed regarding this wound when you last testified at the Lanigan hearing.
I still think that they are probably teeth, but I cannot 100% rule out scratch marks.
Did you say something like, I'm not sure exactly what teeth made these? They could, one of them could, one set of these could be canine, one part of this and an adjacent incisor tooth, but I'm not sure on the second set.
Again, it goes to the fact that the wounds are not very specific for differentiating between between teeth and claw marks. However, it's in the setting of a pattern, one can get a whole lot more information, and that is supported by the articles.
So getting back to wound number 2, when you described this for Mr. Alisi, he suggested to you, so even though you may not be able to identify the specific aspect of the dog dentition, you're able to identify this is from some aspect of dog dentition. Is that what you're saying? And you said yes. So you were saying at the last hearing, this is from dog dentition.
Mhm.
Dog dentition is different than toenail marks.
Paw marks, yeah.
So your testimony
Yeah.
that you offered the jury in this case was different in regards to wound 2 than the testimony you offered the court at the first part of this hearing.
The jury?
Yeah, the jury. When you testified at trial, you said it
Right.
was claw marks or teeth.
Uh-huh.
You said at the last hearing, this was dentition, teeth. So the opinion has now changed.
I think for the most, well, I'm sorry if maybe I made a mistake.
No, I don't think so. I think your opinion has changed. You said this was either claw marks or tooth marks. You weren't sure. There was uncertainty at trial.
Uh-huh.
At the Lanigan hearing, when you were asked by Mr. Alisi, he asked you specifically if this was dentition, and you said it was.
Objection, Your Honor.
Okay, so ask the question differently without the commentary.
You're saying now this is not claw marks or toenail marks. This is by teeth, dentition.
I actually think it could be either.
Now, would you agree that is different than what you said the first time you testified at this hearing?
It sounds like it.
So you've gone back and forth kind of a little bit.
It's not a definitive. It's not in and of itself. That set of abrasions is not definitive.
Well, you didn't offer the jury the opinion that they weren't definitive or that you had confusion, did you?
I'm getting a little confused because at the jury, you told me that I said it was one or the other.
Right. And then you changed to it was dentition, and now you're back to claws or teeth?
I think it's still teeth, but yeah, I can't rule out the claws.
Okay. And because you have no comparative standard, you don't have a standard in the industry where you can look at this and say it has 6 points of contact or 6 features of similarity. You don't have anything like that. You're simply relying on your personal empirical experience.
Well, no, I also saw these 2 punctures, the punctate wounds right there. And that made me think that it was more teeth than claw marks.
This here you're describing
Yes.
as punctate?
Punctate,
Yeah.
yeah.
You never got the benefit of seeing Mr. O'Keefe, did you?
Personally, no.
Did you know he was Irish? Light skin?
Makes sense with that
Yeah.
name.
Freckles, moles. Look at these. They're all over his body. You don't think the dog was puncturing up all over here, did you?
No.
Right. So these are the same. These little things, these skin blemishes, same as these all over the body.
Oh, you're a
think-
doctor?
There's no question.
Do you think that what you're describing as dog puncture wounds, you could be mistaken for just his skin and the different types of marks on his skin, like freckles or moles?
I don't believe so, particularly since they're right where those wounds are, the abrasions are.
Well, wouldn't the skin blemishes be there before any abrasions?
I haven't seen a picture of him before this incident.
Okay. So to get back to, we're now at, this is either a dog bite or it's a scratch. What is it about the top 2 that tell you it's a dog bite?
Would you rephrase that? Or, I mean, would you say it again?
You're saying these are either dog bites or scratches. That's what you're saying. You're not sure which one, but it's definitely a dog. That's your position.
Yes.
Okay. What about these 2 are telling you that this is a dog bite?
I think I said it already previously, that they're parallel. They're parallel lines. that seem to have these punctate lesions associated with them. And they're in and around the other lesions, I believe, are dog bites.
When a dog punctures and pulls, there's not an island of skin and then it goes back to the pole. The puncture starts at the pole and then it goes to the bottom, doesn't it?
There are no complete puncture wounds on this arm.
Well, you just cited puncture wound as a reason why you think this was a dog bite. You said these aren't these are not a skin condition, rather they're puncture wounds, and that was the basis for saying these are bites. If you don't know if these are puncture wounds or not, how can you say these are dog bites?
First of all, I did not say, with all due respect, I did not say they were puncture wounds. They are punctate lesions.
Okay. And so
They're different.
the punctate lesion, is that caused by a tooth?
Yes, I believe it is.
And you know when a dog punctures, it then tears and pulls.
Only if they penetrate the skin. They have to penetrate in order to pull,
And
to create a laceration and pull.
and a puncture is not a penetration?
A puncture is, a punctate lesion is not.
And so what about the two linear abrasions? What science, what comparative analysis, what evidence do you have that these are caused by teeth?
It's part of the pattern,
Of this whole pattern?
of this whole pattern.
But just like wound number one, independently, this doesn't tell you anything. You can't give an opinion to a reasonable degree of medical certainty that this was caused by a dog standing on its own.
By itself, it's consistent with, but yes, I cannot say by itself that it's caused by a dog.
Okay.
That
And
lesion by itself.
And there's nothing about these scratches that are consistent with the horseshoe shape of a nail of a dog, is there?
You mean the horseshoe shape of the jaw?
No, the
of
dog's nail, the dog's nails,
paw nail,
toenail,
toenail?
yeah.
There's nothing specific, no.
So again, to have any real opinion to a medical degree of certainty, you need to look at everything together. You cannot look at this and tell us any specific identifying feature that would support an opinion or conclusion to a degree of medical certainty it was caused by a dog bite or a dog scratch.
Mr. Brennan, that's the way medicine is. You know, in medicine, you don't just look at one complaint or one wound or one test and make a diagnosis. You usually need several supporting tests or other lesions to corroborate a diagnosis. So that's part of medicine.
So you would agree with my statement, what I just said?
Would you repeat it?
Of course. So there is nothing specific with regards to these three scratches in and of themselves, without looking at the entire arm. There's nothing about these three that you can say with specificity that supports an opinion that they were caused by a dog bite or a dog scratch.
I disagree. I think the combination of the punctate lesions right there and there, along with the linear parallel abrasions, supports that assessment.
Do you have any papers, any studies that show that a scratch like this, that would look like this, is a dog bite or a dog scratch based just on the appearance of these three scratches?
Just on the appearance, no. Usually the studies that I've read have pictures of multiple lesions, and in those pictures of multiple lesions, there may be lesions like this, individual lesions.
You can't tell, in your opinion, these are dog bites or dog scratches. So is there anything specific about them that can lead you to a reasonable conclusion, to a reasonable degree of medical certainty that these were caused by a dog? Putting aside the whole panoply of scratches, these here, what about them is unique and distinct?
Objection, Your Honor.
Just after what's been called round two.
What about them?
Okay, again, they're consistent with dog bites and scratches, and together with the overall picture of the numerous wounds, it paints a picture that makes me sure that this is from a dog attack.
Okay, I won't ask again, but I wasn't asking about the overall wounds. We're going to get to that. I was asking just about these three, but I'll leave your answer as it stands. Let's move to wound number 3. Now, wound number 3 really is a collection of scrapes, and you gave some testimony about the first two. So if we look at 1, 2, 3, 4, 5. So in wound 3, we have 5 larger abrasions on the top of the elbow. You see that?
I do.
And then you see a couple of dots down here. Yes?
Yes.
And I want to ask you some questions. And what I'll do, even though this is wound 3, I'll talk about scrape 1, 2, 3, 4, and 5, so we know what we're referring to. Is that fair?
Yes, but
Okay.
again, any one little tiny part of the component of the image or wound is, it's not going to be sufficient to make a diagnosis. I need the pattern.
You never recognized that in your voir dire testimony or in your trial testimony before the jury that you needed the collection of all abrasions to have an opinion. Instead, isn't it fair to say that you were talking about individual wounds as if they stood on their own.
I believe that
Objection, Your Honor.
Can you answer that? I'm gonna
that
allow
is
you to
unfair.
answer.
That's incorrect.
It wasn't until Mr. Alisi directed you that you started talking about dog attack and collection of wounds as a whole.
That is incorrect.
Okay, so looking at these wounds, wound number 3, and I know it may be a series of wounds, it might not be one wound in your opinion, but let's talk about this collection of abrasions, okay? Do you remember in the voir dire talking about this collection of abrasions and you were saying they were consistent with teeth or claw marks?
Okay,
Is that what you said at the voir dire?
I'd have to look again.
Okay, well, why don't we look at page 38, line 13?
Mine is gone. I don't have a board there.
Okay, we'll have to get you one.
Yes.
Thank you.
Thank you very much. Yes, it's 48, line 13.
What page?
That one's not right either. Nope. Okay. Well, let me withdraw that question. Did you testify previously that these are consistent with teeth or claw marks?
Did I testify when?
Previously.
Possibly, yes.
Okay. And do you have a different opinion today whether these are teeth or claw marks?
No.
So you think that these could either be teeth or claw marks?
I think they're more likely teeth marks.
Which one of these 5 do you think are teeth marks?
All of them.
You think all 3 are teeth marks? Do you think a dog bit Mr. O'Keefe and inflicted these at the same time or different times?
I believe that this was this configuration, this collection right
Yes.
here.
Yeah.
I believe this is one bite.
One bite. And so if we were to follow your theory, this was one bite, this would be the arc of the dog's mouth?
Yes, it could be.
Well, is there an arc here?
There appears to be.
Okay. And we know that when a dog punctures it, then from the top teeth pulls down, the bottom pulls up, right?
Push it.
So if this is the arc of the dog right here, and it's like a half of a sun or a half moon over the elbow, you claim these 2 dots are consistent with puncture wounds?
No, punctate lesions.
Oh, punctate lesions, I'm sorry. Which teeth, upper or lower teeth, do you think caused these 5?
I believe those were the upper teeth.
So you believe this is a canine on the left, number 1, and a canine on the right, number 5?
It could be.
Okay. Now, if here's the arc of the dog's mouth, and this is a canine on 1 and 5, where do the canines puncture and pull? Up or down?
I'm sorry, say that again.
Where do the canine teeth puncture? From the bottom or from the top?
So if these are, let me use my pointer here. If these are canines, and this could, by the way, be two, this also could be 2 separate bites. But if these are canines, they usually would start on the based on this picture, the upper or higher area and
Right.
pull down.
Right. They would have to start up and pull down if that was an arc of a mouth, wouldn't it? But you see the bottom of these wounds, right? The round part
Mhm.
that is closer to a puncture is on the bottom. Aren't they going in the wrong direction if this is the arc of the mouth?
No, I don't think that they are going in the wrong direction. You have to keep in mind that presumably Mr. O'Keefe was not standing there and letting the dog just chew on his arm. Okay, that there's
How do you know
relative
that?
move.
Objection, Your Honor.
How do you know that?
No, but she's not finishing her answer, Your Honor.
The question's allowed.
How do you know what he was doing?
Because it's normal human behavior that if you're,
How do you know what he was doing? How do you know what Mr. O'Keefe was doing that night?
again, it's normal human behavior to pull away from someone that's attacking you, a person or an animal. That's normal human behavior. If he was still throughout this whole attack, I would be looking for a different set of wounds.
You're speculating about all these comments about what he was doing and not doing. You have no idea what he was doing, do you?
I'm just
Objection, Your Honor.
The question, can you answer that question, Doctor?
I'm basing it on normal human behavior.
And so you would disagree with me that if these were dog bites, the part that's thicker, that is more similar, although not a puncture, would start at the bottom and work up, meaning the dog's head was over here on the top. You disagree with me about that?
Do I disagree?
Yes.
Yeah, I believe that that's
Okay.
incorrect.
And if these are canines, did you measure the distance between the canines?
Again, there's no ruler, but the other thing is we don't know what position his elbow was in at the time of this. So So it could be, although it looks like it's a larger, a larger configuration than a normal canine distance, into canine distance. That's what you're referring to, the into canine distance. If his arm was flexed, that distance would be shorter. So you cannot make any assessment based on this picture.
Do you notice the differences between the left mark and the right mark are a greater distance than wound number 1, where you said that it was 2 canines that caused these linear abrasions?
And there's no elbow between the linear abrasions of wound collection number 1. There's no elbow up here to be flexed.
Let me ask again, do you notice the difference between these two? It is wider than the difference between wound number 1 when you said it was 2 canines.
You mean this mark here versus this mark here? Is that what you're talking about?
Wound 3, number 1, number 5, where you said these could be canines. You notice the distance is different than the distance where you claim that wound 1 was caused by 2 canines. Do you notice the difference in distance?
Again, I'm not clear what you're asking me. Are you asking me the distance between this tooth and that tooth? I think what you're asking me is the intercanine distance. Is that what you're asking me about?
Intercanine distance, I've never heard that word.
Well,
is that a new one?
No, that's
Okay.
well known in medical literature.
Let's just look at simple math or size. The distance between these two wounds is a greater distance than what you said was canines in wound number 1, isn't it?
Again, I believe I just explained it, that if the elbow was flexed at the time that the wound was inflicted, or the bite was inflicted, you would get these two wounds that are closer to one another than they appear here, because the arm is partially extended here and skin moves.
Are you saying this is a full bite, puncture wound top and bottom?
Excuse me?
Are you saying this was a full bite of puncture wounds, bottom canines, top canines? Are you saying this is a full bite?
I don't believe this is not a full bite. There is no significant penetration of the skin. So this is not a full bite or a complete bite.
Did you say at trial, at the elbow, there's another different series of marks that again have linear abrasions up where the pointer is, and then down below some punctate, superficial round small abrasions, again representing upper and lower teeth, in my opinion. Was that your opinion at trial, that this represented upper and lower teeth?
Yes.
And these lower teeth, what teeth were these?
What teeth?
Yeah.
I don't know.
Were they like canines?
Could be a canine, could be incisors.
There we go. Thank you. And so your opinion at trial is these 4 could all be canines?
Which 4?
1, 2, and then the 2 punctures, or punctate.
That is a possibility. It is actually, and I think I said this too, that this could actually be a configuration of 2 separate bites. Where you have canine puncture wound, punctate lesion from so upper canines, lower canines, and then this could be a separate one. Just can't tell. There's not enough specificity in this configuration of wounds.
And you have nothing to compare it to either.
No.
Do you see the distance is different between what you said is a 4-set upper and lower canine and this one here, this canine? Do you see the obvious difference?
With all due respect, Mr. Brennan, again, the elbow moves, so the skin moves. The skin overlying the elbow moves, and we don't know the configuration that this arm was in at the time those wounds were inflicted. You cannot make a generalization.
I'm going to ask you one more time. You don't have to answer. Do you see the obvious distance between wound 1 and 3 where you say that it was the canines? Do you see that?
Objection, Your Honor.
So I'm going to strike the pad that says you don't need to answer. Can you answer that question, please, doctor? And then we'll move on, Mr. Brennan.
I see the difference, but I understand the difference.
Okay. If these were canine wounds, they can't be claw wounds, right?
Yes.
And based on your knowledge and study and whatever you're relying on, you have no way of telling if this is canines or claw.
Not 100%, correct?
Not even 100%. You don't have an opinion to a reasonable degree of medical certainty whether it's canines or claws, do you?
I believe those are canines.
Did you testify at the Lanigan hearing when Mr. Lisi was asking you questions? Did you observe any claw marks with regard to the injuries and you said it's possible?
Possible, yes.
How can you give an opinion to a reasonable degree of medical certainty it was canines and in the same breath and statement say, well, it's possibly claw wounds as well?
Objection, Your Honor.
My opinion about reasonable degree of medical certainty is about the whole arm, the configuration, the pattern of the whole arm, and not any one individual wound.
Wound 4 up here. What do you think this might be?
I don't know.
I'm not certain.
Well, I mean, in the totality of a dog attack, it has to be something related to a dog because we don't know that it was there before. Had to have been something, right?
It's probably related to the dog, yes.
Well, you don't think he just had this independent wound and then all these came from the dog attack and this one just happened to be hanging out waiting for them?
That's correct. I don't
Right.
think that he had a separate wound.
You don't think this one maybe was caused by the broken shards of glass from the taillight during an alleged collision, but the other ones were from something totally different? Do you?
No, because it has an orientation about it. It's oriented, again, in a somewhat vertical orientation, similar to many of these other sets of wounds.
I don't know what that means. It has a vertical orientation. How does that help us understand if this wound existed before or after the so-called dog attack?
It has some similarity of pattern.
So you think this was caused during the alleged dog attack?
Yes,
Okay. What caused this wound during the alleged dog attack?
I don't know.
Is that because there's no methodology or comparative standards, so you can't compare it to anything?
No, this because there's not enough specificity in that one particular wound all by itself.
What are the options? How could it have been caused during this dog attack?
By a tooth or
Okay.
or claw, most likely.
Could have been caused by the ground?
I doubt it, considering that, again, it's oriented in a similar fashion to the rest of the lesions.
Okay. When you read the background facts of this case, well, let me ask you, if a dog attacks an arm, it's going to create force on the arm, wouldn't it?
It depends on how much penetration. Yes, it depends on how strong the bite is, how much penetration, it gets through the clothing, clothing that's on, on the intervening, between the arm and the dog is going to present a little bit of a buffer.
Well, let's talk about the force on the arm. If this was a dog attack, as you claim, that means the teeth and or the claws penetrated that sweater and caused an abrasion on Mr. O'Keefe's arm, correct?
Yes,
So there had to be an amount of force pulling on the arm to create that friction, which led to the abrasion.
Yes.
Okay. Did you know from any of the facts that you reviewed that when Mr. O'Keefe supposedly left the car, he had a glass in his hand with a straw in the glass?
I'm aware that there was a glass in his hand.
And you're aware when he was found by the side of the road that glass, the broken part of the glass, was right near him with the straw?
I don't know anything about the straw, but yes,
And so if there's a dog attack and somebody's holding the glass,
uh-huh.
right, they're not likely to continue to hold on to the glass throughout the duration of the attack and then move somewhere else with that glass.
I don't know if he was holding onto the glass during the dog attack.
Well, hypothetically, assume that the evidence is he supposedly was holding the glass. Wouldn't a dog attack rip that out of his hand? Wouldn't he drop the glass?
There are many possibilities here. He could have transferred it to the other hand.
Let's look at wound number 5. Do you remember testifying about this?
Yes,
And you said it looks like an arch.
it does to
Okay.
me.
Are you saying the arch is on the top or on the bottom?
No, I thought the arch was on the bottom. By bottom, I mean more what we call proximal part of the arm. So right here is where I think the arch is.
And if this is an arch and these are dog bites, these would be the canines.
They could be. However, I can't rule out that this is, because of the curvature of the arm, I can't rule out that this was from a canine and incisor teeth.
Well, this is a different angle than here, right? But there's no flexion like in the elbow on this wound area. This is the bottom of the wrist, right?
That's correct. However, that part of the arm has a different configuration than the upper arm. And it's got a bone right underneath it.
So you're
The
saying,
ulnar bone.
I'm sorry, I didn't mean to interrupt you.
Oh, it's got the ulnar bone. So
Okay.
a wound to that area is going to look different than a similarly placed or caused wound to this area, which has a lot of padding underneath it from the soft tissue, subcutaneous tissue, and doesn't have the protuberance of this bone right here.
We have a distance problem when we compare these, don't we?
We have a what?
A distance problem. The distances are different. If these are canines, obviously it's a different dog or something else that caused it because the distances are clearly different, right?
Again, one has to know how wounds occur. And I didn't say that those are definitely 2 canine teeth on the periphery. I'm saying that I believe that this is a combination of canine and incisor teeth.
When a dog bites and tears, you see a missing tear pattern, don't you? You see the skin gets torn on many occasions?
Yes, but we don't have any of that here. We have no penetrating wounds here.
Right. Is it remarkable to you that if this was a dog bite with canines, there is no tearing of the skin? Is that remarkable to you?
No, because that dog was not able to create the force enough to penetrate the skin through that sweater.
Could I have exhibit 32, please? Okay. You've seen this picture before?
Yes,
Okay. And this is allegedly is a dog bite from Chloe?
yes,
And you see the tearing of the skin, don't you?
yes.
And you can see the corners where the incisors would penetrate through a puncture. Yes?
I'm not sure what teeth punctured this, but yes,
And
I see the skin is all penetrated.
This is consistent with the literature of a tear and a hold and a pull, right?
No,
Okay.
no, absolutely not.
This is not consistent with the dog biting and then pulling the skin.
This is consistent with an avulsion wound caused by a dog.
Very different wound than we looked at on Mr. O'Keefe's arm.
On
Mr. O'Keefe's arm, very different, right?
correct.
Okay. We can go back to T5, please. Now, your opinion that this is a dog attack.
Mhm.
Have you ever had peer review of this opinion with this photograph?
No,
No. You would agree that this dog bite science is what they call a soft science. Would you agree with that?
I don't know what you mean by that.
Okay, well, it's not like DNA. It's opinion-based. It's subjective-based, the science of dog bites, isn't it?
It's based on a lot of training.
Yeah, and a lot of subjective opinion too, wouldn't you say?
There's opinion here, yes.
Uncertainty,
There is some, yes.
right. And being that type of science, haven't you read in the studies about peer review, how peer review works?
What specifically are you?
That you have another qualified professional look at it and question and vet whatever opinions you're giving. Did you go through that process at all?
I've been through that process, yes.
You've been, okay, and who peer reviewed?
I mean,
findings?
this case?
Yes.
Oh, no, not this case. No, I thought that this information was rather confidential and I didn't share this
Okay.
information.
Well, you discussed with the defense other information in this case, didn't you, about the accident and about people's opinions? You've discussed that as part of your opinion, haven't you?
Yes,
Okay. Did you know that the U.S. Attorney's Office employed a deputy medical examiner to look at these bites? And then he had commented that the wounds of 2 to 3 millimeters up to 7 centimeters were documented on Mr. O'Keefe's right arm, and the injuries do not photographically appear to be, nor are described as puncture bite wounds, and thus are highly unlikely to be the result of an animal bite attack. Did you get that expert opinion from the United States Attorney's Office when they investigated this case to consider as part of peer review?
Objection, Your Honor.
no, I did not get that, but
Did you say you did get that?
no, I did not get that.
Oh, okay.
However, I have a comment about that.
Please.
Not very medical exam, not very many medical examiners have the experience that first of all, have experience with dog bites, seeing hundreds and thousands of dog bites and treating them. And not very many medical examiners have even autopsied a case of dog bites. So although, some physicians have certain opinions based on what they know, they don't have my experience. I'm
Do you
sorry.
know if Mr. Walsh had your experience or not?
I don't know who
The
is it?
gentleman who gave this opinion that was employed by the federal government, do you know if he had your experience or
What's
not?
his name?
Mr. Walsh,
No, I-
John Walsh.
No, I don't.
So he could have more experience for all you know.
Oh, I'm highly unlikely.
Okay, you have more experience than anybody in the country.
I think I have at least as much experience as any other possible person in the country. And I have it from both aspects, from the clinical aspect and from the forensic aspect.
Did you review the opinion of Dr. Kenneth Kinsey, who said that those injuries were not caused by a canine?
Dr. Who?
Kenneth Kinsey.
No.
No. If you look, I believe Mr. O'Keefe's arm were completely bent when he sustained the injuries. A lot of them match up. They're a continuation of another injury.
And I don't even know who Dr. Kinsey is.
Okay.
Is that
So-
a medical doctor?
So you don't have any peer review at all. You have nobody who's given an opinion similar to yours about this being dog bites, do you?
Is Dr. I'm sorry.
You have no peer review. You have no peer endorsement. Everything that you have no peer endorsement for any of your opinions, do you?
I didn't think I was allowed to show these pictures to anyone.
When you're giving opinions about the teeth and suggesting that there's might be bad things you don't really know about, you would agree it would be best to look at the dog, Chloe itself, right?
Not necessary.
If you looked at Chloe and examined Chloe, you would know whether or not there are any irregularities in Chloe's teeth, wouldn't you?
Yes, I might.
You would see it, wouldn't you?
Well, if I got close enough, and
Right.
I don't know if I want to get close enough to Chloe.
Well, why wouldn't you want to? You're a medical doctor. You want to be have an opinion to a degree of medical certainty, why wouldn't you want to see the best evidence of the distance between the teeth and Chloe? Why wouldn't you?
I'd have to make sure that I wasn't putting myself in danger.
Okay. And if you saw Chloe, you could see if there was any missing teeth, couldn't you?
Yes,
You could actually measure the canines in Chloe, and then you could compare them to what you're calling dog wounds on Mr. O'Keefe's arm. You could do that, couldn't you?
I would have to get a veterinarian
Mhm.
to sedate the patient, the dog, because going near that dog would be very dangerous. They'd have to sedate the dog to measure the intercanine distance.
What if you did get a veterinarian to sedate the dog,
Uh-huh.
and then you could safely go and look at Chloe, and you could actually take a mold of Chloe's mouth, right?
Mhm.
Yes? You've read that in the
One-
literature.
yeah,
The
one-
best
yeah,
way to
one could.
I'm sorry.
Yes.
Only one person.
You've read in the literature, the best way to compare the teeth and the mark is you actually do a mold of the dog's mouth. You know how valuable that can be in analysis, don't you?
It can be, but the question, I believe the question here is not which dog created these wounds, but did a dog create these wounds?
That's not my question. My question is, if you took a mold of Chloe's mouth, you would see the distance between the canines, and you could measure it, quantify it, not guess and speculate, quantify it, correct?
But Your Honor, could we approach, please?
Okay.
Thank you.
I'm gonna say this doctor, she is confident in her work, and I'm not mad at her. I really ain't.
You'd be able to tell the size of Chloe's jaw. You could measure it.
Possibly, yes.
You could determine the gape of Chloe's jaw, couldn't you?
I don't know what the gape of,
How it bites, how wide it opens up.
I'm not sure I could determine that.
Okay, you could look at Chloe's teeth.
As they are now, yes.
You could measure the distance between the canines if they still exist in Chloe's mouth.
Yes, from a model of, or an imprint from Chloe's mouth.
You could take a mold,
Right, a mold.
or you could take a tape measure or a ruler, and you could measure. You could
Oh,
do
that
both.
wouldn't be very reliable.
I see. You could determine whether or not she had one incisor, or whether she had 2, 3, 4, or 5, or 6 incisors.
Currently, yes, but I can't tell what the condition of the teeth were during the incident.
Uh-huh. You could tell if there's any missing teeth.
Correct.
You could look at Chloe's paws, couldn't you?
Yes.
You could do moldings of those and measure those as well, couldn't you?
I'm not sure that that would be useful.
Well, if
Measuring
you think that some of these wounds could have been scratches, you could look at the nails and the shape of the nails, couldn't you?
Well, nails are frequently cut on a regular
course.
basis, and the distance between the distance between the nails, as you mentioned earlier, can change depending on whether or not the paw is in a compressed state or a more relaxed state. So that wouldn't be reliable.
So you would not even consider measuring the paws because you think that would be unreliable?
I don't think it would be reliable. No.
You wouldn't study the toenails to see the shape of them?
If I could, I'd look to see if there's an abnormal toenail,
Right.
for instance. Yes.
And so there would be a benefit to doing that. You didn't do that though, did you? You didn't go see Chloe and take a mold of Chloe's mouth, did you?
It wasn't necessary.
Well, did you go up and take pictures or measure the teeth of Chloe?
No.
Did you ask to?
No. It was my understanding that Chloe was in another state, but again, I didn't think it was necessary, and I have reasons why I didn't think it was necessary.
You thought that Chloe was in another state. Did you ever discuss going to see Chloe and doing these studies on Chloe so you could see if they were dissimilar to these abrasions?
I was asked to evaluate the wounds.
Do you know that Chloe exists, that we provided notice to you, that we went up and saw Chloe and took molds? Did you know that?
Objection, Your Honor.
Did you know that was point allowed? Did you know that, doctor?
I do know that now. Yes.
Did you know that before you testified the last date in this case, that we actually went up and found Chloe and took molds and measured the paws and the teeth? Did you know that we did that?
I don't know. I don't recall.
Before you came in and testified the last hearing, you don't recall whether you knew that Chloe was available?
I believe I knew that there was a consultant, that you hired a consultant, and I didn't know what that consultant was going to be doing.
Okay. Now that you know that Chloe's available, wouldn't those molds be helpful? Wouldn't you want to look at them and compare them to the distances on the abrasions on Mr. O'Keefe's arm?
Objection, Your Honor.
I don't think it's necessary for many reasons.
If the distance of Chloe's canines is significantly different than these abrasions in this picture, you would agree that the abrasions in Mr. O'Keefe's arm could not have been caused by Chloe. Would you agree?
No, I wouldn't agree to that statement. Again, because of the various factors such as elasticity of the skin, shrinkage, There's various factors.
So if I understand, you have no interest in examining or seeing Chloe. It's irrelevant to your opinion?
I don't think I need to see Chloe.
Well, you said earlier when I asked you about particular wounds, it would be helpful to know these things about missing teeth and spacing and distance between the canines. Is that no longer helpful to your opinion?
No, I think you're mischaracterizing what I said. I believe I said that it would give information about the condition of the teeth now, but it wouldn't give information about the condition of the teeth when that incident happened.
In the spirit of medicine and science, isn't more information good?
Generally,
Generally. But you generally would not want to go see and examine Chloe.
I don't think it's necessary, and there's so many reasons why.
Okay. Thank you for your time.
Yes.
All right, Mr. Lessie, go right ahead.
If I could have you read the order
Sure.
of the exhibits, thank you, Your Honor. They're organized. I just wanted to make sure I have the records. Thank you, Mr. Brennan.
For the record, you have pre-marked number 33 through 37.
Thank you.
In Your Honor, and thank you, Mr. Sullivan. I have provided the court and offered to counsel, but counsel already had copies, a notebook that has exhibit numbers.
Thank you.
You're welcome. Mr. Brennan has agreed that all the exhibits in the notebook can be in evidence. So that's number 2. And so if I'm remembering correctly, Your Honor's previous direction that if they're in evidence, just refer to them as such. So that's what I
Yes.
plan on doing.
Yes.
And what I also plan on doing, Your Honor, is taking the exhibits that are in the notebook. I've got non-binder ones individually for the witness that are
Okay.
pre-marked. Does that work also?
Sure, you can just put them up on the stand with Dr. Russell.
In my approach to do that? May I talk to the witness and just point out where they are?
I think you can give them to her. I think
Okay.
she can figure out numerically what's what. All right, Mr. Leslie, I'm not rushing you at all, but is it safe to say that you won't finish in 20 minutes?
That is safe, Your Honor.
Okay, so we will plan on breaking at 1. Mr. Clerk will have to cancel our afternoon list. What, how long do you think it might take? And I'm not holding you to this, just curious.
I appreciate the question. If I can just have a quick moment, because I knew what my redirect was going to be until Mr. Brennan went, and I'd like to consider what he did. My best estimate is approximately 2 hours.
Okay, I'd like us to finish by 4 tonight.
Yes, Your Honor, understood.
Mr. Brennan, I know you have no idea how long recross might be, but we'll try and finish by 4 tonight.
Understood, Your Honor.
May I now proceed, Your Honor?
Please.
Thank you. Dr. Russell, during cross-examination at this Daubert hearing on December 12th, you were asked whether you believed you were an expert in the areas of orthopedics, accident reconstruction, biomechanics, motor vehicle accidents, and defensive wounds. In your 29 plus years of experience as an emergency medicine physician and training emergency medicine physicians, are you aware of any emergency room or emergency department physician being board certified in orthopedics?
No,
Are you aware of any emergency medicine physician being required to be an expert in overall orthopedics?
no. General orthopedics, no.
But do emergency medicine physicians nonetheless routinely evaluate and treat people injured in motor vehicle accidents?
Yes,
And did you, in your 29 years of experience as emergency medicine physician, routinely evaluate and treat people injured in motor vehicle accidents?
yes. I worked at a busy level 1 trauma center.
During your cross-examination in response to a question, you stated that you were an expert in emergency orthopedics. Can you please explain that?
Yes, so emergency orthopedics is a subset or just a part of the overall field of general orthopedics. So in emergency orthopedics, physicians care for, evaluate, diagnose, treat patients who have acute injuries and that don't need operative care. So acute fractures, acute dislocations, those types of injuries are done in many busy emergency rooms, right in the emergency room. And that's what I have expertise in.
Did the rotation at you just said busy hospital that you were at, did the rotation when you were training, were you required to take a part of the training in emergency orthopedics?
I was required to take a 1-month rotation in orthopedics.
Now, you were asked during cross-examination at this voir dire about one particular specialized training that you had involving motor vehicle accidents, and you, in response to a question from Mr. Brennan, agreed that that particular course was rudimentary. Do you recall that?
Yes.
When did you take that course that you referred to as rudimentary?
It was around 1979.
And what profession did you have when you took this rudimentary course that you were asked about?
I was a police officer at that time.
And since that one rudimentary course that you had, have you had further training with regard and experience to humans injured in motor vehicle accidents?
Yes, much.
And describe the experience and training you've had in that area.
Well, during my 29 years working in the emergency department, we saw motor vehicle accident victims on every shift. And usually there were multiple victims on every shift. So that was part of it. Plus we had lectures and seminars on motor vehicle accidents, victims.
And is your focus in your testimony, both in June of this year and in December of this year, on wounds from motor vehicle accidents or how motor vehicle accidents occur?
So as a physician, my focus is on the wounds and injuries caused by motor vehicle accidents and how to diagnose and treat them.
So are you sitting as a medical doctor giving opinions on medical causation of the injuries to Mr. O'Keefe?
Yes.
During cross-examination, in this hearing, you were asked about whether you were an expert in accident reconstruction. Is being an expert in accident reconstruction necessary to practice emergency medicine?
No.
Does an emergency medicine physician need to be an expert in accident reconstruction to evaluate and treat people injured in motor vehicle accidents in the emergency department?
No.
In your 29 years experience as an emergency medicine physician and training emergency medicine physicians, are you aware of any emergency medicine physician being an expert in accident reconstruction?
No.
Is accident reconstruction even relevant to the practice of emergency medicine?
No.
Is whether an emergency medicine physician and expert in accident reconstruction a reasoned question in the field of emergency medicine?
No.
During cross-examination in this hearing, you were also asked about whether you have a degree in biomechanics. In your 29 years experience as an emergency medicine physician and training emergency medicine physicians, are you aware of any emergency medicine physician who is an expert in biomechanics?
No.
Is being an expert in biomechanics necessary to practice emergency medicine?
No.
Is whether an emergency medicine physician is an expert in the field of biomechanics a reasoned question in the field of emergency medicine?
No.
In your 29 years of experience as a medical doctor, where do most people go for the treatment of acute injuries from motor vehicle accidents?
To the emergency department.
Do you know, or have you had any experience where a person who has an acute injury from a motor vehicle accident goes to an expert in biomechanics?
No.
Do you know whether anybody who's injured in a motor vehicle accident, acute injury, goes to an expert in accident reconstruction?
No.
On cross in this hearing, you were asked about your expertise in, quote, self-defense. Was your direct testimony in this hearing in your report of December 9 about self-defense or defensive wounds?
Could you repeat that question?
Sure. Was your direct testimony in this hearing in December and the report that you prepared dated December 9th, was that about self-defense or defensive wounds?
My testimony was about defensive wounds, not self-defense.
What's the difference between self-defense and defensive wounds?
Well, I believe self-defense is something like martial arts and the study and techniques of defending oneself from an attack. That's what I believe self-defense is.
You were also asked on cross in this hearing about whether not observing how a wound to the posterior side of a forearm occurred provided you with sufficient context to determine whether a wound was a defensive wound. What context did you have with regard to the wounds on the right arm of the decedent to reach your conclusion that those wounds were defensive wounds?
Well, the context is the configuration, the location of the wounds, and the presence of a dog.
In the cross in this hearing, you've been asked whether you have observed how wounds are created. In your experience, do emergency physicians or forensic pathologists get to observe how wounds are created?
No.
Do emergency medicine physicians and forensic pathologists nonetheless often reach medical diagnostic conclusions without observing how the wounds are created?
Yes, they do.
And is that a common or uncommon practice for emergency medicine physicians?
Well, that's common.
How common?
I think it's fairly common.
You were also asked whether someone could, and this is on cross in this hearing, whether someone could incur wounds to the posterior side of the forearm if they fall to the ground backwards. Did the wounds to the right arm of the decedent in this case arise from him falling to the ground backwards?
No.
Why not?
Because of the configuration and the pattern of the wounds.
And do you come to that conclusion to a reasonable degree of medical certainty?
Yes.
You were also asked on cross in this hearing about when someone hits a moving or a floating object, whether the patterns are dynamic and changing all the time, and the hitting concept. Can you please explain the question that was posed to you about moving, floating objects and hitting objects and how you evaluated those issues with respect to the decedent in this case?
I'm sorry, I don't understand the question.
Doctor, did you understand the question?
Not exactly.
Okay, ask the question differently.
On cross, you were asked about when someone hits a moving or floating object, whether the patterns are dynamic or change. Can you please explain those concepts in that question and how you analyze them with regard to the wounds of the decedent in this case?
Okay. When there is movement and there is contact, there is movement of the, for lack of a better word, inflicting object, such as a tooth or something else. There is movement along the skin during the period of time in which they are in contact. That's what I understood that I was being asked.
On cross-examination, you were asked several questions about pattern recognition and pattern recognition methodology. And you were asked about the development, that's what I want to start with, of your pattern recognition skills with regard to dog-inflicted wounds. How did you develop your pattern recognition skills with regard to dog-inflicted wounds on humans?
Well, as I testified earlier, I've seen many, many, many dog bite victims. And sometimes I was able to talk to, I closely examined their wounds. And not only examined, but evaluated, treated. But in many cases, I was also able to talk to them and ask them about how the wounds were inflicted. And I did this over and over and over again, hundreds of times. I think I testified about at least 500 times over the years. So as you do that, you learn. You know, you recognize, you get sharper. So that's how I did.
And did you also edit any peer-reviewed publications that were relevant to pattern recognition and pattern recognition methodology?
Yes, I did. Now, pattern recognition in general, first of all, pattern recognition in general is a really important feature of medicine. It's critical. It's so important. And we start learning pattern recognition from medical school, from the beginning of medical school, learning how to recognize patterns of cells in pap smears and biopsies, patterns of cells. That's what a lot of pathology is, pattern recognition. And so, and even radiologists use pattern recognition when they look at x-rays of pneumonia, for instance. Different pneumonias have different patterns. So pattern recognition is something that I've been doing since, beginning of medical school, and actually a little bit before medical school. So that was 50 years ago, I think. 40 years
Is
ago.
pattern
40 years ago.
recognition some novel or unscientific process, or is it rooted in evidence-based medical science?
Oh, it's definitely evidence-based medical science. And in fact, there are textbooks on how to recognize certain patterns. So there, for instance, in pathology and, in medicine, there are textbooks on how to tell if somebody's got liver cancer or somebody's got, some other disease. This is pattern recognition for the most part. And x-rays too. It's in textbooks. There are huge textbooks and numerous textbooks written about this.
Is pattern recognition methodology that you've been testifying about, is that generally accepted in the medical community?
Pattern recognition as a methodology? Absolutely.
All right, Mr. Leslie, we're going to take our break. We'll be back at 2 o'clock.
Thank you.
All right, good morning, please.
All right, y'all, people. So I'm late. I had to put the baby to sleep, y'all. She done fell asleep in my lap. Okay. So it looks like we're done for the day. We got done kind of early. I know that we wanted to also watch the hearing. I don't know, we kind of bouncing back, but I know that we wanted to watch the hearing for a lot of people wanted to see the hearing where the prosecutor was recused from the YNW Melly trial. So somebody shared that with me. I want to say it was Starfish. She may not be in here right now. But she shared that with me. And we're gonna see. Oh, wait a minute. We might be able to check that out while we break. Got to keep my people. Oh, should I've been talking to myself? Did y'all hear anything that I said? Looked like I was on mute. I'm gonna stop the share for a second. All right, so I'm looking for the post that was shared with me. Okay, good. All right, so we're gonna pull up the day. So I got a question for y'all. Do y'all want to skip down to where she actually on the stand, or do y'all want to watch the entire thing? I know Karen's gonna pop back on here in a little bit, but oh, let me share. Because we could jump straight to them putting her on the stand, or we could watch, we can hear them talk about it a little bit. I don't know. I haven't seen it. So I low key want to watch it. Yeah, we just gonna watch it because we don't want to miss nothing.
Good morning.
Good morning. Sorry I said that, I'm sorry. I will be resisting. Give us 3 minutes to talk that time. Sure, we're resisting. Ms. Henderson.
Judge.
Good morning. State your appearance.
Good morning, Your Honor. Stephen Klinger, and Cole Bloom, Samantha Rosen on behalf of the state.
Where's Brad?
I'm Bradley Cutter.
She's not joining us today?
No.
She going to be on the case in the future or not?
Yes.
She is?
Yes.
That's your anticipation?
Yes, sir.
All right.
I'm not told anything contrary.
I'm sorry?
I'm not to the contrary.
Thank you. So this is a couple of motions. I guess there's two of them. First one has to do with the squash.
Right, we filed our motion to recuse. You sent down for a hearing. We tried to subpoena witnesses for today's hearing. The state would not accept it with your rendition of what happened. It's close enough to what we believe happened that we no objection to it. We did not get proper service. We couldn't. You set the hearing on Wednesday. We did everything that we could humanly do to get witnesses here today. We let the state know who those witnesses would be, but the fact that the class server just dropped off the end of what we couldn't get proper service. So their motion to quash is probably well taken because we did not get proper service. But all we're trying to do is move this case along. All we're trying to do is have a hearing and have a witness before you. I probably need the help of this court to order the witnesses to show. I don't know what else to do.
Well, Your Honor, at this point, I don't know where they're going to get the authority issues. Because they're supposed to provide they feel they're not getting all the discovery that they need, they need to come to the court and get the court to give them an order that they can get further discovery. And then they might be able to move into the realm of issuing subpoena or trial, or hearing. And that is, maybe I'm not having enough, maybe I have, but I don't believe that there's any motion made in the asset justice requires further discovery to be granted by the court. So, very scarred to begin with. I'm not sure where all that the scheme that wants to investigate is coming from. They've been given the basics, they know what the alleged rates they can this. I think they need to come to this court and ask, we open the court, bring discovery, and let the court know they're not getting what they want before they can go ahead and issue subpoena.
First of all, I just want to point out, this was not a subpoena for a discovery deposition. This was a subpoena for them to show up to court today, so you could have a hearing that you set, so that we can have witnesses for this hearing. Had nothing to do with discovery, it was for attendance at this hearing. We were going to deal with the discovery issue separately, we're happy to deal with it right now. But that's a separate issue than having witnesses to testify before this court, when this court sets a hearing.
And just, there's a little more to it. We filed a response to the motion filed. And I'm sure by now your honors are familiar with it. And in that document, we cite the specific provisions of 3.220, which have provisions for just this very thing, that the time limits can be altered by the court for good cause. What could be more good cause than the honors of response setting a hearing for Friday, that speedy trial is running, that we've just become aware of what we think is a major transgression by the lead officer in the case, that we have 4 different Brady notices that are all different, that this happened in October of 22, and the state attorney's office sat on it through a whole trial, and up till a couple of weeks ago, when we received these Brady notices.
Can I just stop you for a second?
Sure.
In your response, this is the motion that defendant Mel Devin responded to state's motion to quash subpoenas and or for protective order. Paragraph 4, you indicated here that counsel for the defendant believes that there is probable cause that the witnesses under subpoena, the members of the state attorney office, the elected state attorney, to have committed obstruction of justice and attempted witness tampering and felony pursuant to FS 838.022 for misuse of public office due to their actions since October of 2022.
That's what it says, John.
That's right. Very serious allegation.
Very serious allegation, very serious, we believe, alleged conduct.
I want to know what the good faith basis that you have is for to make that statement.
Filed in the court file is the deposition of Michelle Boucher, which chronologically testified to what happened since October of 22, and who was involved and who had knowledge of what happened after, on the very day this happened, Ms. Boutros went to Mr. Keller and told him what Detective already did, and went to administration, to Harold Pryor, and told him on that very day what happened. And they sat for 11 and a half months, where a whole trial took place, where hundreds of thousands of dollars in legal fees were spent without knowing this absolutely vile impeachment evidence that is clearly Brady for a year. So they had meetings about it, and we were trying to ferret out, because your Honor says, what's our good faith basis? What a career prosecutor in the public corruption unit of the state attorney's office testified to under oath. And number 1, Miramar Police Department was made aware of it. Number 2, the head elected state attorney was made aware of it. Number 3, all of his minions that are involved in are subpoenaing them, we believe were made aware of it. And if you look at all that and track the statute we cited, the conduct that we believe happened, and we have to ferret it out with depositions that they're avoiding and everything because of a 5-day rule, is where we're going to be able to prove what our good faith basis is, because we have absolute good faith basis for it. And we'll stand on that based on Michelle Boutros' statement under oath testifying about this.
Do you have anything other than that statement of Boutros in the deposition?
Not yet. That's why we want to take the discovery of these individuals. What else could I have? If they deep six this,
That's what I'm asking you.
no, Judge, that is the starting point of where we need to go. And in order to develop it at this very late date that we just found out about this activity, the only way to do it is to subpoena these witnesses that do not have work product protection. And they shouldn't have a 5-day rule protection. That's fair enough. Maybe there's an explanation. I couldn't, in my wildest dreams, think of what it could be. Maybe they should get their own lawyer. Maybe they should take the fifth, but we need to ferret it out. Because what more should we have before Your Honor than a sworn testimony from a career prosecutor in the public corruption unit who testified to certain activities of not only herself, but Mr. Killen, Ms. Bradley, and everything else. And I do have other evidence. If you look at the how many, Bradley? The four Brady notices, that they all contradict each other. And one of them was signed by Mr. Keller, who's not even the lawyer in this case. He's the public corruption prosecutor. And he stepped in and signed a Brady notice in a case where Ms. Bradley didn't. And then she came in and switched her testimony in the next one. What could be more compelling a good faith basis than to show the actual prosecutor on this case, the homicide prosecutor that tried the first case without telling us anything about Moretti, is now changing her story 3-4 times. But this happened in October 22, so that's additional good faith basis for us to find out how and why we believe there's probable cause to believe they violated the law. If you look at the statute, the specific paragraphs cover contact just like this, just like they used to try to allege that Mr. Devins did witness tampering. They did the same thing. And we're going to prove it by having these people testify. We'd like to take their depots. We filed papers to try to do that in the last couple of days after Your Honor said it, but we haven't yet. So we want to have them testify in court today.
If your motion indicates, or your response indicates, that the elected state attorney committed obstruction of justice, attempted witness tampering, and a felony pursuant to 838.
Absolutely.
State attorney.
Absolutely, the state attorney, the elected official, Harold Pryor, we have good faith belief that he sat on this.
Well, you're more than that. You're saying you have probable cause.
I think there may be probable cause based on.
I think there may be probable cause.
Judge, if you quibble over this, you can do that.
I'm quibbling over. This is a serious allegation.
This is a serious matter.
That's right.
This is an absolute serious matter
I
that
agree
everybody
100%
sat on and hid under the carpet for a year.
I don't know that everybody did, but
You don't know? So why are you asking me why I'm doing it? Because we allege it and we need to ferret it out, Your Honor. And it is a serious, but because it's serious, you don't think that Mr. Devins sitting over there isn't thinking this is a serious matter where his life is on the line, where the state attorney's office.
serious charge too. I'm not minimizing.
It's not two. That's why we're here, Your Honor. With all due respect.
All due respect, it's a serious matter, but so is allegations about corruption in the state attorney's office at the highest point. And when I read Ms. Boudreaux's deposition, somebody provided it to me, and I assumed it was your office. I don't know if you did or not, who gave it to me, but somebody dropped a statement off. I thought Ms. Boudreaux, who I know for a long time, tried many cases with her, indicated that the state attorney's office told her to be honest, straightforward, tell the truth.
So why wouldn't you believe testimony like that that says that Mr. Pryor knew about it the day it happened and didn't do anything about it? There wasn't any investigation by the very unit that investigates stuff like this, like the public corruption unit. That killer sat on it because he knew about it the very day for over a year. Watching a first-degree murder case be tried without even investigating further this allegation. You know, there's a lot of things that trained police officers can do and investigate things such as an allegation like this, and they did nothing. And we're going to be able to, once we get them to testify, show that nothing was done. And they deep six this serious allegation in a first-degree murder case, and there's testimony when they told her to tell the truth. And you know her for a long time. I know her for a long time. We've had battles in court against each other and walked out and shake each other's hand because she's a professional. And she testified that Harold Pryor, the elected state attorney, knew about this the very day it happened. And nothing ever was revealed about it until the last couple of weeks. If this court doesn't think that's important and isn't
I think it's very
possible.
important. I think everything in that deposition is important. But I also thought Ms. Boudreaux indicated that it wasn't the position of the state attorney's office or the Mr. Pryor or the individual supervisors to go ahead and review what was done by whoever's involved in the case, that they anticipate and expect that the prosecutor handling it should do whatever Brady notices around.
Well, let's find out, Judge. That's why we're here.
Wasn't that in the deposition on mine? I mean, that's what she said, correct?
She said what office policy is.
Correct.
I thought that they were told they couldn't testify about, so they cherry pick and choose which office policy they'll reveal. But she indicated in the same memo, she was told not to talk about office policy, but she did. So we got to figure this out. Whether or not, if that happens or not, when there is an allegation against a lead detective in a first-degree murder that he lied in front of a career prosecutor that's brought to the attention of the elected official, they can't hide under, oh, we don't review every Brady violation. This went all the way to the top of their office the day it happened, and they did nothing, I believe. And I believe that violates that statute. And I believe that in and of itself, based on one person's sworn testimony, is probable cause. But, Your Honor,
I believe, based on your body language, with your arms crossed and a scowl on your face, looking at us like we did something wrong, should be much more.
This is really serious.
This is so serious. Why do you think we're all here? Why do you think this has blown up like this? Not because we did something for a year. It's because the state attorney's office and Mr. Pryor, who directs the office, who was elected by the people of Broward County to do justice, not to win cases at all costs. We believe knew about it and participated in the conspiracy to hide it. And that's what we believe, and that's what we pled, and we stand behind our plea.
Thank you. Where's Miss Bradley? I don't understand why she's not here.
I believe she has a deposition. Folks, everything's going to have depositions. And you don't have it scheduled, so you have to plan. It's not that you don't, I'm sure, have other matters that you have to handle.
This is an issue where the way I understand the theory of defendant's theory is that Ms. Bradley is going to become a witness in the case. That they believe that depending on what is said by Detective Moretti, that if there's evidence that based on a flip-flop in the Brady notices, if they come back and they want to use Ms. Bradley to impeach her, to impeach Mr. Detective Moretti during the trial, that they have good faith basis to call her as a witness in the case. So how am I supposed to let an assistant state attorney stay on the case if she's a hostile witness?
You know, this is all moved way past the way normal Brady issues would be handled. Right? So if some Brady, possibly many Brady issues come to light, what happened? Well, if you don't know what it is, you just think that the defense just thinks that there's something out there they don't know what it is. It falls back that the state has its obligation to notify a Brady if they feel, and if they don't, and eventually it comes out that it really truly was Brady, and you get out a new trial, or they notify the appellate court. This is an in general. If, however, they've got more specific indication of what the Brady could be, they can come to the court, give the materials to the court, look it over in camera, make a decision as to whether there needs to be a further investigation.
Typically, what I do when I have a Brady, there's some issue about it, the prosecutor who's involved in it tells me, she comes in here, she's got an obligation of candor to the court, and I ask her a question, and she advises me as to what's going on and why there's a change, why something like that. But she's not here. This is her case. We spent 2 or 3 months trying the case originally. It came to a hung jury, but she's not here for this. I don't understand that. Forgive me, I don't understand it. It's her case. She's supposed to be here. These allegations are very serious, and they include her, include allegations of her, and I don't see her in the courtroom.
Well, I can explain it. The court wants her here as the lead counsel and on the case.
I would think she'd want to be here.
Pardon?
I would think she'd want to be here.
Well, having been issued subpoenas, I think there's more of it makes it different versus her just being here and versus the lead prosecutor.
How is it? How does it make it there? She's the one who signed 3 different Brady notices, and they're different. How is that she doesn't think she should be here for this hearing? When they're asking to recuse her, as well as your office from the trying the case, and she's not here. Forgive me, I don't understand it. Why don't you find out where she's at? Make a phone call. We'll take a recess. Make a phone call, find out where she's at. I don't understand it.
Oh, baby. How did we miss it? Good God Almighty.
Good morning. I would thought you'd been here, but regardless, I didn't want to go any further without you being here because it's always something about your credibility, your integrity, and everything else. So I thought you needed to be here.
Understand?
All right. So let's go forward with this hearing. You call witnesses.
Rather than the call witnesses,
Call your first witness.
I was hoping, first of all, I don't know if all my witnesses are here because I tried to subpoena witnesses, the state wouldn't accept it, so I don't know who's here as witnesses. I know right now that Ms. Boutros is sitting in the courtroom. I don't know if she's well enough or feels well enough to testify. I'm certainly hoping that she does for my purpose, but more for her purpose, that I hope she's really good. And if she is available, I'd like to call her as a witness.
Ms. Boutros, is
I'm
that
okay.
why you're here?
Yes, sir.
Come on up. You okay?
I am. I'm okay. Thank you.
She's here. Something Washington. Defense, right, there's any motion for Washington. Basically said they agree with the motion, that's the way I understood it, that they served incorrectly. So the motion quash is granted. This Boudreaux, excuse me, Ms. Boudreaux is here, and my understanding she's willing to testify. So if they want to put her on and call her as a witness, they can. All right.
Your Honor, I would just like the clarification. What we acknowledged was we could not get proper service because of the timing.
If I misstated that, that's what I understood you said, that you agreed in principle that the procedure wasn't followed because it wasn't enough time. But you agreed with them that the idea was that the motion technically should be granted. That's the way I understood it.
We're on the same page, exactly. But the bottom line is we're going to need the court's assistance to get on the witnesses if we're going to complete this hearing.
Thank you. So, you want to swear in the witness, please?
We'd like to invoke the rule, because Christine Bradley is one of the witnesses. So we got a problem. And
They call her first.
I'd rather not, Your Honor.
we can't call it first, because we have to establish certain things on the record before we call.
Your Honor, I was expecting to call her last.
Without her having the opportunity to hear the other witnesses, because we feel a threat to the the rules provide that we're not going to.
The rules provide for what?
Another witness in proceeding should not be present when another witness testifies.
And Ms. Boudreaux, you step down, then you call Ms. Bradley first. You call her first.
Because we don't want to call her first, because we have to establish.
I don't want to excuse Ms. Bradley. She's here. She's her integrity in question. She's the one that's on.
And you're giving the state an unfair,
I'm sorry. I didn't hear that.
you're giving the state an unfair advantage to have the subject matter of this proceeding here, testify first before we establish all of the other evidence from the other witnesses. And certain evidence from those witnesses will be absolute subject matter for the testimony of Ms. Bradley, because she's the one that is the subject matter. So if we do it in that order, then we're not going to be able to have all of the evidence that we believe shows why this prosecutor, Ms. Bradley, should be recused. So if we let her go first, then we can't adequately cross-examine her or represent Mr. Demings with adequacy, because we don't have all of those things necessary. So in that, just in the very issue of order, prejudice is the defendant, and it gives the state an undue advantage. And, I don't want to go belabor the motion to quash, but we have evidence that Ms. Bradley told us she's not coordinating depositions, and we have to subpoena the witnesses for a hearing on Friday, and this was offered when she knew already that Your Honor had set a motion for Friday, and it was less than 5 days, and then the same law, this one thing said, oh, it's less than 5 days, you can't have everybody else. This is not the way to carry out justice. And having them testify first isn't fine.
As far as the email we're talking about, that's a deposition, well, not. We don't just, no, we're not going to coordinate this, but we'll, what's that? That's, you'll accept more service. Bring him over, more service, then it's within the time period. We're thinking, no one was ever saying we're not going to accept any of those emails. And those quantities are.
I'm not talking about that. I'm talking about counsel suggesting that Ms. Bradley should be waiting outside.
I don't think Ms. Bradley should testify. Ms. Bradley's not she should not be, you don't should be allowed to go into work product or opinion evidence or her thinking on a case. I see absolutely no reason for her to be taking statements like that.
We will not, sorry, I didn't mean to do that.
This is a discrete issue. It's not talking about her mental impressions or how she would try the case or anything like that. They're not going to work properly. They're not going to ask questions regarding that. If you do, I'm sure you're going to object, and I'll sustain those objections. This is a discrete issue. It has to do with the notice of the proceeding.
But at this point, I think if we're bringing the part before the court, and we're seeing to get to the whole Brady issue and skipping over everything else. The only thing on the docket for today was the disqualification of the state attorney office and whether they have shown actual certification. And that motion should be, as I argued in the response, like, denied. That's what was on the docket for today. We haven't made it to Brady yet. We haven't, let it ring on what Ms. Bradley may have done or not done, or disclosed or not disclosed. That's all pivoting off the Brady issue. And we're not ignoring that's not on the docket for today. And look, in those four
this is my concern. This is my concern. I don't disagree that prejudice has to be shown.
All right, y'all. Karen Reed is back. So Taylor Gang is wanting to watch the live viewing of this. We'll come back to the recusal. I'll make another post if you're watching from Twitter. I'll make another post when we switch back. That's what you are here to see.
In conclusion, to identify a lesion as a dog bite wound, it should have ragged and irregular wound edges, show multiple parallel linear scratches or drying scuff abrasions, include a puncture wound and sometimes an avulsion with irregular borders resembling a dental arch print.
And could you please, as the last paragraph we'll focus on, read what you consider important in the next paragraph?
The shape of dog bite wounds depends on the size and breed of the dog and will differ whether or not the full dentition was used to produce them.
Let's stop there. What does it mean to you when the author says, and will differ whether or not the full dentition was used to produce them?
So what that means is that if the bite does not include the full, well, let me back up. What it means is the appearance of the bite will vary depending on whether or not all of the teeth impacted the skin or just some of the teeth impacted the skin.
Please read the next sentence.
Only in ideal circumstances will a complete impression of all frontal teeth be found, and often only a prominent canine impression can be seen.
Is what you just read relevant at all to what you analyzed with regard to the wounds of the decedent in this case?
Very relevant.
How?
Because many of those wounds on Mr. O'Keefe's arm were only partial bites. They did not have the complete dentition.
Do you recall Mr. Brennan saying various times that you have no support for your pattern recognition methodology?
Yes.
Is this support for your pattern recognition methodology?
Yes.
Is it direct support for the pattern recognition methodology you have applied in this case?
Yes.
Is there another article? You mentioned two, you mentioned Munich and Pollock. So let's turn to, and Your Honor, this will be the second and last article.
Okay.
Please turn to Exhibit 34. And is this the Pollock, P-O-L-L-A-K, study that you have mentioned multiple times in your testimony and that's in your report?
Yes.
Please, like we just did with the Munich article, please identify the portions of this study that support, you've testified, support your pattern recognition methodology.
Okay.
And let's
Well,
do
start in
a
the beginning.
seriatim from the beginning.
Yeah,
Yes,
I'll do it
please.
from the beginning. So the dog's front, so the first paragraph here.
Okay, the summary?
Yeah, this says summary. Yes, summary. In the absence of her parents, a girl of 4 months was killed by a 2-year-old male Rottweiler dog belonging to the same family. The dog's front teeth marks of individual circular or scratch-like abrasions, as well as slit-like skin severances of the skin, arranged in curved lines. There seems to be a word or two missing.
No, you missed a word. That's
I
okay.
did.
That's
Yes.
okay, go ahead.
Okay. The pattern of skin lesions largely corresponded to the anatomy of the dog's set of teeth.
Let's stop there. How does the sentence you just read, what's the key component of that sentence that supports your pattern recognition methodology?
That sentence, the pattern of skin lesions.
Now let's go down to the keywords. Is there anything in the keywords that supports and roots your opinion that you've given several times that there's in dog bite wounds on humans, there's a pattern?
Yes, so there's about five or so keywords. One of them is injury pattern.
Why is there a section in many medical studies of key words?
So when you're researching, you can find the articles quickly.
And is there any importance to the use of keywords when there is a study published?
Well, yes, because it's a key concept of the paper.
Please proceed to and I know it may take a little bit of time, and with the court's permission, to the next section of this article that supports your opinion that there is a pattern to dog bite wounds on humans, and that there's a pattern recognition methodology used to discern them.
Well, I think the next significant section would be 3.2,
And what is the title of that section?
morphology of dog bite injuries.
What does morphology mean in the medical community?
Basically means form.
And could it mean something in addition to form?
Form, pattern, appearance, yes.
So with regard to morphology section, please identify the sections, the parts of the article under this section that you believe, that you have concluded support your opinion of both the existence of patterns and a pattern recognition methodology with respect to dog-inflicted wounds.
Well, I go to the second paragraph.
Please read that.
Okay. The bite mark on the skin is ideally a complete and congruent imprint of the front dental arch. Sometimes only the protruding canine teeth are imprinted. If the shorter incisors also leave an impression, smaller skin lesions, round pressure marks, or streaky glide marks can be found between the impact points of the canines. In practice, it is hardly expected that all 6 incisors of a jaw will act uniformly. A gap in the injury pattern can have several causes: oblique biting, curvature of the body surface, interposition of textiles.
What does that mean? I'm going to stop you. What is interposition of textiles in layperson speak, and how, if at all, is that relevant to this case?
It's clothing overlying the area that was bitten.
And was there clothing overlying the bite mark wounds of the deceased?
Yes,
And what clothing specifically was that?
it was a hoodie type switch.
Please continue reading.
Okay, interposition of textiles, different tooth lengths, tooth loss, form and positional anomalies of the teeth.
And keep reading, please.
On the next page,
Yes.
the spectrum of possible injury forms is extremely diverse. Depending on the type and intensity of local tissue damage, skin contusions with epithelial loss, linear abrasions, tears and/or crush wounds, as well as puncture-like lesions can be distinguished.
Thank you. So do these studies directly or indirectly support your opinions in this case that there's both a pattern to dog bite wounds on humans and that there is a pattern recognition methodology to discern them?
They do.
And is it direct or indirect support, these studies?
I believe this is direct.
And do you believe it's robust, these studies, or do you believe there's equivocation with regard to pathognomonic features?
No, I think it's robust, and these articles are cited elsewhere.
And are these articles, particularly the Munich article, is the citation ubiquitous in the medical literature, or is it sporadic? Are there a lot of citations to Munich in the medical literature, or are there only a few?
There are quite a few.
And do you recall the book that Mr. Brennan showed to you earlier on in the hearing?
Yes.
Does that book cite to Munich as support for a section in the book?
It does.
Now, there was confusion. You can put those studies to the side for now, Dr. Russell. Thank you. Now, there was some confusion on cross-examination regarding where these articles could be found. Some were looking for them in your CV. I'm sorry, Mr. Brown.
All right, so I'll strike that part of it. Just go ahead without commentary and just ask the question, please.
Yes.
Redirect.
Sure, I will, Your Honor. Where are the references? Well, are the references to these articles in your CV, or are the references to these articles in your report?
In my report.
During cross-examination, it was stated that you, quote, suggested that you came to your pattern recognition skills because of communication difficulties or because people couldn't share with you or report to you the cause of the wound. Is that an accurate statement about how you develop your pattern recognition skills?
I don't know where that statement comes from.
I'm happy to provide it, or I could read
So
it.
let's strike that first part of it.
Okay.
And just ask the question, please. Again, this is redirect, it's not cross-examination.
Understood. Yes, understood. Thank you. Have you ever suggested that you came to pattern recognition skills because of communication difficulties or because people wouldn't share with you or report to you the cause of a wound?
No.
Would that be an accurate statement at all about how you develop pattern recognition skills?
No.
And why is that not accurate?
Because pattern recognition skills are again taught in various subjects in medical school. And I actually started even before medical school, but in medical school, they're taught in various subjects and in internship and residency. And that was long before I started interviewing patients, with the dog bites of unknown etiology.
Is pattern recognition common or uncommon in the practice of medicine?
Very common.
Can you please give some examples of pattern recognition and the use of pattern recognition methodology in the practice of medicine?
So I think she already did this before the break, right, doctor?
I mentioned it earlier with pathology, looking at biopsies.
Oh, I'm sorry, Dr. Rizzo. This is about you, and so you've heard it, and I'm going to move on.
Thank you.
You're welcome. I'm going to move on to a different section. You have been asked on cross about whether in your emergency department experiences, well, let me rephrase that. In your emergency department experiences with dog-inflicted wounds, have you ever gone to see the dog in question?
No.
Do emergency medicine physicians need to go see the particular dog or any dog in question to determine whether a wound is from a dog as opposed to some other cause?
No.
Do you, Dr. Russell, need to go to the particular dog to determine whether a wound is from a dog?
No.
Have you ever heard of an emergency medicine physician needing to go visit a dog to evaluate and treat a wound from a dog?
No.
Is that a rational proposition?
I don't believe so.
There was much discussion. Well, let me strike this. You were asked a number of questions about whether your testimony here for this hearing and your statements in your report are different from what you testified to in June 18 and June 21 of 2024. What I'd like to do is to compare the two and go through some questions with regard to that. So what I would like to do is to have you have Exhibit 35 which is the transcript of the December 12. Do you have that? It's a thick, it's the December 12, 2024. You should have that.
I do.
Okay. And what I would like you to do is to also have available exhibits 35 and 36 and 37, because that's what we're going to do side by side comparisons. So let's start out with the foundation for this. Do you have an opinion with regard to the nature and source of the wounds on Mr. O'Keefe's right arm?
Yes,
What is that opinion?
they're from dog bites, dog attack.
And do you hold that opinion to a reasonable degree of medical certainty?
Yes,
Now, at the June 2024 voir dire hearing, the claim is that you didn't say to a reasonable degree of medical certainty that the bites you looked at were a dog. So can you please go to tab 36, pages 1-30, line 13 to 1-31, line 1. Stop at 1-31, line 1. These were questions in response to what you were asked on direct by Mr. Jackson. And I would, with the court's permission, like you to read the question in the answer to what you actually testified to at that voir dire hearing. So please go to tab 36.
So can I see counsel at sidebar, please?
Yes.
There is sound. I think they're having a sidebar, so nothing is gonna play right now until they're done meeting at the bench. A little bench conference going on right now. If anybody is curious, I should probably put up a banner, huh? No worries. I'm sure other people probably thought the same because we lost a couple of viewers.
Yes.
Dr. Russell, first of all, do you recall in questions on cross the claim by Mr. Brennan or the statement in his question by Mr. Brennan that you did not express certainty in response to Judge Cannoni's question about the certitude of your opinion? Do you recall those questions?
Yes.
Do you recall? Well, let's go and look exactly at what you said in response to the question that Mr. Brennan raised that was raised by the judge. If you could turn to Exhibit 36. And if you could read page 1-51, lines 10 through 23. I'm sorry, bear with me a moment. Bear with me, I want to give you the correct citation. I want you to go to, did I say 37? I wanted to say 36. Did I say 36?
You said 36, but you said page 151. You might have meant page 131.
Right. That's what I want to go to, Your Honor, which I will. Okay. Bear with me a moment, Your Honor.
Sure.
This is going to be one of only 2 questions in this area.
You may have meant page 130. That's where we started before we came to sidebar.
Thank you, Your Honor. What I'm trying to do is to get to Your Honor's question. That's what I'm going to pull out.
My question was on page 151.
I'm sorry?
My question was on page 151.
150. Thank you, Your Honor.
151.
Can you go to page 151 and read the questions from the court, Judge Cannoni, and what your answers were?
Yes, from line 10. The court, question. I just have a couple of questions for you. I don't think I really heard you. So could you tell me again what your opinion is and to what degree you hold that opinion? Answer, yes. These injuries in the arm are, my opinion is that they are the result of animal bites or scratches. Question, do you know what kind of animal? Answer, yes, most likely dog, large dog. And I'm very reasonable, very sure to, what's the word I want? Medical certainty. Very sure, high degree of medical certainty. Question, reasonable degree of medical certainty? Answer, yes, definitely. Question, and okay, and another question.
No, that's
it.
That's it. Yep. Now, to be fair and accurate, has your opinion that the wounds to the right arm of the decedent were caused by a large dog attack strengthened from June of 2024 until now?
They have.
Why?
Well, because between then and now, my opinions have been challenged. And as any good doctor would do, they go back and reevaluate what they base their opinions on. And I did that. I reevaluated. I looked at the pictures again, the evidence again. I looked at peer review studies, and I was convinced that I was correct.
And had you looked at, what caused you to go look at the peer-reviewed studies? What were you doing?
Well, so I looked at the peer review studies, and I periodically would do that throughout my whole career in terms of dog bites. But I looked at the peer review studies again because I was asked, why I didn't write a report, and so I was asked to write a report.
Were you asked to write a report before in June of 2024?
No.
But you were asked to write a report after June of 2024.
Correct.
Now let's go to is this what doctors and scientists do? Go back and analyze a matter, especially when maybe there's a challenge, another doctor is a question, there's a peer review process, whatever it is that something that's common or uncommon in the medical community?
That's very common.
I only have a few more questions, Your Honor. I'm just looking at them to conclude. On cross, you were asked about whether you were aware of or whether you saw a need to peer review your opinions and conclusions in this matter. You recall that?
Yes.
Was that necessary?
No.
Why not?
Because first of all, there was no question in my mind that these were from dog bites.
And are there any persons that you're aware of in the entire country who have experience with emergency medicine and forensic pathology that you could even send it to for a peer review?
No, and that was the other issue, is I wouldn't even know who to send it to because I don't know of anybody with such experience.
I am going to, let's assume hypothetically that Mr. Walsh has stated that these injuries do not photographically appear to be described as puncture bite wounds and thus are highly unlikely to be the result of an animal bite attack. The abrasions are unspecific. Abrasions occur in body moves over a blunt or rough surface, such as a skin knee. Do you find that analysis sufficient to evaluate whether the bite wounds in this, excuse me, the wounds from the right arm of the right arm of the decedent are from a dog or not?
No.
Why not?
Well, clearly that person, whoever wrote that, didn't even recognize the pattern. And so thus couldn't really even make that opinion and, just didn't recognize the features.
In the hypothetical that I just gave you, do the facts that are used in any way support the conclusion that is stated?
I don't believe so.
You don't believe so, or can you answer whether they do or they don't? Do the facts stated in that hypothetical support the conclusion that is made in that statement?
Actually, they don't.
Assume the same person said a vehicle backing into O'Keefe is one of many possible causes of his death, though the absence of documented injuries of his torso, hips, and legs appear to be inconsistent with a vehicle impact of significant force to simultaneously shatter a rear taillight. Would you agree or disagree with that statement? Or the conclusion? Would you agree or disagree with the conclusion?
Would you please read it again?
Sure.
Sorry.
A vehicle backing into O'Keefe is one of many possible causes of his death, though the absence of documented injuries of his torso, hips, and legs appear to be inconsistent with a vehicle impact of significant force to simultaneously shatter a rear taillight. Do you agree or disagree with that statement?
I agree up to the point, the mention of the taillight.
But what is it that you agree with in that statement?
Well, I agree to the part that says that that it was insufficient to cause the injuries, the death of Mr. O'Keefe.
Now, aside from that hypothetical question, what is your opinion of whether a motor vehicle caused the injuries to the right arm of Mr. O'Keefe?
Motor vehicle did not cause.
And do you hold that opinion to a reasonable degree of medical certainty?
Yes.
Are you aware that only microscopic pieces of plastic were found in the hoodie sweatshirt of Mr. O'Keefe as opposed to, quote, littered, end quote, aspects?
I am.
Are you aware of any evidence of littering of pieces of plastic or glass in the hoodie of Mr. O'Keefe?
No.
Are you aware that there was pig DNA found on the decedent? Are you aware?
Not on the decedent.
On any aspects of the decedent's clothing?
Yes.
Do you know, from your experience, with regard to dog-inflicted wounds, your many emergency room evaluations and treatments of them, whether, or in your knowledge of dogs and dog dentition in general, are you aware of whether dogs eat any type of food or treat that has pig in it?
I'm aware that the dogs, some dogs eat treats that have the pig chews and other kinds of chews. So yes, they do. Some dogs do eat things that contain pig.
Your Honor, just if you will, a point of information. I believe I'm done with my questions, and the reason why I say I believe I'm
Why
done.
don't you come to sidebar instead of having
Okay.
discussion across the court?
That is an interesting piece of information. So y'all know I'm not all the way up to par on Karen Reed, so I'm gonna do my homework so I can have better commentary for y'all. But it sounds like if a dog ate something with some pork in it, then that dog bit you. That pork, it's a possibility that pork could be on you. And y'all keep me honest, but I understand this case to be that they believe she ran him over with the car, and the car made all of the markings on his body.
All right, so recross examination.
You need a moment? Okay.
I'm holding Mr. Brennan up. I just
That's
want to
okay.
move my stuff, and I'll be ready in a moment.
Okay.
Dr. Russell, Attorney Lisi, pardon me, asked you about Dr. Walsh's statement about the cause of injuries. You remember? He just asked you that?
Yeah.
What he didn't offer in the report is this, and let me know if you agree with it. The decedent John O'Keefe was documented to have craniocerebral injuries, including skull fractures of the optical skull and the right parietal bone with associated subdural and subarachnoid hemorrhages. These injuries of the scalp, skull, and brain are consistent with, among other things, a backwards fall, unobstructed, unprotected falls due to various reasons are known to result in serious craniocerebral injuries resulting in death. Other mechanisms of injury cannot be excluded. Do you agree with that?
Objection, Your Honor.
I'm going to allow him to do it.
Do you agree with that part that you didn't hear of Mr. Walsh's opinion?
Yes,
The documented changes in color, swelling of soft tissue around the eyes are most consistent with the medical finding of periorbital ecchymosis, as documented in the autopsy report. Periorbital ecchymosis is a passive accumulation of blood around the eyes secondary to the documented skull fractures. These findings are less consistent with and are not documented as contusions of the eyes. The 1 centimeter laceration of the right upper eyelid, laceration of the anterior right tongue, and abrasion of the anterior and left aspect of the nose are documented, considered nonspecific, and may have occurred to a variety of mechanisms. Do you agree with that?
yes.
Okay. The 2 red contusions on the dorsal aspect of the right hand were documented. The hand injuries may represent an injury sustained during an unprotected fall in which the back of the hand impacts the ground. These hand injuries are nonspecific and may have resulted from impact of hand with any blunt object. Do you agree with that?
It's possible, but there are other mechanisms.
Okay. When you talked about those articles that Mr. Alisi had you read, there is nothing that details what pattern recognition analysis is, the specificity which you are looking for when you're looking for a wound, does it?
I disagree.
Okay. When you looked at that Exhibit 5, if you could pull that up, you said individually, none of those wounds could you say to a reasonable degree of medical certainty were caused by a dog. It's only if you looked at them collectively.
Yes,
Okay. When you look at those collectively, it does not tell you the order in which the wounds were incurred, does it?
no,
It doesn't tell you if they're all incurred at the same time, does it?
they were occurred around the same time, I can tell you that.
Yes. But they don't tell you the order, the chronology, do they?
No,
No. In fact, when you look at the studies that you introduced with Mr. Alisi, let's talk about the Munich one very quickly. There's a chart, page 298. It talks about the things you would want to do to identify a wound. It talks about scene investigation, doesn't it, in the chart, table 2.
that's a fatal case, though.
Scene investigation is something you would look for?
That's in a fatal case caused by a dog. The cause of death was the dog.
This whole thing is, the whole excerpt is a fatal case that you're relying on for this pattern recognition analysis. This whole article is about a fatal case.
That's
isn't
what
it?
I'm saying.
Right. And in this fatal case that you're relying on to say this pattern recognition analysis, it points out scene investigation is the priority, doesn't it?
I think you misunderstand. The focus of that article is to identify the dog that caused the fatal injury. In this particular case, I don't believe any of those are fatal injury. That is not the purpose of the identification of those injuries.
Does the chart also say examination of the victim?
Excuse me?
Examination of the victim, does it also say examination of the victim?
I don't have it in front of me anymore,
Well,
but
you relied on it, you don't remember
Yes.
this?
I think we have it. We don't have
Oh, I
it.
do I have it? Oh, yeah, it's a minute. Okay,
Table 2,
okay.
page 98, examination of the victim. You did not examine the victim, did you?
Table 2.
Yes,
No.
table 2, page 90. And the last part is examination of the,
I examined photos.
the last part is examination of the dog. You did not examine Chloe, did you?
No,
Okay, so the 3 things in the table it tells you to do, you didn't do any 3 of those, not one of them.
those, again, the purpose of this article was about the fatal, how to, the forensic approach to a fatal dog attack. We did not have a fatal dog attack here.
You didn't do any of those 3 things, did you?
No,
Okay. The shards in the sleeve, exactly where those wounds are, same area, same limb, right? The
That's what you
shards,
say.
how many shards were in that sweater?
Objection, Your Honor.
So, I'm sorry, you said that's what you say, doctor? Is that what?
yeah,
Is
and
that
he
what your
he
answer
said,
is?
Mr. Brennan said that the shards were in the exact same location as those wounds.
Okay,
And
let me
that's-
rephrase that. The shards in the right arm of the sweater, the shards from the tail light that was shattered,
Yes.
those shards, how many were there? How many
I
microscopes?
believe there were only a couple.
Why do you believe there were only a couple? Where did you read that?
This is what I was told
This is, you were told by who?
by defense.
Oh, so instead of looking at the actual criminalistics report, you simply rely on what they tell you to base your facts?
That's what I was told. Yeah.
Wouldn't it be more prudent to actually look at the criminalistics report and make your own determination objectively and medically rather than regurgitate a point of the defense?
Well, I was told, this morning you said that the sleeve was littered with glass. And I was told that it was not littered.
Have you ever looked at that criminalistics report for
I'd be
yourself?
happy to do so now.
I'm asking if you've ever looked at it before you offer this opinion.
No.
No. If the glass shards were in that sweater in the arm, and we know glass can cause a hole in a sweater, in a fabric, can puncture it, and it can cause an abrasion to skin. Have you done any tests or studies to rule out that the broken taillight that was in the arm sleeve of Mr. O'Keefe, did you do any studies to rule out that it didn't cause those injuries?
Objection, Your Honor.
I'm going to allow it.
The glass shards would not have caused all the round wounds in the sweater. Those holes. The defects in the sweater mostly were round. They were not slit-like defects that I would expect with glass or plastic.
You're telling us that a sharp piece of glass cannot cause a hole to a sweater?
No, I didn't say that. I said they would not, especially on multiple sites, the same exact type wound, defect.
If the glass was shattered and the glass had a number of pointy edges, wouldn't you agree with me that can cause a number of punctures in somebody's arm if the glass went into the arm and then came out?
Yes, but they wouldn't look like that.
You don't have any past case of history to suggest what the glass shards would look like randomly when they hit somebody, do you?
That's incorrect. I have seen hundreds of motor vehicle accident victims who have been cut by glass. They don't look like that.
So from your perspective, the glass just remained dormant in the sweater, but never protruded through the sweater and caused the abrasions. That's your opinion?
I didn't say
Your
that.
Honor, could we have a sidebar on this? Sure.
I have no further questions. I'm good.
Okay, because he lost me anyway. I'm thinking about a glass being that somebody can be near somebody, and if the glass breaks, I would think that depending on the angle and the wound, you would be able to tell if those are glass marks or any other type of marks. I don't know. I could be off though. I could be off and wrong. But that's immediately where my mind is.
Dr. Russell, when I'm referring to these shards, and I've said glass shards in Mr. O'Keefe's sweater, a more accurate way to define it would be that these were plastic shards, the plastic covering of the taillight, not glass. Okay?
Okay.
All right. Thank you.
Dr. Russell, you are all set.
We're done?
We're done. You're done. We're not done, but you're done. You can step down, Doctor.
Thank you.
If council really can keep your, Mr. Lessie, if council really can keep your arguments to 15 or 20 minutes, I'll give you 5 minutes to pull them together, 5 or 10 minutes to pull them together.
Thank you very much.
I really can't keep the arguments.
All right, so I'll be back out at 3:15.
All rise, please.
All right, so I guess we are on a short break while they do that. And again, this is just a motion. It's crazy. Crazy, crazy, crazy. Yeah, no, I don't want to keep the people bored. So we'll jump when I hear Karen Reed is back live, I will jump on back over. Let's go on back to this hot mess that we was watching.
I don't disagree. My understanding is, though, that in this case, there was a fundamental issue that is presented is whether or not Detective Moretti's credibility is questioned, and whether he says X, Y, or Z is the state, the assistant state attorney going to be called as a witness to impeach something that Detective Moretti says. And if that's the case, and she's called as a witness, then it'd be in a very curious position where she would be arguing credibility to a jury at the end of the case, and there would be actually.
I don't even think there's a point to the defense to know whether they're calling her or not.
They've said it in they've given a notice in witnesses. They called they know, maybe I'm wrong. Now somebody filed a notice.
Not that you notice, we handed the office a subpoena for her, that they were told us that administration instructed them not to accept any subpoenas from us. And that was 3 days ago.
They did not. The attorney, the attorney, and I don't think we had it. I don't think whatever, but
It's irrelevant because it's not a valid subpoena because we didn't have 5 days. We're going to go around in circles. The bottom line, Your Honor, is we have set a hearing for today. We want to go forward on this hearing, and obviously the state's doing everything they can not to go forward on any hearings. Ms. Bradley is here, Ms. Boutros is here, the other state attorneys are in the office. We can have this hearing if the court will just basically say, I set the hearing for today, I want these witnesses here, let's move on.
You'd like to call Mr. Children first? So, I mean, just like they found Ms. Bradley in a couple of minutes, let's let them come down and ask them questions, and then see where we are.
I did that, you didn't, right, and we filed a motion to apply and Ryder and Paul.
And I didn't, regardless, Ms. Bradley's here. I want to hear from her. She's the lead attorney in this case. She needs to be. All right. So, Ms. Bradley, what we're going to do is I want you to step outside. You just wait outside there and open the rules of the procedure. I'm going to give them a little legal after what they have to say. But the other weeks, or read the deposition of Ms. Boutros. I'm sure that you have a copy of the law, Ms. Bradley. I have everything. Anything to outside? Okay. Ms. Boutros, before we get started, I wasn't aware that you were ill, and I apologize. Have a seat. Thank you. Raise your right hand if you sworn.
I do. Michelle Boutros, Boutros. Yes.
Where are you currently employed?
The Broward County State Attorney's Office in the Public Corrections Unit.
Okay, and what is the public corruption unit?
We investigate public officials who are engaged in criminal conduct. We investigate law enforcement that are engaged in criminal conduct, which would be a public official.
And how about if somebody in your office is engaged in unlawful or suspected unlawful conduct? Do you investigate that, or is that sent to an outside agency?
That would be a decision that administration would need to make. We wouldn't be part of that decision. I would assume so, but I can't say for sure. You'd have to ask them.
Okay. How long have you been a state attorney?
20 years.
And what units have you been in?
I started off, as everyone did, in misdemeanor, and then I moved on to felony trial unit, and then I spent 8 years in the gun unit, and then I spent another 7 years in the gang unit, and then I was in case filing for about 6 months, and then I was moved to the public corrections unit.
Were you familiar with a prosecutor's Brady obligation?
Yes, I am.
Can you please explain what you do?
In my career, in my practice, I disclose anything that I feel that would cause a credibility issue for a witness, any witness. Credibility, exculpatory, anything that would benefit the defendant at trial Whether it's admissible or not is a decision that the judges make, not me. You can call it Brady, you can call it a supplemental discovery, you can put it on a paper napkin, but my goal has always been to be transparent and to provide the defense with any information that they deem that they might need at trial.
Now, let's jump ahead. You were asked to take over a case involved in a tampering with a witness case?
Correct.
Okay. And who did that surround?
It surrounded Jamal Demons and his mother, and the allegation was that they were tampering with two witnesses by the name of Holmes and I can't remember the other name, but the mother and the ex-girlfriend and the mother of the ex-girlfriend of Mr. Demons.
And this was being investigated as a separate case, part of this murder case that you're here today? That's probably how was it determined?
Well, it began as a separate case that I was to investigate Miss King, who was Mr. Demons' mother, to kind of discover whether she was tampering with these two witnesses. The actual statement included things about this case and included questions by Detective Moretti about this case.
When you say this case, but
the homicide.
And the investigation subpoena that was sent out, there are no case numbers on that, it's just an investigation subpoena.
We have internal investigative numbers in our office. They are not case numbers. They are just investigation numbers.
Okay, so somebody who was sitting there, this case would not know what case this was about, just know that they were sitting there giving an investigation.
Stay.
What were you asked to do in this case?
I'm never asked to really do anything. I'm handed a scenario and I'm asked to investigate it. And then I make a determination as to the steps that I'm going to take to do the investigation.
And what steps did you determine today?
I decided that the first thing that I was going to do was to see if Ms. King was represented by counsel, and she was. And I contacted Mr. Trackman, and I originally asked him if she would come in without a subpoena. I believe he required a subpoena, and at that point, the goal was to get these two witnesses and move on to the information. So I granted her immunity by giving her a subpoena and explained that to her at the beginning of the statement. So Mr. Trackman was aware of what the investigation was about prior to this statement on the 12th of October.
How did you get assigned this case?
Mr. Killoran assigns the cases. So he, in this situation, was contacted by Ms. Bradley, who asked him if our unit would investigate it. And this isn't normally something that we would investigate it for whatever reason. You'd have to ask him. It was accepted into our unit and assigned to me.
And the reason why your unit doesn't normally investigate this is this didn't deal with a public official.
Yeah, correct.
So this was out of the norm.
Correct, but we do things out of we're not exclusive to public officials. If there's special projects that need to be done, we will handle them. So it wasn't alarming that it was in our unit.
It was out of the norm. There are other times that you do things out of the norm.
Correct. And when I say out of the norm, I don't mean that there was anything negative about that. I just mean that there are instances, like with maybe attorneys, we investigate attorneys and they aren't public officials. So it's really just on a case by case basis. And Mr. Killer makes those decisions with Ms. Falk and Mr. Pryor.
I'd like to start with a couple of very important cases for your honor's consideration. The first is one out of the District of Massachusetts Federal Court. It's Hines 65 Federal Supplement, second, page 62. It's a 1992 case, authored by Judge Berger. It had to do with a soft science handwriting analysis. It was a very thorough and thoughtful case that talked about soft sciences, methodology, and when there was an absence of methodology. In that case, I'm sure your honor is aware, it had to do with a proposed witness who wanted to look at a handwriting exemplar and provide an opinion of a so-called match. The court said there were very important canons, very important principles or foundations that have to be considered when we're discussing a soft science. Empirical study is not enough. Simply because somebody has seen something before, whether it's once or twice or 100 times, it's not a science. It's not a methodology. It's not medicine. It is a personal aside. A potential expert has to be in a better position to understand and explain to jurors rather than a simple layperson. That means there has to be some level of methodology, some type of guidance, some type of study so that they can assist the jury in better understanding what they believe their conclusions are. Empirical is not enough because a subjective opinion without medical, factual, scientific support is just an opinion. A person can look at the constellations and see the Big Dipper, they can see Orion. It's a matter of perspective. It's no different when we have something like a soft science, something different than DNA, where a person wants to give an opinion because they've seen something before. That's not enough. And in this case, Dr. Russell has never been in the business of identifying dog bite wounds. She treats them. She's an emergency room physician, had some experience as an ME. She treats a wound that is brought to her. She's not diagnosing the wound or determining the mechanics of injury. She doesn't have the education. She doesn't have the qualifications. She doesn't have the training for that. That is not what her job is. It is to treat the injuries. And so all of her perspective and opinions are empirical. She doesn't have a book. She doesn't have a study that teaches her how to. She never took a training. She never took a class. She never got a degree or certificate. She is looking at her past experience when someone reports to her that it was a dog bite wound, and she's trying to use her memory and make a decision whether or not she thinks this is similar. That is not science. That is not medical certainty. And so there's nothing to suggest that whatever method she used, I still can't identify it because I don't know, despite many questions of asking her, what her methodology is, other than she says it's pattern recognition analysis. It's empty phrasing unless you can identify and articulate what is the specificity, what is the standard, and we still don't know. After all of this testimony, we don't know. In Cromwell versus Rintala, that case had to do with a prosecution expert talking about paint spill. And this is, could not fit more closely to this case. The conviction was overturned because the prosecution called the paint spill expert. It was found to be prejudicial because the expert relayed their past experience about paint spills. Exactly what Dr. Russell did in this case. No more, no less. Her past experience treating injuries that were reported as dog bites, a person with their past experience with paint spills. The court was very specific in Rinaldi about why this was improper and why it was prejudicial. It said that just because a witness has experience or a particular experience and decides to use that as a methodology does not make it methodology. And it's just like Dr. Russell's testimony. There is nothing about it that employs methodology. In Rinaldi, pardon?
Rintala.
Thank you. In Rinaldi, direct the court to page 39. And it talks about when the expert used methods to determine that paint was poured or spilled. And the problem, why this case was reversed, the court said, instead, meaning the expert, he simply relayed his past experiences working with and around paint and drew conclusions therefrom. That is exactly what Dr. Russell has done. She has relayed her past experiences working with and around treating dog bites and drew her conclusions from that. They cite Combo versus Franceschi. I'm probably saying that wrong as well. But what that quotes is, while training and experience, to which the expert referred, might have taught the expert methodology, it is not itself a methodology. And so while Dr. Russell may have taught herself or been intrigued or interested in dog bites, it is no methodology. The defense has introduced a couple of articles. Those articles do not describe or lay out a methodology for identifying dog bite wounds. They don't provide a standard. They do not provide a comparison. They don't provide any guidance. And so the danger in having somebody go before a jury and portray themselves as an expert when they have no methodology is they can pretty much provide any opinion they want to the jury that can be unchecked because it's not factually based. It can't be compared. It can't be analyzed. It's not peer reviewed. It's just an opinion. And when an expert lacks methodology, classic things happen, which happened in this case. What happens is that a witness does not actually have certainty about what they're saying. A witness is prone to change their opinion because there is no standard or methodology to confine them. A witness can just change their mind without new information because it suits their purpose. When we looked at Exhibit 5, and we actually broke down the wounds into separate wounds, 5 wounds, the doctor, I believe, concedes when you look at each of those abrasions independently. She cannot say with scientific certainty. She can't say with any certainty that those were caused by a dog. Her fallback was when you look at the entire series of wounds, that equals a dog attack. No basis, no reason why we reached that bridge from uncertainty to dog attack other than just because she said so. That can't be challenged because there's no methodology. And so the risk we have is you have an expert who gets up in a voir dire and they give opinions that wound number 1 could have been teeth marks, could have been claw marks. Wound number 2 could have been teeth, could have been claw. Wound number 3 the same. Really no idea. It's just guessing or speculating. And then they get up later and they change their opinion that more benefits their side. She later testifies at trial, sometimes maintaining teeth or claws. And then she appears in this hearing after writing a report and consulting, and she is emphatic that these are not scratches, but that they are dog bites. Think about the posture of that. If she is now saying that these are dog bites and they're not scratches, and she's changed her opinion, that impliedly concedes that her testimony in front of the jury, for which she was allowed to testify as an expert, not only was inaccurate, not only unsure, but inevitably it's misleading. It cannot be helpful testimony if an expert provides an opinion to a jury and they later on, without any real changes in information, changes their opinion for whatever reason. They're not constricted because there's no methodology or standard. And so the fact that this witness was allowed to testify at the last trial with opinions she no longer endorses and stands behind, and the fact that we can reasonably conclude that is misleading to the jury, well, that begets the argument that she should not be given another chance to go in front of a jury and give a different opinion without having actual factual and medical and scientific support, and she does not. There is no doubt about one thing, she has no idea. When I walked her through the different wounds on Exhibit 5, I invited her to explain to your honor, why is it that this wound was caused by a dog? There's no circumstantial evidence to support that, none whatsoever. It's just her personal empirical history dealing with dog injuries in the ER. And when I asked her for wound 1, what direction were these canines? She couldn't tell. Where's the puncture wound where the dog anchors and pulls? There is none. The distance and width of those wounds, how could she reasonably and fairly say they were caused by canines? Any indication, any support, any pattern recognition that would tell us that was caused by canines, and she couldn't give us any information. Not weak information, not information that I could fight with another expert, not information that I could say, wait, not the admissibility. None. She could just fall back on, well, when I look at everything at the dog level. Same thing with number 2. Number 2, interestingly, the widths are much different than wound number 1. It doesn't take an expert to know that it wasn't the same mechanism that caused the injuries to wound 1 and 2. And if they want to continue to pretend it's a dog bite on wound 1, there's no way they can reconcile that wound 1 is in any way similar to wound 2. It would have had to be a baby dog or a different dog or the pack of dogs I asked her about the first time I talked to her. It is totally different. And again, when I asked her for any specificity, these weren't hard leading questions. I opened to her to explain to us, why is that a dog bite now? She would only give us a conclusory answer. It just is. There was nothing about teeth or the tension or about the dog, about anything that would support the claim that that was a dog bite and why she changed it from the scratch. None. We get to the elbow wound number 3. There's the speculation that the arm could move, wouldn't move. Yet she has no idea. She has no factual support for this. None. And she vacillates between this being potentially bites, scratches. All 5 of the different points on wound number 3 could be canines on both sides, or maybe there was a 4-point canine in the smaller fraction of number 1 and number 2 in wound 3. That cannot be. It defies common sense and reasonableness to say the same dog caused wound number 3, points 1 and 2, with the so-called punctures, and caused number 1 and number 2. Again, you can simply look at the distance between canines are not going to move when a dog bites an arm. An arm can move, it can change the angle, the depth, the canines are not going to move. Then we get to wound number 4, equally baseless. Wound number 4 at first wasn't sure if it even had to do with the dog attack, but then that made no sense. So Dr. Russell retreated to say, well, it did have something to do with the dog attack, but hard to define. And then wound number 5, again, a 4-point bite that is totally reconcilable with 1, 2, and 3. There is no collateral or supportive evidence to suggest that this is a dog bite at all. It's fertile imagination for her to get on the stand and claim it's a dog bite. Not just that there was no opportunity and that there was no dog that touched him, but the wounds are dissimilar. She cannot point to a pattern, a methodology, a standard to say, this is why this is a dog bite. It's just a dog bite. So it's interesting when we learn that she didn't know about much of the evidence that wholly contradicts the fact that this is a dog bite. She didn't know that there were plastic shards in the sleeve of his arm. The fact that there is physical evidence that results from a collision left in the very place where this wound happens to be there isn't mere coincidence. It isn't mere coincidence. It's exacting evidence. And what is not exacting evidence? The absence of DNA. Now, this is important because Dr. Russell was comfortable taking the stand and providing information to Your Honor for consideration that was totally baseless. It didn't in any way hamper her willingness to do that. She floated theories of taint in the DNA, or manipulation, or the DNA wasn't handled properly. There was absolutely no good faith basis whatsoever for her to suggest for a second that that DNA collection, preservation, and testing wasn't sound. She had a right to look at the evidence in the prognosis reports and the DNA processing. She knew she could not admit the significance because it would undermine the entire theory. And so she was comfortable on the stand using her experience as a doctor to try to convince Your Honor that DNA was insignificant based on a demeaning of the evidence with no basis. An insulting claim that somebody did something wrong with no basis. The reason why that's important, it shows that this witness has the willingness to testify to Your Honor about a conclusion for which there is no support. This witness has the comfortableness to testify to Your Honor about an opinion that has no factual basis. And her doing that with the DNA was a parallel to her doing it with the dog bites. She is comfortable getting on the stand and simply giving the ultimate opinion that is helpful for her cause without any support. And so that DNA attack by her is reflective of her willingness to compromise fact, science, and medicine to just provide an opinion. Knowing there is no real methodology here, there just isn't. Knowing there's no standard, unable to provide us any balance for why this is a dog bite, having the free rein of an opportunity to look at the exhibit and tell us anything she wants to support its dog bite, and being unable to do that, the defense employs differential diagnosis. That's a fancy way of saying, well, we might not be able to prove this, but we can disprove everything else. That's the way they presented this expert. They own that. Because when you look at those different wounds, and you can't identify them as dog bites individually, you can't say the whole series becomes a dog bite. Wound 1 has 0 value. Wound 2 has 0 value. So 5 times 0 is 0. Cumulatively does nothing for us. Using the word dog attack doesn't make you look at that and say, well, that's methodology. That is nothing. And so differential diagnosis is a very compelling argument for for the government why you should not allow this. This witness is in no position, kind of like the DNA and kind of like the opinion on dog bites, she is in no position to engage in differential diagnosis regarding to car accidents. She may have been a police officer, she treats injuries at the hospital. She is not an accident reconstruction specialist. She has never gone to an accident and done a reconstruction. In fact, she never even went to the scene in this case. She never saw Mr. O'Keefe. She doesn't even know about much of the evidence that exists. She didn't consider the black box. She didn't consider the speed. She doesn't know the angle of the collision. She doesn't know what Mr. Keefe was doing in his last moments. She has no idea about any of that, none. Yet she'll be presented on the stand as if she can exclude a car collision as the cause of those injuries. Not that they could be, and it's consistent with what didn't happen. How dare she get on the stand with no experience, no training, no methodology, no facts, and ignore reality and say this couldn't have been a car collision. It's funny that as an emergency room physician, she considers the basis of mechanics of injury based on what people tell her. If they come in and say, I got bit by a dog, or a parent says, my child was bit by a dog, they rely on statements of witnesses. She didn't rely on the statements of witnesses here. I hit him, I hit him. Oh my God, I hit him. Maybe I clipped him. Maybe I hit him in the knee. Maybe he dropped his phone. Whatever the statements were. All the various statements. An expert like her, if she proposes to be, would consider the witness statements to try to determine the cause of mechanical injury. So for her to take the stand respectfully and suggest for a moment that this was not caused by the collision to Mr. O'Keefe, not only with any no factual basis, in defiance of actual fact, it's repugnant to the sense of fairness in the courtroom. A witness, just because they have experience as a doctor, doesn't mean they can just come into court and say what they want and then let the government try to counter it. That's not how it works. And so when we consider not only what she doesn't know, but what she chose not to know, it is overwhelming. This is not a qualified person to come in and talk about dog bites. From her perspective, she's probably one, if not a few people in the country who can even do this kind of thing, which suggests that there is no real methodology. If she is the only expert in the country, it is not generally accepted in the community. It can't be. It can't be. And as much as the defense may want her to testify to promote this theory, she does not have the credentials and qualifications to do that. She didn't even take the basic steps, as you'll see in some of the literature, of going to the dog. Chloe, they knew we found Chloe. They know we've done molds. And she says they told her. And she tried to fight with every posture and angle that may be important, but she didn't need to do that. I dare say, if she had taken some steps to try to do due diligence, it wouldn't have ended well for her theory. Perhaps that's why she didn't. She doesn't have the qualifications. She doesn't have the experience. She doesn't have the methodology. Her willingness to tell opinions that are speculative, factually wrong, not based in science and math, should disqualify her from giving another baseless opinion about a so-called dog bite wound. There is no DNA. There is plastic shards in his arm. She has done no due diligence. And she can't describe any methodology because there is none. And she, most importantly, has changed her testimony from hearing to hearing, and we should not let that happen again. Thank you.
Thank you very much. All right, Mr. Lessie.
Thank you, Your Honor. The greatest danger to the issues in this case, the greatest danger to a defense right to a jury trial and present its witnesses to have an entire motion supported by nothing but the assertions of an attorney on the other side. That is the greatest danger to our system. That is the greatest danger to a defendant being able to present their case in their view. Remarkably, all of the arguments you just heard now do not come from a medical doctor, which Your Honor has said causation of an injury to a person in Massachusetts must come from a medical doctor. Where is the affidavit? Where is the report of a prosecution witness to support one statement Mr. Brennan just made in 30 minutes? Where is it? It doesn't exist. I would like to start my argument and tell you exactly where I'm going to go. I'm going to go to why we're here and what the issues are for this motion. So I'm going to start my argument with what is the legal standard that Your Honor faces to answer it. And I know Your Honor knows it. I'm just doing it for the logic in the presentation. I'm going to go through that. I'm going to identify specific case law of dog wound cases, not paint cases, not others, because it matters, because Daubert and Lanigan are so flexible and so nuanced. It's got to be the issue before it. Paint cases that Mr. Brennan mentioned are irrelevant. So I'm going to go through cases that speak specifically to dog wounds on humans. Then what I'm going to do is to go through the completely inaccurate statements of Mr. Brennan. He said it, I marked it down 8 times in just his argument alone. There's no methodology. I'm going to go through and say what the methodology she testified to was, where it's rooted, and then I am going to go into why Dr. Russell is actually stronger in December than she was in June. So let me start out with the baseline for this hearing. The January 20th transcript, page 1-4. And if Your Honor will indulge me, it's what Your Honor said, and I'm going to read it verbatim. This was when Dr. Russell was challenged by the prosecution the first time. Line 15. I find that she is a medical doctor. She's an experienced ER doctor, albeit, several years ago since she's worked in that capacity, but that she does have specialized knowledge in that field that may assist the jury in that regard. So if you compare the level of information that Your Honor had at that time to reach the conclusion to what we have presented in this hearing, 11-page single-spaced report. And Your Honor noted before that there wasn't a report, so we wanted to respect that and get a report. Your Honor has sat through testimony, which I'm going to adduce, but not too much because you sat and heard it, and went through her qualifications, and we adduced much more of her qualifications, much more than were adduced when Your Honor first found that finding and made that finding. So let's start with the law. Mr. Brennan and I agree on one thing. The Rottola case is relevant. But respectfully, Mr. Brennan went off in a tangent, because what does Rottola stand for that's relevant here? Quote, the crucial issue, in determining whether a witness is qualified to give an expert opinion is whether the witness has sufficient education, training, experience, and familiarity with the subject matter of the testimony. What is the subject matter of the testimony? It's what are the cause of the wounds to the decedent's right arm. I submit that if you ran an artificial intelligence program, you couldn't come up with a more perfect witness for the subject matter of this testimony. Emergency medicine physician, 29 years experience, forensic trained pathologist who has co-authored books on dog bites. She's well-versed in the articles. She is consulted by experts like Dr. Vail that you heard about for these types of issues. The crucial issue of whether she's qualified, to me, is 100% her favor. And I don't believe you could find another witness more qualified. And that's the crucial inquiry. What's the second prong of the inquiry? After qualifications, is the methodology reliable? That's the second. Whether Mr. Brennan agrees in 95% of what he argued, that's for cross at trial. But more importantly, that's for a jury to determine. That's the job and province of a jury to determine whether, assuming Mr. Brennan ever gets a doctor to come in and counter Dr. Russell, it's for a jury to decide which expert do we give more weight to. But the focus of this hearing, why are we here? The second prong is the methodology. Mr. Brennan 8 times in just this argument now, and he tried it on cross, said there's absolutely no methodology. Your Honor sat and heard the same thing that all of us heard. She went through her own pattern recognition methodology, especially in redirect, but she did it very thoroughly in a report and very thoroughly on direct. She went through what it is. And importantly, counter to what the Commonwealth just said, she says it's rooted in the medical literature. We just heard the statement that there's no support for it. Munich and Pollock. And we walked through, with your Honor's gracious indulgence, we walked through specific sentences and paragraphs where that pattern recognition methodology is stated. And here's a key. Remember, please, the word pathognomonic. This pattern is so specific that it almost by itself rules out anything else. That's the definition of pathognomonic. And that's the definition. And Dr. Russell used highly characteristic, but she did note and explain what another study said was pathognomonic. It's incredible to me that it can be stated that there's no methodology here and that there's no basis for it. It is generally accepted in the medical community. That's the purpose of the Pollock and the Munich article, is to establish that it is accepted. Dr. Russell is not coming here to the court and just testifying, it's my subjective empirical statement. Mr. Brennan tries to do in his argument exactly what an expert rejected and for which he has no support. And that is to say, we got to look at these wound by wound by wound. And he said 0, 0, 0, 5 times 0 is 0. He tried that on cross. Dr. Russell rejected that resoundingly. She said, you're missing the point. The point is the pattern. You look at these all together, and it's the pattern that matters. And the authors, Pollock and Munich, say that pattern is pathognomonic. You really don't even have to go to other causes, although Dr. Russell said she did, because that's what good, thorough doctors do. So it is incorrect that Dr. Russell didn't explicate a methodology. It's incorrect that she didn't explicate that there's a rooting in the medical community and that it's generally accepted. Now let's go to the cases. Mr. Brennan cited to a paint case, etc., but interestingly, and in contrast, in our papers, which Mr. Brennan has had for almost a month, and he didn't respond, interestingly, we cited to the Lobello case, the Brinker case, both of which are dog wound injury cases, not pain cases. I know a little bit about Lobello because I know a little bit about the firm that sponsored the expert in Lobello. It's my firm, my law firm. And the exact argument that Mr. Brennan just made was expressly rejected by the court on a dog bite case, a dog wound case. Here's what the court said. The court finds that Dr. Sirota qualified as an expert on the presentation. This is on Westlaw page 10. The court finds Dr. Sirota qualified as an expert on the presentation, treatment, and medical sequelae of an attack by a dog. Here's the key. As explained in his expert report, Dr. Sirota has personally repaired thousands of wounds and lacerations including wounds and lacerations caused by dog bites. And he's authored a number of peer-reviewed articles in the areas of his certification, et cetera, et cetera, et cetera. And so there is a dog bite case from the Southern District of New York, not an insignificant court, as recent as 2023, saying a doctor that sees and treats all these, that's reliable. And this was a Daubert challenge, Your Honor. This wasn't an incidental question. The challenge was defendant's motion to preclude expert testimony, albeit federal rules of 702, but we know in Massachusetts it's Daubert, Lanigan. You can satisfy Daubert, the federal, but you also Lanigan, and under Davis, you can have generally accepted in the medical community as well. There's one case. Another dog bite case, we cite Brinker, that Mr. Brennan didn't address, is a federal court case in Indiana where same challenge to a doctor about the cause, and it was italicized, the cause of the injury to the person there. And the court basically said in that case that this expert here, and they challenged the causation issue, said that doctors who have experience in treating them, that's enough in and of itself. We don't need to go into, we know Daubert's flexible. You don't have to use all 5 factors. They're called non-exclusive factors for a reason, which is a good segue now to Massachusetts cases. Mr. Brennan's hypothesis is that you can't just have somebody use their years and years of experience. You've got to have something more complicated. We cited the Goodman case, a Massachusetts case, and I'll read the relevant portion. The challenge in that case was to a burn pattern. So it's not a dog bite case. I want to be clear about that, but it's a burn pattern. And here's what the court said. The foundation for Slowick's methodology, that was the expert here, was simplicity itself. Examine the exterior of the facility for external causes, and finding none, examine the interior of the building to locate the origin of the fire by following the burn patterns. And the court put by following the burn patterns in italics, not me. And so the court basically said, here, it's simple. Just look at the patterns. This person has experience with seeing these patterns. Next case we cite, another Massachusetts case, Pasteur. What's the issue there? Not a dog bite case, I've already given you 2, but a firearm examiner in that case. The court said, a judge, and I'm going to quote, a judge may also look to his, let's get it correct, her, for this case, own common sense, as well as the depth and quality of the proffered expert's education, training, experience, read on, to determine reliability. All right? So even in situations where courts have repeatedly said, including dog bite cases, if a doctor has repeatedly looked at, treated, etc., they get to testify with regard to whether they believe a wound is caused by whatever. And in the 2 cases I've given you, dogs. So the law is very clear for what the position is of the defense with regard to methodology. And that's what this hearing's about. That's why we're here. Is her methodology reliable? And there is one methodology. There's a pattern methodology. She testified to it. And the Commonwealth has no competent evidence whatsoever to counter that. It's remarkable to me that we're being faced with the challenge to whether the defense could put up a defense and put up a witness when there's no opposition to her methodology from, as your doctor has, or your honor is required, a medical doctor that is required under law in Massachusetts. I also, Your Honor, want to go to now what the Commonwealth has argued in its papers, which I think further underscores the waywardness of their argument. On page 11 of their papers, The Commonwealth further attempts to criticize, what we said in our papers on page 11, the Commonwealth further attempts to criticize Dr. Russell for being a, quote, trained emergency room physician as opposed to a professional in the field of canine bites or claw marks, veterinary medical science, forensic odontology, or canine behavior. How does that square with your honor's standard that it must be a medical doctor that speaks to the causation of this injury? By definition, a veterinary medical science person is not a medical doctor. A forensic odontologist, most always a dentist, is not a medical doctor. And certainly canine behavior. And why are those words there? Because that describes exactly the expert that the Commonwealth has sat on since the trial, Dr. Cosby. That's him. And in the book that Mr. Brennan attempted to use, Dr. Cosby has written some of those articles, interestingly enough, citing the very articles that Dr. Russell relies upon for the very pattern methodology. So again, the waywardness of the Commonwealth's argument is they're not addressing the need to have a medical doctor. We are not here arguing over whether the dog behaved correctly. We are here to determine, and this is the focus, what is the medical cause of the injuries to the decedent's right arm? And what we have done, perhaps too thoroughly, is we have established the credentials of Dr. Russell, not only with regard to dog bites, but with regard to medical causation, a broader umbrella. And under that umbrella of medical causation is expertise in dog bite wounds, expertise in motor vehicle accidents, but importantly, expertise in wounds caused by motor vehicle accidents. We never presented her as an accident reconstruction because if you need to be a medical doctor to be able to opine on these wounds, I've established through Dr. Russell, and it's unrefuted by the Commonwealth, that Dr. Russell has never heard of someone who's an ER doctor who is an accident reconstructionist. They're two different disciplines. And lastly, on this point, before I move to my next, if an accident reconstructionist is going to come in and try to testify about the nature of wounds, I think I can predict what Your Honor might do. So in terms of why we are here, it's straightforward. Her credentials are enormous. Her experience is enormous. She has been truthful and honest. Your Honor has the notebook for the exhibits for today and can look and see that she did not make inconsistent statements. By way of example, when she said, when it was alleged that she said possibly was in the question, not in her answer. When it was alleged that she didn't answer your question to a medical degree of certainty, we proved that that was wrong with specific language. So on the methodology, this is straightforward. In the law, in the cases I've given you, in Massachusetts as well as dog bite cases, it is completely accepted for a medical doctor to use their many years of experience in treating these types of wounds, and that's exactly what Dr. Russell did in this case. Now, a very important, in my judgment, Your Honor, legal point. The Commonwealth has waived its entire motion, and here's how they did it. I asked Dr. Russell what I refer to in these Daubert hearings as the magic question. I said, do you have an opinion on the cause of the injuries to Mr. O'Keefe's right arm? Yes, I do. What is that opinion? I believe that those wounds were caused by a dog attack. Do you hold that opinion to a reasonable degree of medical certainty? I do. The Commonwealth never objected to that question. To me, that's a waiver of the entire issue. If they thought she was unqualified to answer that question, they should have done what Mr. Lally did in the June 21st trial. Because another part I've got in the notebook for Your Honor to see is she never got the opportunity at the June 21 trial to answer the question of whether she had that opinion to a reasonable degree of medical certainty, because Mr. Lally objected, as is his right, and Your Honor sustained it and sustained it and sustained it. That's yet another reason why it's not inconsistent, because at the June 21 trial, she never got to answer that question because of the Commonwealth. But back to the waiver. The Commonwealth should have, at that moment in the hearing, objected, but they didn't, and they have waived that objection for this motion. Lastly, I want to just cover a couple more items that Mr. Brennan had quickly. He kept saying, can't be, equally basis, evidence wholly contradicted. Where's the medical profession to support that? Those are Mr. Brennan's opinions. And respectfully, Your Honor, I don't believe that's even for the court in this hearing to decide. That's for the jury to decide. As almost all of these cases go to, the Labello case that I cited, those arguments go to the weight of the testimony. They go to cross-examination. As Your Honor well knows, you're the gatekeeper to see whether Dr. Russell gets to go to the jury, whether you're going to keep that gate open that I believe you very carefully and judiciously decided on June 18th. And I respectfully submit that gate should be much wider open now, given what Your Honor has heard and the basis for it. But even if Your Honor might be inclined to be interested with, maybe even persuaded by some of the things Mr. Brennan said, those have nothing to do to whether there's a methodology or whether it's reliable. Those are easily answered by Munich and Pollack. And that's the end of the inquiry. Everything else is beside the point. With regard to the DNA that the Commonwealth has tried to make so much about, there was only one reason that was brought up. It was brought up because Dr. Russell answered she didn't need to know much about the DNA. Why? Because the pattern of the wounds are so highly characteristic of a dog bite and dog attack, and because the authors used the word pathognomonic. But because she was careful, she went through a differential diagnosis, but she was consistently honest and forthright. When she didn't know something, she said so. So in terms of this particular matter, and I'll conclude my points at this point and keep to below the 20-minute mark.
30 minutes.
I'm sorry, 30-minute mark. The tremendous importance of a defendant's right, especially in charges of this seriousness, to present a defense, to present a counter argument to the whole theory of the prosecutor's case. Their theory is that a motor vehicle hit the decedent and caused these injuries to the right forearm. The presumption should be the defendant gets the right to present evidence. Now, they don't have an absolute right. You got to satisfy Daubert, but I believe the satisfaction on the crucial inquiry of qualifications and then the methodology and reliability is overwhelming. So, Your Honor, I would urge that Your Honor find that Dr. Russell is qualified. She's qualified as a medical causation witness, which has her able to not only testify at trial with regard to whether those wounds are caused by a dog attack, but also she can testify, and she's qualified to do so, that it's not from a motor vehicle accident. And she's also allowed to testify with regard to her forensic pathology hat, because contrary to the impression of the first in June, she's been doing forensic pathology as recently as her time at Corcoran. And my last point, Your Honor, is this, and it blends in with the point I made earlier about the jury. Shouldn't a jury be able to hear the alternative theory of the defense? Shouldn't the jury have that information so that justice can be served, so that the best decision can be made about whose theory about these injuries is right? We've satisfied beyond my view, respectfully, any reasonable doubt about her qualifications and methodology. Let's let everything else go to the jury and decide, so Ms. Reed can have her fair day in court.
Okay. Thank you. We have some scheduling things that we should take care of. There's another motion from the Commonwealth on another Daubert hearing regarding the digital evidence expert.
There is, and also, I don't know if it's docketed, but I filed a notice to the court regarding my concerns about ARCA witnesses, and the reason I filed that prior to filing an actual motion is because I appreciate the trial court date. I do not want the defense to be unaware of my intention.
All right. So let's set a date for a Daubert hearing. Any idea how long you expect it will take regarding the digital evidence expert?
Well, Your Honor, when you say that a Daubert hearing, you don't mean an evidentiary hearing, you mean a hearing on whether or not an evidentiary hearing is required.
So we can do that tomorrow, or we can
Well, I can't
set
do
it,
it tomorrow.
or, well, then we'll stay now and do that. Are you ready to do that, Mr.
No,
Jackson?
we just
Then-
got this on January 31st.
Okay,
We've not had an opportunity to respond to
just
it.
December 31st, probably.
What did I say?
January.
New Year's Eve. We've not had an opportunity to respond to it. We
Okay.
expect to have an opportunity to respond to it.
How long will it take you to respond to it?
Probably a couple of weeks.
All right, so what I want to do, because I want to set some dates, and if we're not going to have a hearing, we'll cancel it. It's easier than getting the motion, deciding that there'll be a hearing, and setting a date, because we're sticking with that April 1st trial date.
I understand that, but the problem with setting a date for a hearing and an evidentiary hearing requires us to bring someone in from out of state.
You know, so what I'm saying is, file your paperwork,
Okay,
all right? We'll set a date for a hearing.
okay.
We'll set an evidentiary hearing date. I just want to lock those in. I'm trying to do them
Okay,
on
well,
Mondays or
that's fine.
Fridays for you,
Misunderstood.
thinking that it would be better for your schedule if we tried to accommodate that. But we've got a full session, so.
Mr. Brennan and I talked briefly, I don't want to speak for him, but we talked briefly about the January 27th date. I think all council have that date cleared because it was a trial date at one point in
Right.
our history. So what about the 27th for the motion on Mr. Brennan's Daubert request?
On all witnesses, not just, you said you're filing,
The only one he's got is for Rick Green.
what did you file a notice of, you said today?
Notice that I expect that I will likely move to exclude the ARCA witness respect to failure to comply with Rule 14. It's not a Daubert hearing.
Okay,
It's compliance with Rule 14.
okay, so that's different.
Yes. I am waiting for a response from the United States Attorney's Office that I'm supposed to expect next week.
Okay,
If that changes my position, I'll notify the defense in the court. If it doesn't, then I'm going to pursue that motion.
okay.
Karen, may you speak briefly at time about
Sure.
scheduling?
All right, y'all. I finished up my last call of the day. What did I miss today? Did she make a ruling on the expert? Yeah, I'm gonna have to go back and watch it anyway. They are calling out in the chat how they do not like the fact that the family is sitting there. And that the seating arrangement is weird. I agree with that. D says that it is intentional. Okay, they're talking about scheduling. So we're having a sidebar. Hey, chat. I don't know if you're still in here or not, girl. All right, let's see. Hey, girl. This they put you to sleep. Cindy, the defense made a strong argument on why Dr. Russell should remain a qualified expert. I think he did too. I did hear bits and pieces of it where he was talking about really just reiterating what she said and talking about her reading line for line. I mean, I think that I'm not gonna hold y'all. I think that the prosecutor, the guy, I think he is a good prosecutor, y'all. I think he kind of good at his job. I mean, an argument is an argument. The law is the law. Crazy that Jackson has to fly in and out of town. Oh, he is the special prosecutor, Hershey.
Clear. The 31st will be oral argument at 9 a.m. And if there's an evidentiary hearing, it will be conducted on February 6th. We'll block off the day. And February 7th, and we'll also hear the ARCA motion if there's something on that. So we'll go for the 6th, but we'll leave time if it carries over so we don't have what happened with Dr. Russell, such a big gap in between. Okay? All right, we'll see everybody then. Thank you.
Thank you.
Oh, Jackson is Karen's attorney. All right, y'all. Y'all know we had a snow day today still, but I brought it to y'all. We done watched a whole lot of stuff. Tomorrow we will finish up on our recusal stuff. I'm actually gonna plan this out because again, like I told y'all, we got DA Jackie Johnson trial of jury selection coming up here pretty soon, and I feel like it would be beneficial for us to watch the trials of the guys who were convicted of unaliving Ahmaud. So I think we're going to switch over to that. I believe we've got some YSL stuff to do this week as well. One thing that is coming soon, y'all, is that I am getting ready to create a Taylor Unbridge calendar. So every week I will post a calendar of what we are going to watch each day so that you can just come out and see, like, do you want to stream? Do you want to be a part of it? Do you want to be in the comments? So I am working on that. I'm hoping that I can start it next week. But I will post the calendar. So it'll be on my TikTok. It'll be on X. And I'm going to figure out a way to put it on YouTube. I don't know how, if I have to do a short or something. But I'm going to figure out a way to put it on YouTube. That way we have a Monday through Friday calendar with start and stop times, just in case I've got some things I need to take care of, so that everybody is in the know. All right. I want to thank y'all. Thank you, Chad. Thank you, Cindy. I want to thank all of you all for choosing to stream with me today. I know we get the bulk of our viewers from over on Twitter. So there's 122 people watching from Twitter right now and 30 people watching from YouTube, totaling 152. So thank you to everybody that supports the Taylor Umbridge channel. I appreciate you, and I hope that you all have a safe and good evening, and I will see y'all later. Bye. Oh, it's a community post on YouTube, Jason? Okay, I'll do that. All right, I got you. All right, but good night, y'all.